So, good morning, everyone, and welcome to the championship round of the 28th annual Virgin Islands High School Moot Court competition. We have 13 squads competing today, and to begin with, I want to welcome Alicia Udwani, the president of the Virgin Islands Bar Association. As we said yesterday, the Virgin Islands Bar Association is the organization that sponsors this. We do encourage people to go to usbi.org/donations and to donate annually to support this competition. We give $7,500 out in scholarships to the youth of the Virgin Islands every year, and it would always be financial support from members of the Bar Association, and the public in general is welcome. There are enough members of the Bar Association that if each person donated $10 annually, we would fund all of the scholarships and most of the cost of the program. With that, I would turn it over to Attorney Udwani to give everyone a welcome.
Hi, good morning, everyone. I want to thank you all for being here today and thank you all for volunteering your time. I know time is precious, but I thank you guys for being here to support our youth. Welcome to the 28th annual Moot Court competition. The Virgin Islands Bar Association loves this time of year because we get to see our young high schoolers being and doing so well and being so impressive. So it's definitely a great time of year. I want to start by thanking the judges, those that judged the last competition on Tuesday, as well as those sitting in as judges today. I know the packet of information was large. I think it was around like 200 pages, so a lot of items and materials to review. And so I thank you for taking the time and diligence to do that, so that you're prepared to do that, to come here today and help the competition thrive. I also want to take the time to thank St. Mary's Law School, who helped not only coach a lot of these students, but they also provided some technical support. And as I heard Adam mentioned earlier, this is the largest group of students and competitors we have to date, and so St. Mary's Law School's assistance was definitely very helpful and much appreciated. And we are excited to continue to partner with St. Mary's Law School, which to our high schoolers, if you didn't know already, St. Mary's Law School is the first law school that is fully accredited remotely. So you can be, after college, you can come back home to the Virgin Islands. You could be at home studying to get your JD if you plan to go on to become an attorney in the future, which I hope everyone at least considers that after this practice. I also want to take the time to thank our coaches. I was a coach 1 year, and it is a lot of hard work, a lot of time, and a lot of dedication. And of course, in our profession as attorneys, we don't have a lot of time. So to be able to dedicate that to our youth and encourage these students to do their best, we really very much appreciate your time. I also would like to thank Adam and Rob. Every single year, they dedicate their heart and soul to this competition, and they do an amazing job. Since the pandemic, we've held this competition virtually, and I think the transition, because of Adam and Rob's leadership, the transition was smooth, and it's been really great. Also, I'd like to take this time to talk to our students directly. I sat in on a lot of the competition on Tuesday, and oh my God, I am so impressed. I couldn't see each and every one of you because I did have some meetings and I did have to work. But what I did see, I was extremely impressed. Everybody gave such articulate and intelligent arguments and responses to the judges' questions. I was just taken aback. It was so amazing, and I know it ran a little long. I was listening to everyone's everyone's arguments, even on my cell phone on the drive home, just because it was so good. I was so impressed with each and every one of you. When Adam and Rob first sent me this the packet of material and this question, these issues that you guys would be responding to, I was honestly taken aback because I thought it was going to be so difficult. I really thought about it long and hard, but you proved me wrong. You guys took the material, inhaled it, completely understood it, and were able to create these creative and beautiful arguments. And I thank you for that. And I know at the last competition, you heard the other speakers tell you about how useful this competition is, the skills that you gain in this competition, even if you don't become an attorney. And while that is absolutely true, I don't want to repeat their comments, but I just want to emphasize that is absolutely true. The best thing you can do is to learn how to gather information and articulate your position and your arguments, whether it be whether you're a doctor, a nurse, whether you're an engineer, whether you're a librarian. It's a useful tool in everyday practice, and you're gaining that by taking on this endeavor. So whether you're here to compete today as well, or whether you just competed on Tuesday, thank you so much for your hard work, for your dedication. These are skills that you'll be taking with you in the future, that you'll be using in your endeavor, in whatever you choose to do. Now, when I was asked to come here and speak today, I did think about what it is I would have wanted to hear from a professional when I was in law school. When I was in law school, I remember, I would look up to these attorneys that were parents of students in my school, and none of them would look anything like me. None of them would look like the judges we have here today. And so I would like you to take a moment and believe that anything you choose to do is possible. All it takes is time, work, and dedication. You may encounter, and I hope you don't, but you may encounter a lot of naysayers. When your light is bright, the light is bright always attracts the most flies, right? So whatever anyone tells you you cannot do, if you know in your heart that this is your passion, go for it. Whatever it be, whether it be to advocate for someone else, whether as a lawyer or as a doctor or anything that you want to do, business owner, anything that you want to do, do not let anybody tell you otherwise. If I had $1 for every person who told me I wasn't going to be here where I am today, speaking to all of you, I probably would have a big dent in my student loans, let me just tell you that. So believe in yourself, know that you have what it takes to fulfill your dreams. It will be hard and it will take a lot of work, but at the end of the day, you need to understand that you need to just keep at it and be proud of who you are and be strong internally in order to get to where you want to be. So with that, I want to thank each and every one of you for being here today, judges, coaches, students. It's been a long couple of months, I know, and we're very proud of each and every one of you. You've been doing an amazing job, and thank you, and best of luck to those competing today.
Thanks, Alicia. That's a wonderful message for the students. Much appreciated. And now we come to our annual highlight of my favorite portion. Judge Wilma Lewis from the District Court of the Virgin Islands, our most adamant and vocal supporter of the program in the entire territory. And she never misses the opportunity to participate, whether it's to give a welcome address at the championship or to endure the torture of sitting for a full day as a moot justice. We can rely on her to be here every year. Judge Lewis, the floor is yours.
Thank you, Adam. You are most kind, and it is never a torture, believe you me. It's my great pleasure to welcome you all to the second day of the 2022 Moot Court competition. I am always so very pleased that over the years, the co-chairs of this event, now Adam Thorpe and Rob Kaczynski, before them, Judge Ernest Morris, they've always extended the courtesy of allowing the District Court of the Virgin Islands to contribute in some way or another to this event. And I'm always so very pleased to have the opportunity to participate. So I thank them, all of the co-chairs, and of course, with no exception today, Adam and Rob, for their kind invitations to be here and to be able to participate in yet another moot court competition. As Adam probably forecasted for me, yes, this is one of my favorite events. I love the moot court competition, and I'm always so happy to give it kudos, commendations, and support. And I like it because it gives our students the opportunity to participate and to expand their horizons, their educational horizons, and in so doing, to get a taste of a slice of the legal profession. I also like it because it gives all the rest of us, all of us who are so proud to call the Virgin Islands home, it gives us the opportunity to witness and also to showcase the talent, the incredible talent that is here among our youth in the Virgin Islands. We already heard from Attorney Udwani, who talked about the presentations yesterday and how wonderful they were, how impressive the students were, and they always show up for this event. They always showcase that great talent and great potential that they have. So that's why this event is always so very exciting for me, and I enjoy so much being a part of it. Now, for the students, as you know, today is the championship round of this event, and at the end of the day, the winners will be announced. So let me say to the students, all of you who are participating, that while winners will be announced, prizes will be awarded, including monetary prizes, and those go to the individuals who have received the highest scores from the judges who will be scoring the presentations. While all of that is going to happen, and that is true, it is important for all of you to keep one thing in mind, and that is that you are all winners. You are all champions. Your sheer participation in this event makes you a winner, makes you a champion, puts you in that first class category. Why is this? You put a lot of time and effort into this event. You've done research. You've prepared your oral arguments. You will soon be doing more presentations of those arguments and responding to the questions of the judges. You have interacted with your lawyer coaches, with your fellow students, and you will be interacting in a competitive way with those from other schools. You have embraced the challenge of this entire experience. And all of those things have made you winners because you have added significantly to your bank of knowledge. You have fostered your self-development, and you have built in untold ways on the tremendous potential that we all know that you have and with which each of you is blessed. So before you even utter your first word today, I'm going to offer you my hearty congratulations. Congratulations for taking advantage of this wonderful educational opportunity, and congratulations in advance for what I know is a job well done. A job well done that you have already achieved by all of your preparation for this event. And I hope that each of you will leave here today with your heads held high. Humble, but nonetheless proud of what you have achieved, what you have accomplished, both individually and collectively. So congratulations. Congratulations to each and every one of you. In closing, I'd like to commend the Virgin Islands Bar Association for planning and hosting this event year after year, and for doing so in such exemplary fashion. You have heard of the accolades already given to Rob Kaczynski and Adam Thorpe, and I know the time and dedication that they have put into it over these many years. So, led by those two esteemed co-chairs, together with the Moot Court Planning Committee, they should be commended for their tireless efforts in putting together such a great program. And of course, all the teachers and the parents, the coaches, the judges, and others who have supported this event, they too are to be commended for encouraging the students and giving them that extra opportunity to enhance their skills even more. As we've heard, this is the largest group of participants that have ever been a part of this event. And so each year it's getting bigger and better, and that's what we will continue to expect. St. Mary's Law School, as we've heard, has made quite a contribution, and we thank them for their participation in this event as well, and commend them for working with our young people here in the Virgin Islands. This is the 28th year of the Moot Court competition. It's certainly my hope that the path that has been tread over these many years by the hosting of this event will inspire the continuation of this annual competition for many, many, many years to come. So on behalf of all of us here at the District Court of the Virgin Islands, you have our very best wishes for the successful conclusion of the 2022 Moot Court competition. Thank you all very much, and have a great day.
Thank you, Judge Lewis. It's funny, you call it a courtesy that we extend you. We look at it as the privilege that you extend us to have you participate every year. We always are thrilled that you are coming back every year.
Well, I will be here as long as I have an invitation. You know, I'll always say yes. So thank you, Adam. Thank you for all that you and Rob have done.
Thank you very much. All right, with that, we turn to our panel of judges. Our first judge today is Judge Jomo Mead, a judge of the Superior Court of the Virgin Islands. He is a graduate of St. Croix Central High School and received his Bachelor of Science from what was then the College of the Virgin Islands. He graduated Thurgood Marshall Law School in 1988 and practiced law in the Virgin Islands until his appointment to the Superior Court in 2016. With that, Judge Mead, do you have anything you'd like to say at the outset of the competition?
Good morning. I'd like to welcome each and every one of you, particularly the students. I fully endorse what Judge Lewis and President Duwani have said. In the past, I've been a coach in this competition. I've coached St. Joseph's, I've coached St. Croix Central High, and I find the students' arguments are most intellectually stimulating and academically challenging. As a matter of fact, the arguments are oftentimes better than the attorneys who appear before me in court. So I'm looking forward to this competition, and I am so honored to have been selected as a judge of the competition. Good luck to each and every one of you, and you're all winners. Thank you.
Thank you, Judge Mead. Such wonderful, inspiration for the students. Next judge, and we're very excited. We have a return from the Third Circuit Court of Appeals for the United States this year. Our second year having a judge from this court. Judge Roth was appointed to the United States District Court for the District of Delaware in 1985. In 1991, Judge Roth was elevated to the United States Court of Appeals for the Third Circuit, which oversees Pennsylvania, Delaware, and the Virgin Islands. And in 2006, she took senior status and has served as a senior judge on the Third Circuit since then. And we are just have the absolute pleasure and privilege of having Judge Roth here today. Judge Roth, do you have anything you'd like to share with the students?
Yeah, I'm delighted to be here, and I reiterate the sentiments that have been expressed about how valuable this is for the students. But the one thing I heard that hit me particularly was when Ms. Uglani talked about becoming something that you were told you could not become. Because when I was 10 years old, my father was a lawyer in Delaware, and he came home one night and for dinner and said, "The most amazing thing happened today. This woman came in and applied for a job with our law firm." He said, "Women shouldn't be lawyers." I didn't talk back to my father, but I sat there and I thought, what do you mean women shouldn't be lawyers? And I kept that in the back of my mind. And when I finished college, I went and worked for the Foreign Service for a while. And I thought about, what do you really want to do? And I thought, I want to be a lawyer. My father said I couldn't be a lawyer, but I'm going to show him I can be a lawyer. And I have never regretted sticking by my decision to become a lawyer. And when I graduated with honors from law school, my father hired me at the family firm. So I made him eat his words. So to all of you students out there, don't be discouraged by what you may hear. It's you who know what you can do. It's not your father or someone else who's going to tell you that you can't do what you really want to do. And I'm delighted to be here today. Thank you.
Oh, what a wonderful message to drop. Several years ago, Justice O'Connor came down to speak, and a lot of people know the story how she graduated in the same class of law school as Chief Justice Rehnquist, and I think she even finished one slot ahead of him. She was second and he was third. And her first job she applied to at a law firm, they said, if you can pass this typing exam and type 40 words a minute or more, we'll give you a job as a receptionist. She kindly declined, went home to live with her parents, and she said, I remembered that there was this prosecutor who had a female attorney in his office. And so I went to him and asked if he needed an attorney who would volunteer to take cases and take the work home. And that's how she got her first job. And her response was, sometimes if you want to be what you want to be, you have to do the hard work and go through the hard situations. And she didn't let that deter her, and she became the first woman appointed to the United States Supreme Court. Yeah, we get three different examples of how that carries through, and I really hope that this program provides that opportunity to students. And with that, I am actually delaying the program further than I should, and we should turn to our Moot Chief Justice, the Honorable Deborah S. Watlington. She is an alumni of Ivana Eudora Kent High School here on St. Thomas and received her law school from my alma mater, Howard University School of Law in D.C. She served as the Territorial Public Defender of the Virgin Islands prior to her appointment to the court. She would have been, on Tuesday, you heard from Matt Campbell, the federal defender. He's her federal counterpart for what Judge Watlington used to do in the territory. And in 2012, she was appointed the family court judge on St. Thomas. So, Moot Justice Watlington, do you have anything you'd like to say to the students?
Good morning. Good morning. Thank you for inviting me to participate in this auspicious event. I'm also a great admirer of the Moot Court competition. I too served as a coach when I practiced, and several of my children participated in the Moot Court competition. And I've had the honor of serving as a judge in the competition once before. And it's always a delight to witness the work that the children put into this event, and the students put into this event. It is remarkable, their presentations, their responses, their poise, and their confidence. And I think this is such a worthwhile event. In the past, I know that the Superior Court once this event And I'm happy to know that the Sultan's Bar Association has also yes, I'm happy to know that the Virgin Islands Bar Association has taken up the mantle and ran with this program. It is worth continuing for time indefinitely. And so I just congratulate all the students who have participated. I know it's a lot of hard work, but my mother used to say hard work never killed anybody. And I guarantee you, if you continue to work hard for what you believe in life, you will reap much dividends. And all of you, as has been said before, are winners. Just the fact that you're here, that you put the time in, that you prepared. So just relax today and give us your best, and let's make this an enjoyable event as it has already been. So congratulations to all and good luck.
Thank you so much, Justice Watlington. Thus far, I have ignored my co-chair, and I do want to give him a chance to say anything if he would like, since he is equally responsible for this program and its success.
Thank you, Adam. I do not have anything to add. I'm just excited about hearing the arguments. I think this is probably, it's always exciting to see, you know, the arguments and how everything gets flushed out. And I just reiterate what's already been said. So have fun and enjoy the day. You know, don't lose sight of that. You know, you could probably feel, I guess, disappointed at the end if you don't get the result, but, you know, don't lose sight of what you've already done, and hopefully today's enjoyable. So have fun.
Yes, sorry, coordination going on here. Thanks, Rob. I want to first just reiterate that the scholarships that people are competing for individually, the best oralist of the competition will receive a scholarship of $1,250. The first runner-up will receive $925. The second runner-up will receive $750. The third runner-up will receive $250. And the fourth and fifth runners-up will each receive $100. To the first place team will go $1,500 to be split equally among the members of the team. Some teams had 2 people, so you get half each. Some teams had 3, you split it in thirds. Second place team will receive $1,050. The third place team will receive $900. And the fourth place team will receive $675. The students are given 7 minutes each for their arguments. The time is stopped when the judges are asking a question, and the time commences immediately when the judge stops speaking. The students will be given a warning of 5 minutes, 3 minutes, 1 minute, 30 seconds, and time. They are evaluated on 5 categories. They are clarity of presentation, command of the factual and legal issues, prepared arguments, responses to question, and demeanor. With that, I would like to introduce our timekeeper for this morning, Stephanie Zabel. She is a former law clerk to Chief Justice Hodge, and she likes the program so much she still volunteers despite not being a member of the bar and living in Washington, D.C. Stephanie, if you could say hi so you will pop up and everyone can pin you in place. Speak.
Hi.
All right. So if you could pin her in place, she will be the one you're looking at for your time. With that, if we could get St. Croix Educational Complex up while I move the remainder of the schools to the waiting room. Oh, some of you, no, that's all right. Sorry, I'm just trying to figure out who's who in some of these. St. St. Croix Educational Complex, while I'm doing this, we can have you put your notices of appearance in for the justices. So the first person, could you get ready and say your name, say and spell your school, the party you represent, and the issue that you are representing.
Good afternoon, Your Honors. Good morning, Your Honors. My name is Alani, A-L-A, N as in Nancy, I, Arnold, A-R, N as in Nancy, O-L-D. I attend the St. Croix Educational Complex High School, and I am on the appellate team. The issue I will be addressing today is that the Supreme Court erred when it held that the high school, its principal, and vice principal violated Ms. Flick's First Amendment rights. Good morning. My name is Nancy Parija. That's spelled Nancy, N as in nice, A, N as in nice, C, Y, Parija, P as in park, A, R, R, I, L, L, A. I'm with the St. Croix Educational Complex High School, and I am representing the appellant team. My argument addresses whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability. Your Honors, may it please the court. Your Honors, the judgment of the Moot Superior Court should be reversed because a school should be an institution of learning, not a courtyard through which adolescent demonstrators strut, virtual or in person, challenging institutional authority. Ms. Flick, along with her cohorts, clearly intended to disrupt the learning of the day, thereby violating a universally established school culture, and she received the punishment she deserved. St. Croix North High School did not violate Ms. Flick's First Amendment rights in expelling her from the institution because Ms. Flick planned the protest intentionally to interfere with the work of the school, infringe on the rights of other students, and encourage students to break the uniform policy.
But by appearing by Zoom, she was not in the school, and how can you say she disrupted the school if she was not actually there?
Your Honor, within the fact pattern, it states that due to COVID-19, the school has transferred from its physical campus, physical school grounds, to virtual school. Virtual school is the campus of the school. Students are logging in, lessons are being conducted, teachers are teaching, grades matter. And also similar to the courtroom, the court proceedings today, due to COVID-19, virtual court proceedings occur virtually, and attorneys present their cases, they dress up as attorneys as they would on physical campus, and judges give their verdicts. First,
how would you determine that she received the punishment she deserved if in fact, as you say, the school campus was virtual and the very issue she was complaining about was the difficulty she was having with virtual learning?
Your Honors, in the fact pattern, it states that Ms. Flick intended to have 200 students break the uniform policy. And when there was a possibility that admins of the school might have found out of her plan, she went directly to Kmart and bought 50 white shirts where she wrote "Forget UTEA" on. So
did she in fact have 200 students engage in the silent protest?
No, Your Honor, she had the 50 students across the school, across various classes in the school, including hers, and more. With
why
that,
do you think that the punishment of expulsion was appropriate?
Yes, Your Honor, Principal Rooney imposed disciplinary actions with with expulsion because it was necessary. She had such a great influence over the school, and she interfered with the work of the school and interfered with students learning for those 2 days. With several minimized cameras of Forget UTEA across the class Zoom call for the 2 days, there was one Mr. Keating versus numerous Miss Flicks in that class, able to have the students actually pay attention to his lesson for those 2 days. For example, in the Des Moines versus Tinker case, located in Primary Authorities Part 1 on page 30, it states that in order for a school to be justified in their disciplinary actions against a student, the student's actions must either interfere with the work of the school or impinge on the rights of other students. Within the Des Moines case, the school failed to yield evidence that they had reason to anticipate that the armband worn would be a distraction to those in school. Secondly, it also states on page 36 that the school is an appropriate place to exercise symbolic speech. However, this is only permitted if school functions are not unreasonably disturbed. Within the fact pattern, it says that no more than 25% of Mr. Keating's class was completed. Please note for each class session, there's a total of 90 minutes, and Ms. Flick's protest prolonged for the 2 consecutive school days within that class, which then totals to 3 human hours multiplied by the number of students in that class. Also,
Attorney Arnold, the case that you cited, Tinker, did not the Supreme Court rule that a student has the First Amendment right to engage in silent protest if the student believes that something has been wronged or something was wrong?
yes, Your Honor, that's exactly the point.
But wearing the T-shirt is not silent protest. Were any words verbalized so as to disrupt the educational process?
No, Your Honor, in the Des Moines case, the armbands worn was peaceful. It had a meaning behind of it, which was the students' objections and objections towards the war in Vietnam. Ms. Flick's own was loud. Her T-shirt was loud. The letters, the fonts, the colors, the vibrant colors of her shirt was just loud and distracting for the 2 days in class.
Okay.
Therefore, Ms. Flick's actions infringe on the rights of her classmates to be an environment that is conducive for learning.
But how can you say that? How can you say that? Didn't the other students participate in the silent protest? Did they wear T-shirts also?
Yes, Your Honor. There was numerous students who actually participated in this protest as well. So there's several students wearing that Forget UTEA, so that T-shirt. So that was distracting to the day in comparison to the Des Moines case with the black armband.
The other students wearing the T-shirt was disruptive to whom, did you say?
The T-shirts worn by Ms. Flick and her cohorts were distracting to the lesson plan for that day too, and also to the audience in Mr. Keating's class, as well as other classes in the school.
Well, how do you justify that Ms. Flex was the only one punished for wearing the T-shirts when other students also participated in the silent protest?
Ms. Flick organized this whole protest. She influenced others to join her with this protest as well. So she should be held liable, and she should be held liable for organizing this protest, and she should be disciplined. This leads me to the fact that there's a time and place for everything. Why did Ms. Flick feel that the school was the most effective place to carry this protest out?
Wasn't she exercising this protest or performing this protest in a government class? Wasn't this an appropriate class to do this kind of protest?
Yes, Your Honor, but we have to remember who is actually in charge of the AP Government and Civic class. And in this situation, Mr. Keating is in charge and not Miss Tracy Flick. Why did this protest occur during school hours, in class, and on the school-issued computer? On average, students spend 1,080 instructional hours in school per year, which only accounts to 12.5% of the year. She could have used the remaining 87.5% of her own time to carry this protest out instead of wasting school time.
But didn't she, when she protested, didn't she use good language? She didn't use fighting words. She didn't use obscene words. Isn't her choice of language a factor in her favor?
Well, Your Honor, Ms. Flick knew what she was doing. On the T-shirt, it has capitalized F and the remaining of the word forget, and the same thing, you, for they capitalize you. So Ms. Flick knew what she was doing. Her audience was her classmates in her AP Government and Civics class. I'm
supposed to infer something from FU?
Yes, Your Honor. Her audience was her peers. Her audience was among her age, 9, 10, 11, and 12 graders. She knew that they would have understood what she said. It was a double meaning behind of the protest, behind of her shirt. The cause of the protest is the territorial power outages being a nuisance to her virtual learning. However, she later proceeds to disrupt the class for others. The irony and hypocrisy of her actions is alarming.
How would you suggest that she could have protested in another meaningful way?
Ms. Fleck could have gone outside of school hours on TEA's doorstep, being the root of the issue. When there's an issue in class concerning two students, you either go to the student who is the issue or go to someone who can resolve that issue, which is the teacher. Your Honors, may I finish? You
can conclude. You may conclude your response and your argument.
Well, Your Honor, in this situation, TEA is the root of the problem, and TEA is the only person who can resolve this issue. So if she went directly to TEA, who could have handled the situation better, she would have gotten a better outcome. Your Honors, since the infraction of Ms. Flick's actions both infringe on the rights of others and as well interfered with the work of the school for 2 whole days, we respectfully request that this honorable court reverses the lower court's decision by finding that St. Croix North High School, its principal and vice principal, did not violate Ms. Flick's First Amendment rights. Thank you.
Thank you.
Thank you very much. Judges, when you are finished filling out your score sheet, just give me a signal letting me know you're complete. And while we're waiting for that, Ms. Parija, you are next and you can get prepared.
I'm finished with my...
All right, there's one.
I'm finished.
2, finished. 3. All right, Ms. Parija, when you begin speaking, the time will commence. Oh, sorry, is there technical issues? All right. The floor is yours.
Your Honors, or judges, can everyone hear me?
Yes.
Yes.
You may proceed. You may proceed.
Okay. Good morning, Justices. May it please the court?
Please proceed.
Your Honors, the judgment of the Moot Superior Court should be reversed simply because of our Virgin Islands morals and legacy. As we pride ourselves in raising the next generation with the necessary skills of responsibility and accountability. As the saying goes, with great power comes great responsibility. Ms. Flick was powerful and mature enough to organize tens of students to protest a quasi-government agency and demand efficient services. Thus, she should have been named responsible enough to hold up her end of the bargain with Tommy Z. Her efforts to avoid being taken advantage of by the TEA seem inauthentic, seeing that she, in the same efforts, now wishes to take advantage of a local businessman, allowing an uprising adult and fully functional activist to disaffirm liability simply because her birthday was a few days later in the week does not stand with our Virgin Islands morals and should not be used as an excuse to crutch the future citizens and members of our community.
Attorney
Parisia, I know you have argued that Ms. Flick had demonstrated some maturity, but isn't it the jurisdictional province of the legislature to determine the age of majority?
Yes, Your Honor. As they have determined the age of majority, it's also important to note that the legislature has chosen that in specific instances to allow those under 18 to be liable and because of their circumstances, allow the court to decide. Given that Tracy Flick has...
What factors should the court... Are you referring to Title 16 Virgin Islands Code, Section 261, which in which the legislature indicates that the age of majority is 18 years old?
Yes, Your Honor. But also,
so you're saying the other factors the court should take into consideration in determining whether or not someone who is below 18 should be treated as an adult. Am I correct?
Your Honor, because of although there is the age of 18 limit, I'm saying that the legislature has taken into account that there are certain circumstances that are put in place in different situations. That in this case...
And what are some of those circumstances?
Well, given that Tracy Flick has various responsible factors and character traits to understand the circumstances she was placed under when interacting in the agreement, she should be made liable under 18 in this specific instance, and therefore the court should decide.
But does the law provide any exceptions?
Repeat, Your Honor?
Does the law provide any exceptions to persons under 18 having the ability to enter into contracts?
Yes, Your Honor, but they are not specifically stated as we don't have a general law abiding to contractual maturity.
So if there's none, as there are exceptions stated in other areas of the Virgin Islands code with respect to juveniles who commit certain criminal acts. And so the legislature has specifically provided for certain exceptions. If the legislature has not provided for an exception in the case of contracts, is the court authorized to make those amendments?
Yes, Your Honor, because the legislature has given the court the ability to decide, especially when the person in question is under 18 and should, in fact, based on the circumstances, be made liable. And
Isn't it better if we have a bright line rule that we don't have to worry about this exception and that exception? We just know that if she's 18, good. If she's not 18, she cannot contract.
Well, Your Honor, given that the law is subjective, and especially understanding that the transition from 17 to 18 does not change the mental capacity of Tracy Flick or any 17-year-old in her similar position, we have to apply certain circumstances and look at the situation in place to make the justified decision. And so we look at the maturity of the person. Tracy Flick in herself was a member of Moot Court, president of student council, in which she displayed different responsible acts that showed she understood the terms of a contract and the bargain that she was being placed under. In addition, 16-year-olds have shown their adultism and the ability to operate an automobile and physically operate 5,000-pound death machines, while they would be fined as an adult if the situation persists in an accident. And now, Tracy Flick is able to own a job, own a debit card where she has a financial base left for her. And this is very different from the picture that some opposing counsels place of a young child who does not have any way to support themselves or any sort of financial advantage. It is also given in the Kiefer versus Motors Inc. case that if the person in question who is not of the adult district mature age given should be bound to a contract made if they are mature enough. Now, Kiefer was drafted for military service, given the ability to bear arms, and mature enough to handle a child. And so they found that he was also mature enough to make binding contracts in the marketplace because even though he was under the majority age. And it is stated.
Attorney Perella, does Tommy Z have any responsibility in this matter to determine whether the person he's contracting with has the maturity or is of age?
I'm sorry, Your Honor, you froze on my end. Can you repeat that?
Okay. Does Tommy Z have any responsibility for determining whether the person is contracting with is of the age of majority?
Well, Your Honor, it is not customary for a business owner to ask for an ID, nor are any business owners obligated to check for a given ID, seeing that an ID does not serve a public purpose, especially in fact or public policy. Now, it is not clear how Ms. Flick contacted Tommy Z, given that if it was in text or through verbal agreement, a confirmation for the order would have been clearly stated and given, but she should have been made responsible for the disaffirmance of the order, and at her coming of age, using her discretion, the contract was not disaffirmed.
The harm done to Tommy Z. He has these shirts he can't sell now.
Yes, Your Honor, exactly. And given this, Tracy Flick should be put responsible for the liability in the contract that she made. In this case, like I said, we have a person who has assumed numerous responsibilities, including taking into account that she has planned a ceremony for a friend and numerous in-school activities where supplies and items were needed. And she in turn had the accountability to hold up these ends. In this similar case, she should have the same accountability.
So, Attorney Perija, the court is trying to understand what you're saying. You're saying even though Ms. Flick had not attained the age of majority as contained Title 16 Virgin Islands Code 261, that the court should look at other factors or extracurricular activities to determine whether or not she is mature enough to be held liable for the contract that she entered into.
Well, Your Honor, not only her extracurricular activities, but the fact that, one, she was a week away, and when the t-shirts were made and the contract was actually bound, she was of the majority age. When she would have made 18, her mental capacity and her financial literacy would not have changed any different from where she is now. And especially taking into account the different roles in society and in the community that she plays, she understood her requirements.
Well, doesn't the fact that she disaffirmed the contract within days of turning 18 make a difference?
No, Your Honor, she did not disaffirm the contract ever within that time period, even after she reached the majority age. And well, Your Honor, we can take into account a student in a similar case. We can take Nancy Parija. I, Nancy Parija, am 17 years old, born and raised in the Virgin Islands, a product of the public school system, president of the Student Council of the St. Croix Educational Complex, and also a moot court debater, giving these similar characteristics as Tracy Flick. And given from these circumstances, I also understand the importance of holding up your end of the bargain. In this situation, Tracy Flick understood the requirements made and the responsibilities that came with them.
So are you suggesting that the court should make a case-by-case determination and set precedents for the Virgin Islands that any person under 18 years of age who has the quote-unquote maturity should then be held liable for their contracts?
Yes, Your Honor, but also I am not disaffirming the rule of the 18-year-old age limit, but also affirming the legislature's choice and a firm choice of having specific instances. Those under 18 should be made liable, decision of the court.
So Attorney Parija, you say those under 18. How low should the court go? Say a 15-year-old or 14-year-old enters into a contract, and somehow that 14-year-old or 15-year-old have demonstrated mature characteristics. You're saying that the court should hold that 14-year-old or 15-year-old liable for contracts?
Well, Your Honor.
Is that the rule you're asking the finance coach to adopt?
Well, Your Honor, I'm actually asking the court to use their own discretion, and that the age gap between Tracy Flick and turning 18 was not wide at all. And if she did turn 18 when the contract was made, it is shown by the facts that she would not have been properly prepared and that she would have assumed liability because her mental capacity did not change. And we allow minors to make life-changing decisions, especially on a medical basis. Her mental capacity does not change when the clock strikes 12:01 on April 19th, 2020. Now, Your Honor, I see that may I conclude?
You may conclude your final argument.
Thank you. The transition into adulthood, as I said, is nowhere near the change of, take, for example, night and day. Therefore, we, the 17-year-olds of the Virgin Islands, ask that you reverse the lower court's decision and hold Ms. Flick and us accountable for our actions so that we are able to uphold the principles of mature adults as the future leaders of tomorrow. Thank you.
Thank you very much. I didn't get a chance to say this at the outset of the round, but Isabella Cruz was the alternate for that team. She obviously didn't argue today, but we do want to recognize all her hard work that she did in serving as an alternate. Also, just a reminder to who is online, please take pictures and email them to Rob. I know I said yesterday that it was okay to text or whatever, but given how we have to forward them to the press, please email them to Rob. Do so before 5 p.m., our deadline to get them to the press. And please include the names of all the people in the picture because they're going to demand that we provide that anyway. Also, I didn't announce at the beginning, but each of the schools is put in a waiting room for this round of the competition because we don't want the students gaining an advantage by hearing the questioning of the previous round. So I will allow this school to remain in because this is their only squad at this point. So I'm not violating any privacy or anything like that. For those watching the live stream, if you're a coach, you should not be communicating anything with your students. That is absolutely something that would not just disqualify the students who got the info, but your entire team from any placement. With that, our next school is St. Thomas and Seventh-day Adventist School. Let me put them in the waiting room. St. Thomas Seventh Day, are you there? Yes, all right.
Adam?
Yep.
I'm sorry, I just need to notice that the timekeeper will be switching and Mallory will be taking over time.
Oh, yes. Okay, Mallory, can we get you on so you can speak and everything and they know where you are?
Good morning, everyone. I'm Mallory. I'm the new timekeeper. Let me see.
Okay, I need a second to pin you.
And let me undo the blurriness of my background so that the time is completely clear.
Oh boy, let me see.
You have a stack of appellees. It's right here. All right, I'm gonna be holding it up. Okay.
Yes, there you go.
There we go. There we go.
Okay, 1 minute. I'm trying to pin her. Okay, let's see. Pin. Okay. Where are you? I think I got you now.
All right. All set, judges? We're ready for notices of appearance?
Yes.
Yes.
All right. So,
Is everyone else ready?
yes. Mr. Joshua, please put your notice of appearance on the record.
Good morning, Your Honors. My name is Ariel Joshua. That is spelled ARI-ELJOSHUA. I'm representing the St. Thomas St. John Seventh-day Adventist School, and I will be covering the first issue of appeals, which is whether the Superior Court erred in finding that the St. Paul North High School and its principal and vice principal violated Ms. Flick's First Amendment rights.
All right, Mr. Blake.
Good morning, Honors. My name is Dikai Blake, spelled D'(Kaiblake). I will be representing the St. Thomas St. John Seventh-day Adventist School on the second issue on appeal, whether the Superior Court erred in determining that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability.
All right, Mr. Joshua, when you begin speaking, the time will begin running.
May it please the court?
You might
Your Honors. Your Honors, many people believe that minors are incapable of understanding the things that adults do, and often their opinions and beliefs are shunned merely based on the age of the individual. This also can result in forgetting that we all, children and adults, live in the same country and share the same rights. Even in schools, the rights of students are frequently dismissed, resulting in their rights being violated without the minors doing anything about it. In this case, the same can be said. Your Honors, the Superior Court correctly ruled in finding that the St. Croix North High School and its principal and vice principal violated Ms. Flick's First Amendment rights in accordance to her peaceful protest. This court should affirm the ruling of the Superior Court for 3 reasons. Firstly, her protest did not cause a significant amount of disruption at the school, therefore exceeding their authority. Second,
Attorney Joshua, did not the teachers of the St. Croix North High School unable to complete their lesson plan because of Mrs. Flick's silent protest?
yes, Your Honor. For example, we know of a teacher, John Keating. He was not able to complete 75% of his lesson plan. But that was not because of my client, Ms. Flick's protest. That was because on his own accord, he started an entire classroom discussion on the matter instead of proceeding with his lesson as he should have.
Well, would you have started the discussion if it were not for Ms. Flick's protest?
Your Honors, Ms. Flick's protest was the topic of discussion, but it is up to the teacher, because he is the leader of the class, to keep control of his own classroom and to proceed with his lesson on his own accord, rather than to have an entire discussion on a different matter. Firstly, Your Honors, Ms. Flick merely took
Mr. Joshua, Attorney Joshua, wasn't there another way that this Ms. Flick could have expressed her dissatisfaction with T, other than in the classroom or to disrupt the teacher's lesson plan?
Your Honors, Ms. Flick was acting under her First Amendment rights, a right, something that she does not need permission to do. She was within her rights, and she did not cross the boundaries that were stated in Tinker v. Des Moines or Cohen v. California.
But didn't the school have a dress policy, a uniform policy, and wasn't the wearing of this T-shirt in violation of the uniform policy?
Your Honors, Tinker v. Des Moines states, in order for the state in a person or school's officials to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompanies an unpopular viewpoint. So, because Ms. Flick's protest didn't interfere substantially with the discipline of the students' rights, the school uniform prohibition cannot be sustained. The First Amendment rights of Ms. Flick were violated, with no proof of anything that would allow that to happen. And that is the most important thing, not the school uniform not being worn.
But does the school have a responsibility to protect the other students as well? And according to the school, they were trying to prevent disruption. How do you address that?
Your Honors, yes, that is true. But another thing that is also true is that Ms. Flick also has the right to act under the First Amendment. And if she follows the guidelines as described in Tinker v. Moore and Cohen v. California, which is not to cause substantial disruption or to have any fighting words that will cause a non-addressee to violence, then she is within her rights to act in any way that she chooses when she is protesting her rights and her ideas and beliefs.
But you say that she did use fighting words, as your opponent expressed to me that the FU on the sign was interpreted by the other students as fighting words. It was beyond just describing the situation, but it was using obscenities to emphasize her position.
Your Honors, Ms. Flick's t-shirts had no obscenities nor rude language. Her t-shirts said, "Forget you T, you suck." Nor did the wearing of her t-shirts cause any other students to rile up and cause violence.
But the FU, she said, was interpreted by the other students as being an obscenity.
Forget you was not...
FU. I mean, I could say it, I won't say it, but I know what she was referring to.
Your Honors, Ms. Flick's t-shirts said, "Forget you T, you suck." There were no obscenities involved in her protest, nor was it translated or taken by the students as obscene language. And to prove that, there was no violence that occurred during her protest when it happened when she joined the Zoom. So firstly, Your Honors, Ms. Flick merely took the reins in an ongoing problem that affected many of the students that attended the St. Croix North High School during their time in the learning online environment. She tried to make a difference, and in doing so, her First Amendment rights were violated. During this protest, she did not cause a substantial disruption to have been punished as severely as she was.
Do students have an absolute right to free speech?
Yes, Your Honor. Tinker v. Moore states that the First Amendment rights of our students are not taken away when they enter the school gates.
But is it absolute?
Your Honors, it is not absolute, actually. In Mahoney v. District versus BL, it is stated that schools can regulate speech in three situations. Firstly, indecent, lewd, or vulgar language uttered during a school assembly or on school grounds. Second, speech uttered during a class trip that promotes illegal drug use. And third, speech that is appearing in a school-sponsored newspaper that can perceive bearing the imprimatur of the school. If the speech that Ms. Flick or any other person that chooses to act within their First Amendment rights do not cross these bounds, then she is within her rights to act as she did. Your Honors, Tinker v. Moore states, when he is in a cafeteria, the playing field, or on campus during authorized hours, he may express his opinions, even on controversial topics, if he does so without materially and substantially interfering with the requirements of appropriate discipline in the operation of the school and without colliding with the rights of others. We know that a teacher, John Keaton, did become flustered when he initially saw the t-shirts and forgot his lesson plan. But instead of continuing his class, he, on his own accord, went and held an entire classroom discussion on the matter. Him not being able to complete 75% of his lesson was on him, and not because of my client Ms. Flick's protest. Tinker also goes on to say that the wearing of symbols, which are divorced from disruptive conduct by those participating, is closely akin to free speech, and thus granted comprehensive protection under the First Amendment rights, which is because it did not materially and substantially interfere with the operations of the school. The wearing of Ms. Flick's t-shirts did not substantially interfere with the operation of the school, because it is closely akin to free speech, which is divorced from disruptive conduct and protected under the First Amendment rights. Your Honor, I see that my time has elapsed.
Yes.
May I please briefly conclude?
Briefly conclude, please.
Your Honors, to conclude, I would like to cite Tinker Peter Moy. The school officials sought to punish petitioners for a silent, passive expression of opinion, unaccompanied by any disorder or disturbance on part of the petitioners. My client, Ms. Flick, was robbed of her First Amendment rights at school, a place where her ideas and beliefs should be heard and respected. And because of that, she lost her right to flourish academically. So I ask that you please affirm the ruling of the Superior Court and give my client her due justice. Thank you.
Thank you.
All right, well, the judges are finishing their scoring. Mr. Blake, please come up and get prepared to argue. And just a reminder to the seventh day coaches, please take pictures and email them today to Rob before 5 p.m. and include the names of the people in the picture. Judges, when you are finished, please give me a signal.
I'm finished.
I'm finished.
Finish.
All right. Mr. Blake, when you begin speaking, the time will run.
May it please the court, I stand before you today and ask that the court affirm the ruling of the Superior Court. The Superior Court did not err when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability. Your Honors, too often, young adults are taken advantage of in this community, whether by banks, managers, or even their own teachers. In today's case, I represent a teenager who is susceptible to the dangers of the outside world, particularly as it relates to legal obligations. Today, I am not only arguing to protect my clients, but to protect the other youth in the community from their own mistakes and from deceitful people. If I may, I would like to review 3 points. 1, a rule allowing minors to disaffirm their contracts and avoid liability is the best rule for the Virgin Islands. 2, this law is fair and just. And 3, the Virgin Islands should adopt this rule because of the widespread use of this principle in other jurisdictions. Firstly, this rule is the best rule for the Virgin Islands because it prevents minors from making significant legal commitments. There are many adults in the world
Excuse me, Attorney Blake. We live in a world today where young people, minors, are very adept at computers and able to contract and make purchases online, in fact, more so than many adults. Do you think that there is a need for a change in the law? Or the court should consider that in making decisions about minors' maturity level to enter into contracts?
No, Your Honor, I do not believe the court should change the law because the age majority is to separate a minor from being an adult and a child. One can determine that...
I guess I should ask you whether the court has the ability to change the law.
Yes, Your Honor, the court does have the ability to change the law.
And how so?
Because, Your Honor, the Supreme Court has the power to reverse the ruling of the Superior Court. But I ask that you do not, because the Superior Court correctly found that the best rule for the Virgin Islands was to allow minors to disaffirm their contract and avoid liability. If I may state, in Kiefer versus Fred Homeowners, it was summarized that minors are immature in both mind and experience, and they should be protected from their bad judgments, making the common law understandable and comprehensive.
But what about poor Tommy Z? Who's going to protect him? He has 200 t-shirts now that he can't sell, and he in good faith contracted with a customer. He had no idea what her age was. Certainly she was so close to 18 that she could have been 18, and he fulfilled his part of the contract, and now he's stuck with merchandise he can't sell. What about his interests?
Well, Your Honor, though it is sad Tommy Z lost his funds, it is appropriate. Because Title 16 Virgin Islands Code, Sections 261 states, all persons are deemed to have arrived at the age majority at 18 years, and thereafter to have control over their own actions and businesses and have all the rights and be subject to all the liabilities of persons of full age. Abiding by the statute today, my client was not 18 years at the time of the contract and did not receive any benefits from Tommy Z, which is why she should not be liable for any funds she did not receive. In Porter v. Wilson, it did state a minor is only liable for restitution for the benefits that she has received. And since my client did not receive anything, she should not return any funds to Tommy Z.
But sir, Mr. Blake, did Ms. Flick not receive 200 t-shirts? You said that she did not receive anything. Did she not receive the t-shirts?
No, Your Honor, Ms. Flick did not receive the t-shirts. She found an alternative to her plan by going to Kmart and purchasing the t-shirts for her class. Never once did she rely on Tommy Z services to enact her protest.
So, did she receive any t-shirt from Tommy Z?
No, Your Honor, she did not.
But did she instruct him to print t-shirts?
Yes, Your Honor, she did.
Okay, so then, as Judge Roth said, he's left with 200 t-shirts that he cannot use. I mean, isn't that fundamentally unfair to Tommy Z's?
Yes, Your Honor, it is fundamentally unfair. But concerning the law today, she was a minor. One cannot determine that a minor will be liable for this contract when the contractor did not determine if she was a minor or not. This law is fair and just. It was up to Tommy Z to find out whether she was a minor or not. To make a minor pay for services that she has not utilized will be a gross misconduct of the law.
But if the court found that your client did understand what she was doing and properly and contracted, should someone be responsible for paying Tommy Z? Like maybe her parents?
No, Your Honor, her parents should not be liable to pay for Tommy Z services because they were not the ones who enacted the contract. It was their daughter. And since their daughter is a minor, she is not bound to an executory contract or abide by it.
Are parents responsible for the actions of their children?
In certain situations, yes, but for today, they are not. Ms. Flick was the one who enacted the process, and her parents should not be liable for their daughter's decision.
So, Tony Blake, are you saying that businesses in the Virgin Islands who minors enter into contract with have an affirmative duty to determine whether or not the person with whom they're entering the contract has attained the age of majority before they perform? And that obligation should be imputed to Tommy Z's?
Yes, Your Honor. I think that is a great precaution to take when a contractor is entering into a contract with anyone, even if they are a minor or not. It is not my client's fault that Tommy Z did not find out her age at the time of the contract. Ms. Flick did not even know this law existed to think that she would be taking advantage of him. Tommy Z, as an adult, should have been wary of the law because he is an adult and should have more legal knowledge than a child in high school.
So he's in a better position to know the law than the minor herself. Is that what you're saying?
Your Honor, I am saying, as a contractor, he should know any law dealing with contracts and how he is able to not lose his funds and take the necessary precautions to make sure the contract is abided by.
Go on.
Thank you. The reason this law is being contested by several individuals is because of the viable protection it provides minors. In the case of Kiefer versus Fred Homewaters, it stated, "We believe that the reasons for allowing that obstacle to remain viable at this point outweigh those for casting aside." In light of this, we can see that the Supreme Court agreed with the protection of the common law knowing the consequences that would take place if a new rule was adopted. I ask the court to think about the children running in the street, the teenagers going to their part-time jobs, the ones who are the new generations of our islands. To put them at a great disadvantage because it suits some adults' needs would be a gross representation of what compassion is. To summarize an important
But shouldn't we also hold young adults, those close to 18, responsible for some of their actions? Shouldn't they know that right from wrong and exercise good judgment in their actions? I mean, she made a decision to cancel the order. It was too late, or not pick up the T-shirts, didn't she?
Yes, Your Honor.
So she was conscious enough. She was conscious enough to do that. So she had to have known that there was some cost, labor, and resources utilized in the preparation.
Yes, Your Honor. But bombarded by the process, she had to find a quick way to enact this process. And the age majority is not a magical time limit where someone is gained maturity. It is a distinction between an adult and a child. And since she was a child, she should be protected as such. It is not my client's fault whether the court may deem that she may have maturity or not. It is us to uphold the Virgin Islands statute that a person over the age of 18 is liable for all their services and businesses. And since she was a minor, she should not be liable for the funds Tommy Z has lost. Secondly, it is up to the contractor. Your Honor, I see that my time has expired.
It has. You can briefly conclude.
Thank you. To come to a conclusion, the best rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability. In the midst of immaturity and deceits, minors should have the ability to protect themselves and others when it comes to contracts and other legal obligations. Ms. Flick was under the age of majority at the time of the contract and is eligible to void it, supported by the common law. I humbly ask the court to affirm the ruling of the Superior Court and continue to protect minors in the Virgin Islands. Thank you for your time, patience, and questions, and hope that we can continue to protect the youth in the community. Thank you.
Thank you.
Thank you.
All right, very good. Well, we have the judges getting ready there. I will move you back into the waiting room. As I had reminded, take pictures throughout the day, email them to Rob.
Attorney Adam, I need just a 2-minute break.
All right, well,
Yes.
that's fine.
Could I take a 5-minute break?
Okay.
Then let's take a 10-minute break now and let the judges have a little bit of time.
All right. Thank you.
Thank you.
Good morning, Charlotte Damali High School. How are you today?
We're good. Good morning.
The judges asked for a break, so we're on a 10-minute break right now. Just wanted to check you in and remind the coaches, please email pictures today. Email them to Rob. Don't text or do anything like that. And please include the names of the people in the picture.
One second, Chairman.
Good morning, everyone. I just want to let you know I am your timekeeper today, so make sure I am pinned up in your corner so you can see the time.
Okay.
Good, Reed?
Yes, I'm ready.
All right. Please put your notice of appearance on the record.
Okay. Good day, Your Honors, and all in attendance. I am Jeb Jadon, that is J-E-B, last name D as in dog, I-E-U, D as in dog, O-N-N-E, from the South Amalia High School, and I will be representing the Virgin Islands Department of Education, and I will be addressing the first question of appeal whether there was a First Amendment violation in Ms. Flick's amendments rate.
All right, and Mr. Morales, could you do your notice of appearance?
Good day, Your Honors, and all in attendance. My name is Carlos Morales, spelled CarlosMorales. I am from Shaltamale High School, representing appellant Tommy Z, and I will be addressing the second question on appeal, whether the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability.
All right, Mr. DeDawn, you are up, and when you begin speaking, your time will commence.
May it please the court. Attorney Jadon on behalf of the Department of Education. Your Honors, disruption has no place in school, whether it is virtual or in-person schooling. Here we have a substantive disruption that has begun and will have exploded in the near future. Ms. Flick realized that her action was disturbing the peace, in this case the normal operation of schools, and that her intent was not just to persist, but it was also to escalate. The Superior Court erred in finding a First Amendment right violation, and that the ruling should be overturned for the following reason. Reason number one, Ms. Flick's actions were a substantial disruption that threatened to cause a greater disruption. Two, Ms. Flick's speech aligned more closely with on-campus speech, which is limited for students. And lastly, her actions and speech taken together and the violation of our long-standing unchallenged uniform policy is not speech protected in schools.
Attorney D, forgive me if I mispronounce your name, D.
Dear Don, Your Honor.
Okay. You have just outlined three factors the court should take into consideration to reverse the Superior Court's ruling. Now, let me ask you this. When a student goes into the classroom, does that student forfeit his or her First Amendment right of free speech?
Well, Your Honor, I would not say forfeit or give it all away, but it is limited for students.
Okay, how is it limited?
There are certain things that students cannot do when they are in schools. For example, using vulgar language or physically attacking somebody, and that's always limited for students. And there are many more ways that is limited, Your Honor.
Oh, but
How is this language vulgar?
Repeat that again?
How is this language vulgar?
No, I was just stating an example in which speech on campus for students are limited, Your Honor.
Oh, so you're not indicating that this speech was vulgar, is that correct?
This speech, to me, Your Honors, was vulgar in a sense, and that is why it caused a substantial disruption.
And how is it vulgar?
Your Honors, it is attacking one of the major electronical source that provides the schools and anywhere else in the St. Croix district their utility or power service. And the way that Ms. Flick went about her actions was totally uncalled for, and it interfered with the school settings and causing a substantial disruption.
But how is that vulgar? Is that not a justified criticism that she can make?
A justified criticism that involves a poster that's basically saying F you to the TEA, Your Honor, is considered to be vulgar.
So it's that aspect of the language then that you object to?
Well, that is one of the many factors that we are looking at, but in my argument, I am addressing that her actions taken all together was a substantial disruption that caused the school operation to not work as a normal setting that it was. To my first point, for 2 days in a row, Ms. Flicks was the ringleader who appeared on the computer screens in her t-shirts. From the time she appeared on the screens, the school official had all right to step in. Her actions started in school and spread throughout of a good thing called technology. JSW Mountain School District, yes, Your Honor.
Attorney DeDon, but isn't it true that the school principal and vice principal had already developed a policy even before Ms. Flick showed up in class with her t-shirt?
No, Your Honor, they developed that conclusion when one, she was interrupting the class setting for 2 days in a row when she appeared on the computer screens, and two, the violation of the school uniform policy. Three, a future substantial disruption of 200 t-shirts.
But
Ms. Flick,
200 students didn't appear with t-shirts on, as was feared. Is that true?
could you repeat that again, Your Honor?
I said 200 students didn't show up in the t-shirts as was feared.
They did not show up, but it was a future substantial disruption as stated in Tinker. Once it's a future foreseeable disruption, the school official has all right to step in.
And
Ms.
so
Flick, initial plan.
is a student's First Amendment rights any different from the average citizen?
Yes, Your Honor, because if the average citizen is not in a governmental place, for example, if they're not in school or in a courtroom, it is limited. But if they are outside in the general public, it is somewhat limited, but not to a certain extent of the students or anybody else in a governmental institution.
So you're suggesting that the fact that school was online means that it was on school property?
Yes, Your Honor, that is exactly what I'm stating.
Explain that.
The fact shows that Mr. Keating, specifically to the point of him being only completing a mere percent of 25 of his lesson plan for 2 days, and other teacher had to address this situation in the classes, face disruption as well. This got back to Principal Rooney and Vice Principal Vernon, despite the remote nature of schools due to the pandemic. This is a substantial disruption, but the 200 t-shirts will have been far more worse. We are precocious individuals. We know that there are not 200 individuals in one classroom setting. For any schools, 200 shirts would be a clear sign of a future substantial disruption. Which brings me to my second point. While JS and Mahanoy BBL both identify off-campus speech that can be regulated in a manner similar to on-campus speech, Ms. Flick's speech falls squarely on the on-campus category. Although the Supreme Court in BL shied away from creating a broad, highly general rule stating what's counted as off-campus speech, Justice Byers note that the brief in BL and the amnesties supporting her outline all speech taking place over school laptops and speech taking place during remote learning as on-campus speech. Ms. Flick's speech isn't just speech taken anywhere or anytime, which I'm alluding to JS. It is during school hours, during class time, on a school device, through a school platform. In this instance, even though Ms. Flick's speech isn't physically away, her speech is on campus and situationally it should be treated as such, or in other words, it is tantamounted, Your Honor.
Well, wasn't this an educational opportunity for the teacher and the class, the other students?
Yes, Your Honor. I'm glad that you asked that question. It was a teaching opportunity for Mr. Keating, and we're doing exactly what we expect a teacher supposed to do in this instance. For example,
you're saying that the student can initiate a subject matter?
We do not expect our teacher to stay strictly on the lesson plan, but if it's closely related, it is a learning matter. In this instance, Ms. Flick's first period class was AP Government and Civics, and the content that she introduced, or the substantial disruption that she introduced, was relevant in this course. But when the other class and when other teachers got a hold of this and had to address it in their class, that is when the future substantial disruption actually became a disruption. When they had
you complain about the teacher only fulfilling 25% of his lesson plan, but was he not presented with a different vital lesson that was important for the students to learn this protest and how our Constitution protects protest and how protest is useful in the advancement of government? And it wasn't appropriate for the teacher to pick up on this and to present it as a lesson plan for the teacher, for the pupils in his class, so that he cannot be criticized for only fulfilling 25% of his lesson plan.
Well, Your Honor, the 25% is stated for only Ms. Flick's first period class because that was the class that she was in first period. But
yes,
when the other...
But even though he only presented 25%. He presented other very valuable educational issues that was important for the class to learn and was a good substitute.
That's correct, Your Honor. That's a life lesson right there in Miss Flick's first period class. But we do not expect art to be talking about AP Government and Civics in their art class. We do not expect math to be talking about AP Government and Civics in their math class. We're saying that Miss Flicks can have a problem with TEA. She has the right to speak on TEA. But what she cannot do is use a school platform to create a disruption while laying down the groundwork for more substantial disruption. Lastly, Your Honors, JS and BL both hinge on the fact of Sweet being off campus and not have nothing to do with the dress code. Unlike Tinker, we do not have a temporary armband, and the Virgin Islands history of public school uniform, I would say give or take approximately 60 years. With that being said, we are no strangers in society. Your Honor, I see that my time has elapsed. May I finish my point and conclude?
You may, briefly.
We are not strangers in society, but we know that students wear their uniform to help them stay focused and maintain order. The Department of Education requires students to wear their uniforms and to turn on their cameras to ensure that they attend virtual classes. Ms. Flicks used a school device through a school platform to lead a disruption during class hours and school hours in violation of a uniform policy. Tinker had 3 students who violated the temporary armband, but 3 is far fewer and far less disrupting than 25, let alone the future substantial or potential substantial disruption that could have been 200. It is for these reasons that there is no First Amendment right violation in this case, and this court should vacate the most superior court ruling, installing judgment in favor of my client. Your Honors, we thank you for your time.
Thank you.
All right, while the judges are doing their scores, Mr. Morales, please come up and be ready to speak when they are finished. And as always, let me know when you're done with your scores, judges.
I'm finished.
You finished?
Finished.
All right, Mr. Morales, when you begin speaking, your time will commence.
May it please the court. Attorney Morales on behalf of Tommy Z. We are not here to rob minors of their ability to disaffirm. That protection does not exist for those who execute contracts when they are adults. The Superior Court erred in its decision, and that decision should be overturned for these reasons.
Attorney Morales, how can you, are you suggesting to the court that Ms. Flick had attained the age of majority when she entered into the contract? Are you saying she was, but wasn't she 17 years old when she entered into the contract?
Well, no, Your Honors. Upon on Monday the 13th, she only made a request, whereas it became official on Monday the 20th when the shirts were made available to her for pickup. And by that time, she had made birthday on the Sunday.
So you're saying the facts indicate that when she entered into the contract with the t-shirt company that she had attained the age of majority? She was 18 years old?
Correct, Your Honors. That's exactly what I'm saying.
Okay.
Did she indicate in any way to Tommy Z that the contract was not final at the time she went in and talked to him?
Could you repeat? I didn't hear the first part.
Did she indicate in any way to Tommy Z when she went in and ordered the t-shirts that the contract was not complete yet at that time, would not be complete until he had produced the t-shirts?
Well, yes, Your Honors. That was the agreement. He told Miss Flick that the shirts will be made available on the 20th.
But that did not indicate that he wouldn't begin immediately to print them up and to take goods that he had available in his shop for any purchaser to make them unavailable then to any purchaser except the plaintiff, except the young lady. He now has 200 t-shirts that he can't sell, and he started working on those immediately, but you're saying the contract wasn't complete at that time?
Correct, Your Honors. Okay, so hypothetically, let's bring a hypothetical into the situation. If on Monday the 13th, Ms. Flick called to see if a hotel had availability on the 20th and asked them to hold a room, a contract does not exist on the 13th. When she arrives to claim that room on the 20th, she would be at the age of majority, an adult. At that point, the contract would be entered into as an adult, as Ms. Tracy Flick did with my client Tommy Z. This is similar to our case because where the contract between Tracy Flick and Bob placing an order for 200 customized t-shirts that were printed and to be picked up at a later date, it was merely a request until the Monday 20th when the request became official.
But didn't Tommy Z make the 200 t-shirts based on the contact and the request, as you say?
Yes, he did.
So are you saying that if in fact Ms. Flick could contract, that the contract only became a contract after she turned 18 years of age?
Correct, Your Honors.
Well, does she in fact, so you're saying because she didn't have the legal ability to contract before 18 years of age, that the contract only became effective after she turned 18? Is that what you're saying?
I'm not sure I understood your question. Can you repeat?
Are you saying that she didn't have a contract before she turned 18?
Yes.
And
she did not.
At the time that she turned 18, she then had a contract?
Yes, Your Honors.
So if she was 18 on the 13th of April when she made the request, would there have been a contract then?
No, it will still be the 20th because upon the 20th was when the t-shirts were made ready available for her to pick up.
Okay. You may continue.
Miss, if the best common law is to follow these statements mechanically opposite the decision in government of the VI versus Connor, Ms. Flick is not an infant or any other person who lacks the full capacity to contract at the time of the execution of this contract. Ms. Flick knowingly planned for the future, but she was capable of acting in full. But if this court views this span of time as a gray area, then the cases and additional analysis of the sections of restatements that the Moot Superior Court looked at are also not in her favor. To my second point, even if she was a minor at the time of the contract, Ms. Flick affirmed her contract. As we've noted, upon the execution of the contract, Ms. Flick was at the age of majority. However, by not reaching out and actively allowing my client to continue work on her project, even after the school may have gotten wind of her plan, even after she put a contingency in place at the school, even after a second day of activity or her additional activity, this shows she affirmed the contract.
Attorney Morales, the Virgin Islands statute say that persons under 18 do not have the capacity to make contracts, and only persons over the age of 18, once they've reached the age of majority, can enter into contracts. Are you suggesting that we ignore that statute?
Could you speak
or that an exception be made?
I didn't hear the first half of the question.
Are you suggesting that we ignore the Virgin Islands law that says you have to be 18 years old to enter into a contract? At least 18 years old? Or are you suggesting that there should be an exception made?
Well, Your Honors, neither, because the contract started when she was an adult on Monday the 20th.
Okay. Okay, I got your position.
The Bagley v. Bachelor case also addressed a similar situation. In that case, Bagley used to live to ski 119 times, both before and after his 18th birthday, and sought to disaffirm a full year after his injury. That court found he ratified his contract, waiving his ability to disaffirm. Similarly, Tracy Flick manifested an intent to let her agreement stand. She wanted the benefits of this agreement. She could have canceled Monday afternoon, all day Tuesday, all day Wednesday, all day Thursday, and all day Friday. Your Honors, she potentially even had Saturday, a day before her 18th birthday, to cancel her agreement, but she did not. In the process, she affirmed her contract with my client. So, what then is the best common law rule for the Virgin Islands? We could look to New Hampshire in Porter v. Wilson, where a minor can disaffirm, but they are still held liable for actions seeking restitutions for the benefits they have received. Ms. Frick benefited from my client's time, talent, and t-shirts. If this was a rule, she would be liable. But the truth is, Your Honors, the lower court looked at the right place, but did not read the full text. That court went as far as looking at the provisions and statutes of Alaska, which pulled from Oregon, that the Virgin Islands adopted. The court found this to be highly persuasive, even if we look to the slight majority of jurisdictions. The court found,
Did the lower court actually conduct a Banks analysis of this issue? And are you questioning that determination?
Yes, it did conduct Banks analysis, Your Honors.
Okay, and so you're disagreeing with this decision based on that analysis?
I'm not disagreeing with the decision. They just didn't read the rule in full, which stands as a minor can disaffirm their contracts and avoid liability, but conversely, they can ratify their contracts and face liability. This is not a new rule. This is the same standing rule in full. We still contend that Ms. Flake was an adult upon the execution of her contract, but by affirming her contract, she will still be held liable no matter the best common law. It's for these reasons stated, this court should find in favor of my client, Tommy Z, and overturn the Moot Superior Court's ruling. Your Honors, if there are no further questions, I would like to yield the rest of my time to the court. Thank you for your time.
Thank you, Attorney.
All right, thank you, Charlotte Amalie High School appellants. I would mention that Almonique Francis was the alternate for that team. She didn't argue today, but she definitely participated and put in all the work. Our next team, while the judges are scoring, will be All Saints appellees. I'll move Charlotte Amalie into the waiting room again. Just a reminder to take and send pictures with the names of the people in the picture.
Okay.
All right. All Saints, are you with us?
I'm done.
Yes.
I'm finished.
All right. Mallory, can you speak so they know where the timekeeper is?
Good morning. It's still morning. Good morning, everyone. I'm Mallory, and I am your timekeeper today.
Please pin her so you can see the time. All right. I believe the judges are ready, so All Saints appellees, can you please put your notices of appearance on the record?
Good morning. My name is Makeda Elizabeth Cady. M-A-K-E-D as in dog, A dash E-L-I-Z-A-B as in boy, E-T-H-C-A-B as in boy, E-Y. I am representing All Saints Cathedral School on behalf of the appellee. I will be arguing issue number 1. Whether the Superior Court erred in its findings that St. Croix North High School and its principal and vice principal violated Ms. Flick's First Amendment rights.
All right, Ms. Fleming.
Good morning. My name is Danielle Fleming. X-A-N-I-H-F-L-E-M-I-N-G. I am representing the All Saints Cathedral School on behalf of the appellee. I will be arguing issue 2. While the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow men to discipline their contracts and avoid liability.
All right, Ms. Kaby, you are up. Your time will begin when you begin speaking.
May it please the court. Your Honors, Ms. Tracy Flick's First Amendment rights were violated when the principal and vice principal expelled her from St. Croix North High School. The Supreme Court should uphold the decision of the Superior Court as they were correct in their ruling. The First Amendment right to free speech is one of the most sacred, protected, and important constitutional rights. Ms. Flick's conduct was within the protection of the First Amendment. Only very narrow exceptions exist where United States citizens cannot freely express themselves and where public institutions, such as public school, can regulate the speech of American citizens. The exceptions which allow for regulation of free speech are generally limited to hate speech or content that immediately incites violence.
Counselor, does it make any difference that Ms. Flick was not actually in school, but was doing this by video, by Zoom?
No, Your Honor. Yes, Your Honor, it does make a difference that she was at home because since she was at home, she was on a school-issued device given to by the government, and she was therefore she was an extension of on school grounds. But her being on school grounds still did not call for, her violation still did not call for an expulsion. The exception
Attorney Kirby, are you saying that because the Supreme Court has held that when a student enters the school campus, that he or she does not forfeit his or her First Amendment right?
Your Honor, may you repeat your question, please?
Yeah, are you saying, as the Supreme Court has held, that when a student, assuming Ms. Flick was on the school campus, that when she entered the campus, she did not forfeit her First Amendment rights?
Your Honor, no, she did not forfeit her First Amendment right. Ms. Tracy Flick, as a student, as an American citizen, is given the right to free speech. And being on school, they can regulate certain free speech, such as vulgar, lewd, or disruptive language, but Ms. Flick did not do such thing.
But did Ms. Flick's conduct prevented the teachers from, or particularly one teacher from completing his lesson plan, thereby causing irreparable damage to the students?
No, Your Honor. Ms. Flick did not disrupt class. It was the teacher, Mr. Keaton, who decided to take up his own class time to go and discuss the contents. Ms. Flick silently came into school, into class wearing her t-shirt as an expression of her dissatisfaction, and therefore Mr. Keaton should be the one held accountable because Ms. Flick did not do such, she did not disrupt class.
But for Ms. Flick's conduct, would the teacher engage in that type of discourse or discussion with the student?
Will you repeat your question, Your Honor?
Were it not, okay, would the teacher engage in the discussion with his student if Ms. Flick did not engage in her silent protest?
Your Honor, it may have been that Mr. Keating may have brought up this fact of disruption with TEA's internet issue, but it did hurt Ms. Flick's wearing her clothing choice. May you repeat your question, Your Honor?
Would the teacher have engaged in the conduct or the discussion if Ms. Flick did not wear a T-shirt demonstrating her dissatisfaction with the internet connectivity?
Yes, Your Honor. The teacher may have brought this up if Ms. Flick did not bring it up in class, because it was an issue going around with all students. So therefore, it would have been brought up at one point in time.
Okay, you may proceed. Thank you.
The exceptions which allow for the regulation of free speech may be a little broader for schools, which have a right to stand in locum parentis and serve as the authority figure to discipline children and have legitimate reasons to maintain order amongst the students for proper operation of their schools. But even still, there are limits, and students still have free speech rights that must be protected unless they are truly profane and uttered on school grounds during school time.
Attorney KB, the school felt that Ms. Flick, your client, was caused disruption with the teachers being unable, not just in her class, but in other classes, unable to complete their lesson plans. What actions you think the school should have taken instead of the action that it took in expelling your client?
Your Honor, I think suspension, removing Ms. Flick from class, emailing her parents, having a conference were all options that could have been taken before this immediate step of expulsion.
So you believe that the punishment was excessive?
Yes, Your Honor. I believe the punishment was really excessive.
You talked about obscene language, but I have teenage grandchildren who use the expression F you in ways that I find quite offensive. And wasn't that a dominant theme on the message on these T-shirts, F you? How should we interpret the symbolism of what was expressed on the T-shirts?
Your Honor, the T-shirt stated, forget you, not F you. She clearly stated her intentions with the words, forget you, so it cannot be taken that she was trying to imply F you, because she clearly stated, forget you.
But would not some of her contemporaries, her classmates, have interpreted as F you instead of forget you?
Yes, Your Honor, her classmates may have interpreted that way, but Ms. Flick clearly stated what she was implying. So she should not have been held to expulsion because she clearly stated what she was implying. So if other students took it that way, it's how they interpreted it, not how Ms. Flick implied it to be.
But Ms. Flick was known to be a leader around school, involved in many activities, and so shouldn't she have expected that the student body and her other cohorts would have interpreted that or intended for it to give that vulgar connotation, such as FU?
Repeat your question, Your Honor.
I'm saying, as a leader in school and an active participant in many extracurricular activities, an excellent student, shouldn't she have known that the forget you word could have been interpreted in other ways, and others would have taken it to mean FU, and didn't she have a responsibility to quell that and not engage in what appeared to be a vulgar connotation?
Your Honor, she may or may not have expected that connotation to be brought forth, but then again, she clearly did state what she was implying. So she couldn't really hold the fact that other students may be thinking of that in that way because she stated how it should be taken. But even still, there are limits, and students should still have free speech rights that must be protected unless they are truly profane and uttered on school grounds during school times or immediately inciting violence. The court in Mahoney provided a very clear standard. The court held that schools may only regulate speech in certain limited circumstances, such as when indecent, lewd, or vulgar speech uttered on school grounds. Here, the shirt worn by Ms. Flick was not indecent, lewd, or vulgar, and did not immediately incite violence. Therefore, the public school did not have a right to regulate her speech in the way that they did, where they deprived her of her fundamental right to a public education by expelling her.
Even though the school, the lower court ruled in your favor, is there anything that in the ruling that you disagree with?
Your Honor, can you clarify, please?
Is there anything in the lower court's ruling, even though it was in your favor, is there anything in that ruling that you disagree with?
I disagree with Ms. Flick being held accountable for everyone's actions. Yes, I do agree that Ms. Flick should be held to some sort of standard and be punished because what she did was a violation of the dress code policy, but she should have not been immediately expelled.
You may conclude in your 30 seconds.
In conclusion, Your Honors, the Supreme Court should uphold the Superior Court's findings that Ms. Flick's First Amendment rights were violated by the actions taken by the school and its principal and vice principal. Thank you.
Thank you.
All right, well, the judges are scoring. Could we please get Ms. Fleming up? Judges, give me the okay when you are done.
I'm ready.
Finished. All right. Okay, we got the timekeeper back. Ms. Fleming, when you begin speaking, your time will commence.
May it please the Court. The Supreme Court should uphold that the Superior Court's decision that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability, as there is a strong public policy interest in the Virgin Islands and elsewhere for protecting minors. The legislature makes the laws and the court enforces them. The court should not be making the law or deciding each case on a case-by-case basis, subjectively. The law and the courts generally recognize that the age of majority is 18 in the Virgin Islands. As there is no first statute on minors disaffirming contracts in the Virgin Islands law, the Superior Court properly undertook the required analysis in this case by demanded by conducting a bank's analysis, as described in the decision in Connor. The VI Superior Court properly noted that courts had not adopted a particular rule, and the slight majority of courts in other jurisdictions do allow minors to disaffirm their contracts, and then they wisely determined that the best rule and soundest approach for the Virgin Islands was to allow minors to disaffirm their contracts in a reasonable amount of time. The court recognized that the public policy interest exists in protecting minors. When you start to allow minors to be held responsible for contracts on a case-by-case basis, it becomes a slippery slope. How many days before a person turns 18 is almost 18 years old and is mature enough? Is it 5 days? Is it 10 days? Is it 20 days? The 18-year-old mark is set for a reason and is universally accepted as a point of a person becoming an adult.
Should minors be enabled to affirm a contract after they reach the age of majority, after they reach the age of 18?
No, Your Honor, because they shouldn't have been able to enter the contract in the first place. The fact that she was
And
only...
who would you suggest, or don't you think that Tommy Z is entitled to some compensation for the work he performed based on the order made by your client?
No, Your Honor, I do not believe that Tommy Z should be receiving any compensation because it was his due diligence to realize that Ms. Flick was not the age of majority yet, and it was his due diligence to ask for some sort of verification that she was above the age of 18.
So he failed to exercise due diligence, is that what you're saying, to ensure that he was contracting with someone capable?
Yes, Your Honor.
Continue.
And now he has 200 T-shirts that he can do nothing with. Has he no remedy?
Your Honor, I believe that if Tommy Z really wanted to do something with these T-shirts, he could have given it to a shelter or somewhere that needed extra clothing when they take in people. The fact that she was only a few days shy of 18 is not the point. She was not 18, which is the required age. Tommy Z has been a businessman for quite some time. While Ms. Flick was almost 18, the fact is yet that she was not yet 18. Regardless of what Tommy Z thought or assumed in terms of Ms. Flick being above the age of 18.
Are there any exceptions in the law with respect to a minor ability to contract or be treated as an adult?
Your Honor, in some cases, the legislature allowed for minors to be held for things such as criminal charges, or to allow them to consent to, or make certain medical decisions for themselves. He did not check for any identification to see if Ms. Flick was not legally able to make the contract and made this purchase. The cost of making 200 T-shirts may not be a big expense for a business owner, but it is a big expense for a 17-year-old. If you rules who are accountable here, you change the law for the Virgin Islands, and therefore expose other minors who may not be as mature as Ms. Flick to be taken advantage of. The interest in holding her accountable for the order of T-shirts does not outweigh maintaining an important public protection for all minors. Your Honors, I ask you to think about how many minors might have been taken advantage of in other situations because they entered a contract without proper knowledge. While Tommy Z might not be a bad person here, there will be other money-hungry businessmen who will use this change in the law to take advantage of minors. It is not
in this case, Attorney Fleming, your client is very much involved in student government, is an excellent student. She has this ambition to be the first female governor. She's organized other activities before. Do you think these factors should be considered in determining whether she's mature enough to enter into a contract, and in fact whether the court should make a judicial declaration to emancipate her?
No, Your Honor, I do not believe that those facts should come into play because then you would be changing the law on a case-by-case basis, subjectively.
Very well, continue.
Tommy Z failed to do that because here, it is very inexpensive and easy for a business to protect itself. Tommy Z failed to do that here, and unfortunately, he must accept the business loss that he suffered because he did not do this one simple step. Any legitimate businessman should always ask for client's ID, no matter how mature they may seem. Upholding this decision by the Superior Court will put all businesses on notice that they should change, that they should Changing the decision of the Superior Courts opened the doors for minors to be taken advantage of. Should a minor be held responsible for signing a contract to buy a house? Should a minor be held responsible for signing a contract to buy a car? If the court changes the rule, which is in place for a very good reason, where does it stop? Should the court be deciding each case on specific facts and circumstances and deciding that minors should be held responsible for some contracts and not others? That would not be wise. In the Virgin Islands and many other places, it has been maintained that a minor cannot enter a contract for any amount for good reason. Although it may seem unfair to Tamazi, the court got it right. There is a good public policy reason to maintain that minors should not be able to enter a contract until they are at 18 years. The Virgin Islands legislature has changed the law to hold minors responsible for certain things, like criminal charges, and allowing them to consent to and make certain medical decisions for themselves. But those situations are different and individual. Your Honor, it seems that my time is beginning to expire. May I conclude my argument?
Yes, you may. Okay.
In conclusion, Your Honors, the court should uphold the Superior Court's decision that the best common law rule of the Virgin Islands is to allow minors to discipline their contract and avoid liability within a reasonable amount of time.
You have a few more seconds.
This case is different in Bagley's because in Bagley, the minor used the contract after they got to be of age. He used the pass for a total of 119 times after turning 18. In this case, she never went back to ratify the contract for the t-shirts after she became of age.
All right, thank you.
Thank you.
While the judges are scoring, I will admit St. Peter and Paul to the room. All Saints, please take pictures and email them to Rob with the names of the people in the picture, and do so before the end of the day. Just as a reminder to everyone, the schools that no longer have anyone competing will not be moved back into the waiting room, and so All Saints will remain here to observe because that was their last competition round. And let me then add St. Peter and Paul.
Finished.
All right. I am assuming this is St. Peter and Paul School that I just admitted. Is that correct?
Yes, it is St. Peter and Paul.
All right. Can we get your video feed up and start getting prepared while the judges are scoring? Okay.
I'm done.
And Judge Watlington, I think you're the last.
Yes, I'm done.
All right. So with that, could we please get your notice of appearance?
Good afternoon, Your Honors. I am Alistair Cardi, ALISTAIRCARTY, and the school that I represent is the St. Peter and Paul Catholic School. And the issue that I will be arguing today is whether the St. Cornwall High School's principal and vice principal violated Ms. Flick's First Amendment rights. And the side that I represent is the appellant. Good afternoon, Your Honors. I am Ethan Farrell, ETHANFARRELL. The school that I represent is St. Peter and Paul Catholic School. The issue that I'll be arguing is whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contract and avoid liability. The side that I'll be arguing is the appellant.
All right, Mr. Cardi.
Also, I just want to let everyone know I am the timekeeper, so make sure I'm pinned and you can see me for the time.
Thank you, Mallory. I completely forgot to do that. And with that, when you begin speaking, your time will commence.
May it please the court. Your Honors, the Superior Court did make an error when it found that the St. Cornwall High School's principal and vice principal violated Ms. Flick's First Amendment rights. First, Ms. Flick was punished for her speech because it caused a material and substantial disruption in the school. Second, her speech also involved substantial disorder, meaning that it was indecent. Third, her speech infringed on the constitutional rights of her fellow classmates. And lastly, Ms. Flick violated the school's dress code. Ms. Flick's speech caused material and substantial disruption when her civics teacher, Mr. Keating, did not complete 75% of his lesson plan just to discuss the true meaning of the shirts with his students.
But wasn't it an important free speech issue for him to discuss the issue of the T-shirts? Wasn't that an issue which came up and had a lot of significance for the students, and he as a teacher correctly decided it was the most important thing to talk about?
May you rephrase that question, Your Honor?
The fact that he only completed 25% of what he had expected to do, he was presented an opportunity to talk about another very important issue. And wasn't it better for him to talk about the other important issue and the questions of free speech than it was for him to simply ignore that and go back to his original lesson plan?
Well, Your Honor, Mr. Keating had a lesson plan that was not completed simply because of Ms. Flick's disruption. If Ms. Flick never wore these shirts, this disruption would have never occurred, Your Honor.
But also, Counsel, I think the justice question to you is, did not the other classmate benefit in an important lesson in civic, that is, whether or not someone has a First Amendment right, simply because Ms. Flick chose to engage in a silent protest? Did it benefit the school rather than prejudice the other students?
Your Honor, it did benefit the school, but simply because of Ms. Flick's protest, Mr. John Keating, he had a lesson plan that was not completed because of this protest, Your Honor. This disruption also lasted for two days, and it not only disrupted one class, but many other classes, simply because students were taking pictures of the shirt and posting it on different social media sites, such as TikTok, Your Honor. And considering the fact that there were no TEA officials there to witness this occurrence, the only common viewer of the shirts would be the teachers in the situation. Second, Ms. Flick's speech involves substantial disorder. If we take a look at the phrase that was said on the shirt, forget you TEA, you suck. The you suck portion of the phrase can be seen as indecent, Your Honor. The reason being is that if we refer back to the Chaplinsky versus New Hampshire case, it states that the government can restrict speech under different conditions. Those conditions being, the speech must not be indecent, lewd, vulgar, profane, and fighting words, Your Honor.
What is it, Attorney Cardi, that if this T-shirt, the writings on this T-shirt was considered indecent, why is it that only Ms. Flick was punished and disciplined for this?
Well, Your Honor, Ms. Flick was the ringleader of this whole operation. So therefore, she was punished to set an example for other students and to prevent chaos from growing in the school, Your Honor.
So she was penalized for the actions of others, or weren't others equally responsible for making a decision to wear the T-shirts?
Well, Your Honor, Ms. Flick encouraged other students to wear the T-shirt. So her punishment is rightfully permissible, considering the fact that she devised a plot and she also encouraged her classmates to violate the school's rules and disrespect the teacher, Your Honor.
And so was expulsion the only remedy available to the school?
Well, Your Honor, the school did have different ways of punishment, but it was right that Ms. Flick got an expulsion, Your Honor.
Why was it right? Why was it right?
It was right simply because Ms. Flick knew that she had to be online in class with her school uniform on and with her camera on. Ms. Flick therefore violated the school's rules and went against them and wore something that was not a part of her school uniform, Your Honor. This is not appropriate behavior, especially in a school setting, Your Honor. Because in page 2 of 8 of the fact pattern, it states that a student must be online on Zoom with their cameras on, and they must be in uniform. Third, Ms. Flick's speech infringes on the constitutional rights of her fellow classmates. The reason being is that Ms. Flick disrupted others from learning, and she encouraged others, as I previously stated, to wear the shirts. And in the Tinker rule, it states that a school is permissible to punish a student if their speech is disrupted, if it involves invasion of rights of others, and it causes substantial disorder, Your Honor, in which Ms. Flick's speech did exactly so. Alternatively, however, Ms. Flick was punished for violating the school's dress code. This is significant because the students were to get in uniform and get in the right frame of mind for learning, Your Honor.
One day violation of the school dress code, does that justify an expulsion? Or a 2-day violation of the school dress code, does that justify an expulsion?
Yes, Your Honor, because if we remember that the context that was on the shirt is the main reason why Ms. Flick got an expulsion. So she violated the school's dress code, and she had substantially and materially disorderly conduct that was on the shirt, Your Honor. Even if Ms. Flick
how can we say it was disruptive? It was a writing on the shirt, but there's no obscenity used in that writing.
Well, Your Honor, it was disruptive simply because Mr. John Keating, he had to discuss this matter with his class, which made it substantially and materially disruptive to the educational process, Your Honor.
But wasn't that an important matter for him to discuss with his class? As American citizens, shouldn't we understand the right of free speech and the right of freely discussing issues that are before us?
Well, Your Honor, it may have been an important matter. However, Mr. Keating had a lesson plan that was not completed simply because of Ms. Flick's silent protest. If Ms. Flick never wore this shirt, this occurrence would have never happened. Even so, if Ms. Flick wanted to convey her emotions toward the government company, TEA, she could have used a virtual whiteboard that was issued on the school-issued computers, Your Honor. It would not have mattered if Ms. Flick even wore a t-shirt or a dress. She still would have been.
Do you agree, Attorney, do you agree with the precedent set in Mahanoy Area School District versus BL?
May you repeat your question, Your Honor?
Do you agree with the precedent set in Mahanoy Area School District versus BL? That's where the cheerleader protested outside of school. And in that case, the First Amendment rights were protected. Do you agree with that precedent?
Well, Your Honor, I would disagree because in this case, Ms. Flick was at home, yes, but she was in a school setting. So therefore, she needed to have the right uniform on, and she needed to be in the right frame of mind for learning, not in the right frame of mind for a protest, Your Honor. Ms. Flick decided to not focus on the task at hand, which was school, and she decided to protest instead of focusing on what really matters to her, which is her education, Your Honor.
So you think that case is distinguished by the fact that it was outside of the school and not in the school, even though the school was virtual in this case?
Yes, Your Honor, it does make a difference that in the JS case, she was at home. But in Ms. Flick's case, she was in school, in virtual school, and she needed to have the right state of mind to learn and not to protest, Your Honor. To conclude, simply because Ms. Flick has freedom of speech, this does not mean she is free from the consequences. Her punishment was permissible because she caused a substantial disorder, she violated the school's dress code, and she encouraged others to participate in this action. Due to all of these reasons, I respectfully request that you reverse the court's decision. Thank you.
Thank you, Attorney.
All right, well, the judges are totaling. Mr. Farrell, please come up and be ready.
Okay,
Okay.
All right, Mr. Farrell, your time will begin when you begin speaking.
Good afternoon, Your Honors. May it please the court. The Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability. The best common law rule for the Virgin Islands should be that a minor is bound by their contract and must pay restitution to the merchant. This court should reverse the Superior Court's decision because first, the t-shirts were custom made and cannot be sold to anyone else but Ms. Flick. Second, Ms. Flick didn't attempt to disaffirm the contract after knowing she was not in need of the t-shirts. And finally, Ms. Flick had a reasonable amount of time to disaffirm the contract.
Attorney Farrell, do you believe that this court should set precedents that minors should be bound by their contracts and pay for whatever cost they incur regardless of their age? So someone, a minor who's maybe 14 years, who's not legally eligible to work, where would they earn the monies to pay somebody like Tommy Z?
Well, Your Honor, the best age for a minor should be 16 because minors are being held accountable for criminal matters at the age of 16 and 16-year-olds are being able to drive and held responsible for accidents that they get into.
And does the law with respect to minors being able to contract or prohibiting minors from contract, are there any exceptions to that law?
Can you repeat the question, Your Honor?
Are you aware of any exceptions to the law that says a child has to be 18 years of old, or you have to be 18 years or more to enter into contracts? Are there any exceptions to that, as there are exceptions with respect to minors who commit criminal acts, certain criminal acts?
Yes, Your Honor, if the item was a necessity, Your Honor. On April 13, 2020,
what constitutes a necessity? Is there a necessity here? Are you arguing that this was a necessity?
Yes, Your Honor. The t-shirts were a necessity to Ms. Flick. On April 13, 2020, Ms. Flick contacted Tommy Z Mediocre Tees and requested 200 t-shirts with the message, "Forget you TEA, you suck," be made by April 20th, 2020. Since Ms. Flick telephoned Tommy Z, it is not customary for a merchant to request a government-issued ID. Therefore, Tommy Z couldn't have known Ms. Flick was a minor. Tommy Z had the t-shirts available on the agreed delivery date, but Ms. Flick never called or came to pick up the t-shirts. Your Honors, may I remind you that it was 200 custom-made t-shirts that my client made for Tommy Z. If he does not pay restitution to Tommy Z, he will have to come up with the fees to pay for those t-shirts. Your Honors, in the Porter vs. Wilson case, it states that infant or lunatic, whether executed, a contract of an infant or lunatic, whether executed or executory, cannot be avoided without restoring the other parties. Your Honors, minors are being tried as adults for criminal matters. 16-year-olds are held accountable for accidents that they get into. And it is unjust if Ms. Flick doesn't pay Tommy Z restitution for over a simple transaction.
Could Ms. Flick have verified the contract, have come in after she turned 18 and said, I still want to continue with this contract under your version of how the law should be changed? Would you go along with that consideration?
Can you repeat the question, Your Honor?
If Ms. Flick, by words or deeds, had indicated after she had turned 18 that she was standing behind the contract. Would that be an appropriate action under your proposed change in the law?
Yes, Your Honor, because she then made the age majority and she should have come forward and picked up the merchandise that she was agreed to get.
But if she had called Tommy Z and said, yeah, I want to continue with this contract, that would have been sufficient?
Yes, it would have been sufficient, Your Honor. Your Honor, this rule was adopted in 1965, and minors in the 21st century are more mature than minors in 1965. For example, Ms. Flake was an intelligent young woman who took part in Moot Court, the student government, the chess club, and even hold events in her community. Second, Ms. Flake didn't attempt to disaffirm the contract after knowing she was not in need of the t-shirts. In the Bagley versus Mountbachelor case, the court concluded since Bagley used the seasonal pass 119 times, he manifestly showed the intent to agree to the seasonal pass. In our case,
but in this case, isn't Bagley's a little bit much more excessive in terms of times and usage compared to in this case where only a few days passed after she turned 18 before she disavowed the contract?
Can you repeat your question, Your Honor?
In Bagley, the time was, you said 119 usage. I mean, there was a lot, it was much more excessive compared to this case, where only a few days passed after she placed the order and she canceled. How do you compare the two?
And then over and over and over again, she would give them a slap on the wrist.
Oh, someone else needs to be muted.
Because, Your Honor, Ms. Flake let the contract stand by not contacting Tommy Z to disaffirm the contract. Therefore, my client Tommy Z continued making the t-shirts that was ordered. In our case, it states that that same evening that Ms. Flake made the contract with Tommy Z, the school was going to stop such actions from happening. So the students agreed that they were going to buy $50 white t-shirts from Kmart and customize them with paint and markers. Your Honors, Ms. Flake knew that same evening that she was not in need of the t-shirts and she should have called Tommy Z to disaffirm the contract. Finally, Your Honor, Ms. Flake had a reasonable amount of time. In Engelbert's case, it states items other than necessities are avoidable and may be disaffirmed when the minor becomes of age. Let's not forget, Your Honors, that she made 18 in that same week. Your Honors, if this rule stands, business owners will be losing profit from this scandalous act that teenagers are committing. In my case,
does the business owner have a responsibility to verify who it is doing business with, he or she is doing business with?
Well, Your Honor, since the contract was over the phone, and during that time it was COVID-19, so business owners and clients couldn't come into the shop. So Tommy Z called Ms. Flake, or Ms. Flake called Tommy Z to order 200 t-shirts.
And what about a deposit? Isn't it good business practice to require some kind of a deposit payment before they incur the cost of doing 200 shirts?
Well, Your Honor, this transaction was a simple pay, pick up, and go transaction, so no deposit was needed, Your Honor. To conclude, Your Honor, as such, the legislature demonstrated a public policy not to protect minors from lawfully negotiated contract. Therefore, I respectfully request that this court reverse the Superior Court's decision because the best common law rule for the Virgin Islands is to allow minors to be bound by their contract and must pay restitution to the seller. Thank you.
Thank you.
All right.
Okay, I have a power problem. I'm gonna have to plug my, iPad in.
Okay,
I should have-
that's fine.
I
This
have
is a
everything here I
convenient
need.
time to do that while we're transitioning here. That team also had an alternate. Diego Ken was the third member of that team. He obviously doesn't get to argue today, but we do want to recognize his participation. I will move St. Peter and Paul back to the waiting room and bring in St. Croix Central High School. All right, St. Croix Central, are you hearing me?
Yes, we are.
All right. We are in the process of Judge Roth needs to get her iPad plugged in, and we're taking a little bit for that before we start doing the notices of appearance.
Thank you.
Just as a reminder, please take pictures today and be sure to email them to Rob and include the names of the people in the pictures. And please email them before 5 p.m. because that's our deadline to get them to the press.
Will do.
Okay, and good afternoon, St. Croix Central. I am the timekeeper, so make sure you can see me.
I can clearly.
I usually ask my grandsons to do things like that.
That's why minors should be held accountable.
Right? I hand most of it to my goddaughter. Anytime there's technology I don't understand, I hand it to the 11-year-old in the room. All right, we all set, Judge Roth, or do you still need some time?
Well, you don't get as much of me as good light, but I think for this argument and then after lunch, I can rearrange things a little better.
All right then. If we could get St. Croix to put their notices of appearance on the record, please.
Good afternoon, Your Honors. My name is Bernice Burley. My first name is spelled B-R-Y N-I-C-E. My last name is spelled B-E-R-L-E-Y. I attend the St. Croix Central High School, and today I will be addressing the First Amendment issue on behalf of the appellee, Ms. Tracy Flick.
All right, Ms. Cornelius.
Good afternoon, Your Honors. My name is Leah Cornelius. My first name is spelled L-E-A. My last name is spelled C-O-R-N-E-L-I-U-S. I attend the St. Croix Central High School, and today I will be addressing the question of contract liability on behalf of Tracy Flick.
All right. Ms. Burley. All right, when you begin speaking, your time will commence.
Madam Chief Justice, and may it please the court. This case is about the awesome power of free speech in our American public schools. Courts have long recognized the comprehensive authority that teachers and other public school officials have over their students. But this power is not limitless. The First Amendment guarantee of the right to free speech extends to students in public schools. And although that right is not automatically equal to the rights of adults in other settings, schools must balance the right to exercise free speech against the need to maintain an appropriate school environment. A school exceeds its authority when it fails to demonstrate two things. First, that the prohibitions against speech are based on a showing that that speech substantially disrupts the school, or second, that the speech is reasonably expected to cause substantial disruption in school. Because the Department of Education, St. Croix North High School, and its principals have exceeded that same authority, we ask this court to affirm the decision of the Superior Court and find that the school did violate Tracy Flick's First Amendment rights.
Attorney Burley, the school officials contend that your client's conduct disrupted classes, not just her own class, but other classes, and as it was planned for over 2 days. Do you consider that to be the kind of disruption that would put limits on the First Amendment rights?
Chief Justice Rutland, Tracy's conduct did not cause a substantial disruption or threaten the rights of others. Tracy's conduct was a matter of pure speech, and pure speech receives comprehensive protection under the First Amendment. And she specifically chose this class, her AP Government and Civics class, to engage in this certain conduct. Because an AP Government and Civics class is a discussion-based class. Where students
But the teacher indicated that he was not able to complete his lesson plan for that day, and other teachers experienced similar problems, even in the government class.
Yes, Your Honor. While Mr. Keaton was frazzled and wasn't able to complete a part of his lesson plan, he still did not express any disappointment in the students' protest led during his class, nor did the other teachers of the St. Croix North High School took the authoritative right to discipline their students. Your Honors, whether you are a student, a teacher, or even a principal, we all engage in outside classroom discussions. These were just mere rumblings, and these rumblings are compared to the students and teachers of JS, where the Third Circuit found that the school violated students' First Amendment rights when it suspended them from making off-campus offensive speech about their principal.
But aren't we talking about on-campus speech now in view of the fact that we have virtual school attendance?
Your Honors, this occurred, yes, while this may have been a virtual setting, this is still considered on-campus speech. But teachers or principals do not have absolute authority over their students. They cannot limit students' free speech. Students have the right to express their general and concerns on public matters because the classroom is where students are exposed to a wide range of ideas. Simply put, Your Honors, this is the foundation of an American democracy.
Attorney Burley, did the court just understand you to say that teachers have no right to disrupt a student's First Amendment right? Did I hear you correctly?
Justice Mead, students do have the comprehensive protection under the First Amendment because what they did is pure speech. Yes, schools do have the authoritative right to discipline their students if that conduct engages in a substantial disruption. However, in this case, Tracy's conduct did not substantially disrupt the school or threaten the rights of others.
Well, if one teacher was only able to implement 25% of his plan and other classes were not able to do that, would you consider it a substantive disruption of the educational process?
No, Your Honors, because Tracy's intentions weren't for the other classes to be disrupted. She wanted this protest to be a class discussion held in her AP Government and Civics class. Tracy's conduct was a silent, passive political protest, which is protected by Tinker. And Tinker held that a school violates a student's First Amendment rights when he or she engages in a silent, passive political protest on school property. The special interest of the school allows it to prohibit certain expressions, but, Your Honors, that authority cannot be based on a mere desire to avoid an uncomfortable viewpoint, or it cannot be a remote fear. In the eyes of Principal Rooney and Vice Principal Brennan, Tracy Flick symbolized a threat that needed to be eliminated.
So you're saying that the punishment fed out to Miss Flick was draconian, and it was based on some personal animus that the principal and the assistant principal had for her?
Yes, Your Honors. On page 4 of the record, Principal Rooney and Vice Principal Brennan uses the kind of language that evidences a clear attempt to target, to censor, and to punish Ms. Flick for her unpopular beliefs, while they ignore the other students who are truly involved in the protests. Principal Rooney states, "I don't trust this kid any further than I can throw her." What is so dangerous about a character like Tracy Flick is that she gives good kids bad ideas. The last thing I need at this point in my career is 1,500 Tracy Flick disciples running around these halls. Not 100, 1,500 disciples. And Vice Principal
Attorney Burley. So what do you think should have been done instead, that would not, by the school, that would not have violated your client's rights, First Amendment rights?
Your Honors, instead of taking to the drastic measures of expelling Tracy Flick, the school or Mr. Keating himself could have simply instructed Tracy to return back into her proper school uniform. However, Mr. Keating did not express any kind of disappointment, which shows that he accepted this protest, and it was just, Tracy's intentions were just to have a class discussion. Vice Principal Brennan says, "I agree. When you mess with the bull, you get the horns. I think we should expel her." Your Honors, this threat that the principals of St. Clair picture for Tracy was not Tracy's true character. Tracy, as a matter of fact, was the best of the best, the cream of the crop. Page 2 of the record evidently describes Tracy's character holding high aspirations to become the first female governor of the USVI, and she represents her school's swimming team, moot court, student government, and chess club.
But yet, the message that she put on the T-shirts, although it didn't specifically use any obscene words, were not the large lettering F-U-U understood by her classmates to be referring to an obscenity?
Your Honors, Tracy Flick's protest shirt simply stated, "Forget UT." Forget UT. Tracy did not, her speech was not lewd, vulgar, indecent, or offensive. She just
But didn't it emphasize F-U, which is interpreted by many school kids and people of greater age as being an obscenity?
No, Your Honors. It just like what I said before, it simply stated, "Forget UT." Even if it said FU, it still was not profane or disruptive this school. Your Honors, Ms. Flick has a passion for community outreach and organization, where she demonstrates this passion in her AP Government and Civics class and her silent, passive political protest against T. So, how can Tracy give good students bad ideas when she possesses the qualities of an ambitious, model student?
What would you change from the Superior Court ruling? Is there anything that you disagree with on the Superior Court's ruling, even though it was in your favor?
Your Honors, I do not disagree with the Superior Court's ruling because Tracy's conduct is protected by the First Amendment, and the First Amendment states, "Congress shall make no law abridging to the freedom of speech." So in this case, the school did violate Tracy Flick's First Amendment rights when they expelled her from St. Clair North High School. Your Honor, see that my time has expired. May I conclude?
Just conclude briefly.
Your Honors, students receive comprehensive protection under the First Amendment. And this is why we ask this court to affirm the decision of the Superior Court and find that the Department of Education, St. Croix North High School, and its principals did violate Tracy Flick's fundamental right to free speech. Thank you.
Thank you.
All right, Ms. Cornelius, while the judges are scoring, please come up and be prepared. Okay.
Okay.
All right, Ms. Cornelius, when you begin speaking, your time will commence.
Chief Justice, and may it please the court. Virgin Islands law is clear. Under Title 16, Section 261, persons ages 18 years of age or older, unless emancipated, have total control over their actions and the liabilities they may assume. This law may apply to anyone that has reached the age of majority, the age of 18 years old, but it does not eliminate the protections intended to shield former minors from any mistakes that they've made. This is because minors can't enter into legally binding agreements unless otherwise provided by law. Locally, there is no law that protects the rights of former minors once they've entered into contracts. As a result, we ask this court to extend protections implicit under the Virgin Islands law and find that people like Tracy Flick may be able to disaffirm her contract. We ask this court to affirm this decision of the lower court for two reasons. First, Ms. Flick made no affirmative steps on the contract and received no benefit from it, so she should be able to avoid it. Secondly, Ms. Flick, as an unemancipated
Cornelius, didn't she in fact place an order for 200 t-shirts and then decided not to pick them up?
Your Honor, you are correct. On April 13th, Ms. Tracy Flick did inquire to Mr. Tommy Z about 200 protest shirts.
Was it just an inquiry?
Your Honor, we can understand that there was an agreement, but the record is silent as to whether it was written or oral. We can infer.
Does it matter? Does it matter whether it's written or oral?
Your Honor,
oral contracts as well as written contracts?
It does not matter, Your Honor. Absolutely not. Ms. Flick, at the time that she entered into this agreement with Mr. Tommy Z, was 17 years old. She was under the age of majority, so she had no legal capacity to enter into any agreement with Mr. Tommy Z. Secondly, as an unemancipated minor, Ms. Flick lacked the capacity to enter into any agreement without her parents' consent. Because Ms. Flick made no affirmative steps on the contract and didn't receive any benefit from it, she should be able to avoid it. Sections 221 and 261 of Title 16 determines what persons at what age assume responsibility for their business decisions and any other related liability. Together, these provisions allow for anyone 18 years of age or older, unless emancipated, to enter into legally binding agreements. Penn explains that Section 2...
Some would argue that Ms. Flick had the maturity to enter into a contract, if you will, based on her numerous activities in the school, her leadership roles, and the fact that she can organize this kind of protest. Should the court consider any factors to determine whether a minor has a maturity to enter into a contract?
Your Honor, whether we find that a minor may be mature or not, the law still stands. The age of majority is 18 years old, and at at the time this contract was entered into by Ms. Flick, she was 17 years old. So she cannot.
You're saying the court should just machistically apply the dictate of Title 16, 261, that the age of majority is 18 without looking at any other factors, and that would be the best rule for the Virgin Islands?
Your Honor, we can look at banks. We can look at the banks has 3 factors that we can look at. First, whether any Virgin Islands courts have previously adopted this particular rule. Second, whether any positions taken by majority of courts from other states and territories, and which approach best represents the Virgin Islands. And in this case, the best rule for the Virgin Islands is the rule adopted by the Superior Court to find that Ms. Tracy Flick may be able to disaffirm her contract with Mr. Tommy V.
Why is that the best rule? Why is that the best rule for the Virgin Islands?
That's an attorney made.
I'm sorry. Yeah,
I'm sorry, Judge made.
Yeah, it's okay. Attorney Cornelius, why is that the best rule for the Virgin Islands?
Your Honor, this is the best rule for the Virgin Islands because minors are supposed to be protected under the law by the infancy doctrine, which protects minors from harmful and unfair terms, Your Honor. In this case, Ms. Flick was entered into a contract that was unfair and harmful. She was a high school senior, Your Honors. She was getting ready for prom, filling out college applications. She was evidently going to college, Your Honor. She wanted to be the first governor of the Virgin Islands. She entered into an agreement with Mr. Tommy Z on April 13, 2020, and made no other objectively affirming steps on this.
If we look at precedent from other jurisdictions, are there not a number of states that recognize that someone who has almost reached majority, who shows understanding of what they're doing, and who induces the other person in the bargain to take steps which cost him, that minor should be held responsible for the liability caused? Shouldn't we pay some attention to those other authorities?
Your Honor, the law still stands. The age of majority is 18 years old. Whether you enter into a contract at 17 or 16 or 15, it cannot be legally enforceable. Ms. Flick was a high school senior getting ready for all of these activities. Senior activities, Your Honor, who does not want to participate in their senior activities? Mr. Tommy Z was evidently asked to create 200 protest shirts. Let's say these protest shirts are $15 each. That's $3,000, Your Honor. $3,000.
And look at poor Mr. Tommy Z.
Could you repeat your question, Justice Roth?
I was just wondering, should we not consider the plight of poor Tommy Z, who is left with $3,000 worth of T-shirts that are now absolutely worthless to him? Is that not an injustice that has been imposed upon him?
Your Honors, we understand Tommy Z's position, but as a fair-dealing businessman, he has a legal obligation. He has the right to protect his own business, which he did not. As a business owner, he is supposed to ask for some kind of security deposit towards these 200 protest shirts, which he did not. He was supposed to ask for some sort of identification that would prove that Ms. Flick was not a minor and that she could pay for these 200 protest shirts, which he did not. Your Honors, on Tommy Z's part, this was just pure negligence. Whether Tracy Flick had asked for these t-shirts, she cannot be held liable because she was a minor. The Virgin Islands Attorney General explained that minors under the care of their parents must obtain parents' consent prior to receiving certain third-party services. Your Honors, I see my time has expired. May I conclude?
You may conclude briefly.
Thank you. Your Honors, whether buying fabric from DVDV on St. Croix, purchasing items from Walgreens on St. Thomas, or getting items from the Mega Mall in the Third Circuit, the majority rule still applies. And this court should find that my client, Ms. Tracy Flick, should be able to disaffirm her contract with Mr. Tommy Z. Thank you.
Thank you.
All right, we are coming, that was our last argument before lunch.
Oh my gosh.
I want to acknowledge Angelina Springer is the alternate for St. Croix Central Appellees. She participated in the program, but she did not get to argue today. With that, we will take our half-hour lunch, and we will be back here at 1:45 to start promptly. Judges, please have your law clerks and judicial secretaries email the score sheets as the interim so Rob and I can start tallying for the day. All right, we'll see everyone back here in a half hour. That, St. Croix Central, are you ready to begin?
Yes, we are.
Awesome. Can we get your notices of appearance on the record, please?
Yeah, I'm doing a moot court.
Okay.
Good afternoon, Your Honors. My name is Carmen D. Pickering. My first name is spelled C-A-R-M-I-N-D-Y, and my last name is spelled P-I-C-K-E-R-I-N-G. I attend the St. Croix Central High School and will be addressing the First Amendment issues on behalf of the Department of Education, St. Croix North High School, its principal and assistant principal. Good afternoon, Your Honors. My name is Yuna Alexander. My first name is spelled U-N-A. My last name is spelled A-L-E-X-A-N-D-E-R. I attend the St. Croix Central High School and will be addressing the issue of contract liability on behalf of Tommy Z.
All right, just a second while I move everyone into their waiting rooms. Adrena Scott Elliott, are you associated with the school?
I know Arjuna Scott Elliott is associated with All Saints School.
Okay. Okay, then we don't have to worry because they're done competing. I'm trying to think. So if I'm right, we have, I don't see Eudora Ken online. I don't see St. Peter and Paul online, I think. Or, well, maybe not, or Seventh Day. So I believe that there is no school currently in here. All right, then.
Well, the DNF is Antilles, right?
Yes, I had moved them into the waiting room. Are they in here? Oh, shoot, it didn't work. All right, thank you for that. All right, then the 3 schools that should be in the waiting room are in. Sorry, judges. Are you ready? Now that I've wasted so much time, I apologize.
Yes.
Yes.
All right then. Ms. Pickering, your time begins when you begin speaking.
Madam Chief Justice, and may it please the court. The U.S. Supreme Court has long held that students do not share their constitutional right to free speech at the schoolhouse gate. But the court also recognizes the special characteristics of schools to instruct and provide students with a safe, orderly environment, which authorizes them to regulate student speech. While students are entitled to a significant amount of First Amendment protection, schools still have considerable freedom to discipline students for conduct that may otherwise be protected. In order for a school to rightfully regulate student speech, it must show that that speech materially and substantially interferes with the operation of the school, or that they had reason to predict that the speech would materially disrupt the school. Because the teachers and administration of St. Clair High School had evidence to show that the actions of Ms. Flick satisfied both tests, we ask this court to reverse the decision of the lower court and find that there was no violation of Ms. Flick's First Amendment rights. Tinker held that
In this case, did the speech that that was challenged here, was that occurring on the school grounds and on the school campus? And can it be compared to the Mahoney case versus BL?
Your Honor, thanks to Mahoney, virtual learning is categorized as a school-related activity and also counts as on campus, meaning that the school can regulate student speech during virtual learning. Tinker held that a school violates students' First Amendment rights when it suspends them for conducting a peaceful demonstration. However,
Attorney Pickering, wasn't Ms. Flick's protest a peaceful protest? Am I occurring?
Your Honor, Tracy Flick's protest went beyond the peaceful demonstration around Tinker.
How so?
Your Honor, put yourselves in Mr. Keating's position. Imagine waking up, ready to start your day as an AP Civics and Government educator, only to find that not one, not two, not even 3, but all 25 of your students are out of school uniform and wearing t-shirts with the words FUT emblazoned on them. FUT! And we all know what that means.
No, I don't. What does it? Okay, forget it.
Wait.
Your Honor, Your Honor, the meaning of those words are too profane for me to repeat them for you today.
The court understands, but doesn't the Supreme Court indicate that sometimes language which may seem offensive is protected by the First Amendment? Or did the court make a distinction between when the language is used by a minor and when it is used by an adult?
Your Honor, a speech cannot be used if it is vulgar, indecent, offensive, or supports any form of drug use, or even showing a misleading message of the school. While Ms. Flick did engage in pure speech, she engaged in pure speech combined with offensive words that can be conjured up as profanity. The Supreme Court also found that the special characteristics of a school allowed to prohibit specific expressions. Tinker found that the black armbands worn by students to prescribe a protest for the Vietnam War consisted of pure political speech. speech, however, did not interfere with the work of other students or violate the school's uniform policy.
But how was there disruption here? Didn't the class proceed with the teacher teaching?
Your Honor, Ms. Flick's protest interfered with Mr. Keeling's lesson plan. He was only able to complete 25% of his lesson plan for 2 consecutive days.
But was it not acceptable for him to realize that a more important teaching lesson had come up, the use of free speech and the impact of free speech, and this time certainly wasn't wasted. It was used by him in constructive discussion with the class about the issues before the school.
Your Honor, while this is an AP Civics and Government class, and while it can be categorized as a discussion-based class, in the perfect environment for Ms. Flick to bring her protest. She did not ask for permission, and she left her teacher frazzled and continued to infringe on the educational rights of her peers.
And how did she infringe on the rights of her peers?
Ms. Flick held 24 of her classmates victim to her peer pressure, and she ultimately allowed for them to wear this t-shirt in other classrooms, which caused discussion. Page 3 of the record shows that Ms. Flick talked to her students and other classmates during school hours via TikTok, expressing...
Didn't they enthusiastically join in? They weren't being forced to do anything.
Your Honor, as Ms. Flick is a part of Moot Court, along with other extracurricular activities, and also plans to become the first female governor of the U.S. Virgin Islands, we understand that a trait of young leaders is manipulation. Ms. Flick is a master manipulator, and she held these other students victim to her peer pressure, allowing them to engage...
Do manipulators have less free speech than other citizens?
No, Your Honor. That is not what I'm saying. My clients encourage and want students to express their values of public concerns. However, a substantial disruption cannot be tolerated. This is not the environment for which they can understand how words can affect their peers and the teachers of the school.
How would you characterize the disturbance or the disruption caused by the wearing of the t-shirts? Was it minor, major?
Your Honor, I categorize this protest as a major interference. It not only disturbed one classroom, but several others. Ms. Flick knew of this because she initially planned to order 200 protest t-shirts. Your Honor,
But that did not occur. Instead of 200 protesters, there were 25.
yes, yeah.
So that's a substantially lesser amount than the 200. How does the disturbance here compare to that in Tinker?
The disturbance here went beyond what is allowed in Tinker, Your Honor. Ms. Flick wore t-shirts that were not a part of her uniform policy and also displayed an implication to profanity. She also decided that instead of using the virtual whiteboard, where she has freedom to express her concerns, she decided to intentionally disturb Mr. Keeling's class. This is a result of her negative influence on her peers.
And how would you suggest? Well, what would you suggest would have been a better way for her to handle her protest or to protest?
Your Honor, like I previously stated, she could have used the virtual whiteboard, but she can freely express her concerns, or even go to the principal and her teacher to ask for permission to bring up this protest during her AP Civics and Government class which is the perfect environment for this discussion.
And do you think this type of protest warranted expulsion? You can answer the question and then conclude.
Thank you, Your Honor. Ms. Flick did deserve to be expelled. She caused a substantial disruption. My clients, as the principal and assistant principal of the St. Clair High School, value their students' concerns, but they cannot and will not tolerate any substantial disruption in their school. And with that being said, we ask this court to reverse the decision of the Superior Court and find that there was no violation of Ms. Flick's First Amendment rights. Thank you.
Thank you.
All right, well, the judges complete their score sheet. Ms. Alexander, please come up and be ready. And just like the morning, give me the all clear, judges, when you're finished with your scoring.
I'm done.
Done. Two.
I'm done.
All right. Ms. Alexander, when you begin speaking, your time will begin to run.
Madam Chief Justice, and may it please the court. When a mature minor contacts a fair dealing business, makes a deal, has the opportunity to cancel the deal the following Monday, Tuesday, Wednesday, Thursday, or even Friday, and does not, we can conclude that the minor has accepted the agreement and should be held liable. This is the essence of the benefit rule. In the absence of a law that addresses a former minor's contractual liability, the benefit rule strikes a perfect balance between minors who want to do business in the marketplace and businesses willing to make that risk. To protect those interests, this court should reverse the decision of the lower court and find that although Ms. Tracy Flick may be allowed to disaffirm from her contract, she should do so and still be held liable for the cost borne by Tommy Z.
But if she was a minor at the time, as she was in this case, does she have the ability to disaffirm something that was voidable? Meaning the contract, because she had no legal capacity according to the law since she was under 18.
Your Honor, we understand that Ms. Flick was a minor, but 6 days after she initiated the agreement, Ms. Flick turned 18. When she turned 18, she let the protections afforded her under Virgin Islands law lapse.
So you're saying that she was entitled to disaffirm the contract before she turned 18, but not after she turned 18?
No, that's not what I'm saying, Your Honor. Ms. Flick was entitled to disaffirm before and after she turned 18. She even had the opportunity to disaffirm the day of initiating the agreement, the 2 days of the protest, Your Honor. She could have disaffirmed the day she got expelled. She could have even disaffirmed the day of her 18th birthday or the day after. In this case,
So, are you saying that by doing nothing, she in fact was taking a positive step to affirm the contract?
Yes, Your Honor. Ms. Flick ratified the agreement. In 1959, the Attorney General's office stated that once a minor executes a contract, that creates an obligation to pay for the value use of the premises. Restatement second, section 14, continues to inform, once a minor comes of age, she must take action to disaffirm. As Engelbert explains, disaffirmance occurs by some clear, unmistakable act. Otherwise, as Bagley makes clear, the contract would be ratified as a matter of law. In this case, Your Honors, Ms. Flick took no affirmative steps to disaffirm on or the day after her 18th birthday, even though she was the one who initiated the agreement, Your Honors. She was the one who designed the shirts, Your Honor. She contacted Tommy Z to have 200 protest shirts made. The record is silent
as to whether Ms. Flick emailed, WhatsApp, used Facebook Messenger, texted, or even called Tommy Z before he incurred the time, expense, and energy to make not 10, not 20, but 200 protest shirts.
But did Tommy Z have an obligation to determine who he was doing business with?
Your Honor, he did. Although the record is silent as to whether Tommy Z asked for an ID or even asked for a deposit, we can conclude that because Tommy Z was able to contact Ms. Flick's parents, he had some sort of insurance on Ms. Flick. Therefore, this court can conclude that Ms. Flick ratified the agreement and became liable to Tommy Z. Even if this court believes Ms. Flick disaffirmed within a reasonable time, it should adopt the benefit rule as a matter of sound public policy and hold her liable for any costs borne by Tommy Z. Porter explains that businesses should be able to recover any benefit conferred upon a former minor seeking to avoid a contract. Though not the majority rule, the benefit rule preserves the right of minors to disaffirm and respects the right of businesses that assume the risk of offering services to the public at large. The benefit rule aligns
What about the rule of necessity? What about the rule of necessity? Was this a necessary or would the goods be considered necessity of necessity?
Your Honor, these were not goods of necessity. Ms. Flick even took the action to go to Kmart and purchase shirts to design her own shirts for her protests. Ms. Flick received the benefit in this case. Your Honor, while it may be questionable whether Ms. Flick's parents attempt to disaffirm the contract with Tommy Z on their daughter's behalf was effective on the day Ms. Flick herself turned 18, one thing is for sure, Tommy Z used his time, materials, and other resources to create 200 protest shirts. If Ms. Flick could take affirmative steps to purchase shirts from another business, could she not take the same steps to contact my client Tommy Z and inform him that she no longer is interested in the shirts? Holding otherwise will discourage businesses from engaging with people in the marketplace. Thank you.
Thank you.
All right. As with other squads, there was an alternate. Aaron Flynn participated in the program, but unfortunately did not get to argue today. And along with in previous rounds, we will let St. Croix Central remain in because they are officially done presenting arguments today, so they can observe. Let me get St. Peter and Paul appellees in the room. Is this St. Peter and Paul? I'm not sure. I know the space is being shared. Yes or no would be helpful.
Yes, this is St. Peter and Paul.
All right. Okay, judges, when you are done scoring, let me know. Done.
I can't see the iron.
Done.
Wait, can you guys see us?
Yes.
Oh, okay.
Oh, Judge Mead, are you ready?
Yes, I'm ready.
All right. So please put your notice of appearance on the record.
Good afternoon. I'm Pierre Joseph. P as in pig. I-E-R-R-E. Joseph. J-O-S-E. P as in pencil. H. The school that I attend is St. Peter Paul Catholic School. The issue that I'll be arguing is whether the Superior Court erred in its findings that St. Paul North High School and its principal and vice principal violated Tracy Flick's First Amendment rights, and I represent the appellee. Good afternoon. I am Diana Esprit. D as in dog, A, Y, A, N, A, E as in elephant, S, P, R, I, T. I attend St. Superior and Paul Catholic School, and I'll be arguing whether the Superior Court was correct when it determined that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability. And I represent the appellee.
All right. Mr. Joseph, when you begin speaking, your time will run.
Good afternoon, Your Honors. May it please the Court. My client, Tracy Flake, strongly believes that the Superior Court was correct in its findings that St. Croix North High School and its principal and vice principal violated her First Amendment rights. Here are the 3 reasons why Ms. Flake is protected under the First Amendment. First, Ms. Flake's speech did not materially and substantially disrupt the education process. Second, Ms. Flake wearing the shirt is seen as a form of free speech, therefore it is protected under the First Amendment. And finally, Ms. Flake did not infringe on the rights of her fellow classmates. First, Ms. Flake's speech did not materially and substantially disrupt the education process because relying in the case of Malinois versus VL, although VL used vulgar language in her speech, the criticism of the team did not include highlights that would put it outside the protection of the First Amendment because her speech occurred outside of school grounds. The Supreme Court concluded that since VL's speech did not identify the school and did not target the school with vulgar or abusive language, her speech could not be considered that she materially and substantially disrupt the education process. The main issue
Attorney Joseph, how can Mahoney be distinguished from this case in terms of the speech that occurred? Where did they occur, and how can you distinguish the cases?
In this matter, on-campus speech and off-campus speech does not have a difference for Ms. Flake, because the main issue is to look at whether the speech of Ms. Flake identified the school or was targeting the school with vulgar or abusive language. And clearly, Your Honor, that did not happen.
So is the fact that the school in your client's case occurred virtual, and that's considered on campus, do you agree?
Yes, Your Honor.
Okay, and the speech in the Mahoney case occurred off campus. Don't you think that that's a significant difference between the cases?
Yes, but also part of the reasons why the favor ruled in BL, because they ruled that since BL's speech did not identify the school and did not target the school with vulgar or abusive language, this is why her speech did not consider as a material and substantial disruption.
But Attorney Joseph, this protest occurred on St. Croix North High School. So it is clear, is it not, that the action was on the school's premises and the teacher did not need to specifically identify the school for any person of common sense to know that the protest was directed at St. Croix North High School. Isn't that true?
Your Honor, may you rephrase that question, please?
Okay. I think you're trying to show a distinction between Mahoney and the case which you're arguing. And you're saying in Mahoney, the incident occurred off campus. Am I correct?
Yes, Your Honor.
And it didn't name the school.
No, Your Honor, it did not name the school.
But in this situation, the protest occurred during virtual learning, which would be considered the school campus. And because it occurred through the virtual learning process, and it occurred while Ms. Flick was being lectured in a civic class, does one need to identify the school to conclude that the protest was directed at St. Croix North High School? Is it?
No, Your Honor. No, Your Honor, because relying on the case of Cohen versus California, Cohen wore a jacket that said F the draft, and the people in the courthouse believed that he was causing a material and substantial disruption. But that was not the case because the Supreme Court concluded that since Cohen had not engaged in any act of violence, did not make any loud or disruptive noises, and did not consist fighting words that were directed toward them, that is why he did not materially and substantially cause a disruption. And for Ms. Blake, she was even though the school were the only ones that were able to see that message, it should not, since that Cohen, in the case of Cohen, the rule in Cohen's favor, this is why for Ms. Blake, it should be also ruled in Ms. Blake's favor. Because since she did not
But Ms. Blake's teacher was only able to complete 25% of his lesson plan for two days. Wasn't that a disruption of the school, disruption of the class presentations at the school?
Yes, Your Honor, that is true. But that should be considered as a minor disruption instead of a substantial disruption. Because if we can compare the disruption TEA has caused and the disruption Ms. Blake has caused, is nowhere near to the level where what TEA has done. Before this silent protest occurred, in a span of 3 weeks, there has been power outages 2 times a week, with it lasting 45 minutes to an hour, which infringes on Ms. Blake's education process. Not only hers, but other students. So, and to compare to the disruption Ms. Blake has caused, this is why Ms. Blake's action should be seen as a minor disruption, not a substantial disruption, Your Honor.
So what should you have done instead if you believe it violated your client's rights?
Your Honor, before getting to expulsion, there are many disciplinary acts that could have been taken. For example, a warning can be sufficient enough because my client had good intentions, and if she succeeded with the intention, it would have benefited the school and brought their attention to the school to join Ms. Blake and try to resolve the issue that many students are facing because their education were being infringed upon by TEA. Second, Ms. Blake emphasizing her First Amendment right when she wore the shirt during school to express her feelings on TEA. Relying on the case of Tinker and her friends were also emphasizing their First Amendment rights during school by wearing clothing to portray their personal message on the Vietnam War. The Supreme Court concluded that the wearing of armbands is seen as a form of free speech and decided it was therefore protected under the First Amendment, which should not be restricted. The case of Tinker applies to Ms. Blake because Ms. Blake used clothing as a form of free speech to portray her message on TEA, and to expel her for this action is compelling evidence that her First Amendment rights were violated.
Well, would you compare an armband in the Tinker case with the T-shirt that said, "Forget you, T, you suck"?
Yes, Your Honor, because both of these are considered as clothing, Your Honor. And since they rule that clothing is a form of pure speech, this is why it should also apply to Ms. Blake, because Ms. Blake was using clothing as a form of free speech. And
this wasn't just bare clothing. This wasn't just bare clothing. This was clothing with a message that was deemed offensive.
Well, Your Honor, also, in the case of Cohen versus California, keep in mind, Cohen also wore a jacket that said "F the draft" that contained vulgar language. But yet, the Supreme Court concluded that all what he tried to do was portray his expressions on the Vietnam War and made it and ruled that he was still protected under the First Amendment.
But that was not in a school. Does a student have that same right? Is an absolute right to free speech?
Can you rephrase that question, please, Your Honor?
Does your client have an absolute right to free speech?
No, Your Honor, but it is the conduct that she has caused is the reason why there was no need for them to expel her, Your Honor. Finally, Ms. Blake did not infringe upon her fellow classmates because 24 other students decided to wear the shirts themselves because they felt that TA was causing an infringement on their education. These are students who really care about their education and feel that they are in need in doing this silent protest for how unreliable TA has been. Also, the disruption occurred during their AP government class, which means it didn't cause an infringement on their education because the matter of this situation relates to an AP government class. What the teacher could have done It's added lessons they gained from AP government class into a real-life situation that these students are facing. Instead of questioning whether Ms. Flick caused an infringement on her fellow classmates, we should view it as Ms. Flick made the class more fascinating in light of the fact that it got more students invested in the discussion they had.
Yeah, but attorney, what about the other classes that were disrupted? Forget the civic class. What about the other classes that were disrupted? Was there actually a benefit to those students who were in those classes?
Your Honor, as I stated previously, that disruption in the other subjects should be considered as a minor disruption, not a substantial disruption. Because if we compare to what TA has done and to what Ms. Flick has done, Ms. Flick action was nowhere near to the level of TA. Because in a span of 3 weeks, having a power outages 2 times a week with it lasting 45 minutes to an hour, that is a lot of class time that students are missing. To conclude, Your Honors, Ms. Flick's speech is protected by the First Amendment because my client's speech did not materially and substantially disrupt the education process. The shirt is seen as a form of free speech, and she did not infringe on her. Your Honor, I've seen that my time is up. May I have leave of court to finish my conclusion? You may conclude. She did not infringe on the rights of her fellow classmates. Therefore, the punishment was impermissible. I respectfully ask that the Supreme Court should affirm the ruling of the Superior Court that St. Croix North High School and its principal and vice principal violated Tracy Flick's First Amendment rights. Thank you.
Thank you.
Thank you.
May I note as a matter of judicial record that Katanji Brown Jackson was just confirmed.
Yes, I just made an announcement. We have the first black female U.S. Supreme Court justice as of now, and only the third African American to be appointed to the U.S. Supreme Court in history.
Thank you for that, Judge Jones.
I got to know her well down here in Washington, and I think it's a great appointment.
All right, judges, let me know when you are finished.
Finished.
Done.
Finished.
All right, Mrs. Free, your time will begin to run when you begin speaking.
Good afternoon, Your Honors. May it please the Court. Your Honors, the Superior Court was correct when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability for the following 3 reasons. First, it protects minors from entering into contracts with responsibilities and obligations that they may not understand. Second, it gives minors a chance to affirm or disaffirm any contract after reaching the age of majority, and in this case, Ms. Flick disaffirmed the contract. Third, it protects minors from being held liable for benefits they have not received, and in this case, Ms. Flick received no benefits from the contract. Your Honors, it says in the restatement, second of contract, sections 12, that no one can be bound by contract who has no legal capacity to incur at least voidable contractual duties. Ms. Tracy Flick was only 17 years old, a minor at the time of the establishment of the T-shirt contract on April 13, 2020.
But Attorney Smith, forgive me for interrupting you, but from the record, even though chronologically Ms. Flick had not attained the age of majority, that being 18, when she entered into the contract, mentally, wasn't she mature enough to know and fully understand what she was doing based on the extent of her extracurricular activities? She was an honorary student. She's extremely mentally mature.
Yes, Your Honor. She may have been a mature student, but she is a minor at the age of 17 years old. And a minor cannot affirm or disaffirm the contract until they has reached the age of majority. Ms. Flick contacted Tommy Z via phone, and Tommy Z acted oblivious and never sent out an email or text message to verify if she reached the age of majority or not. And as an experienced business owner, he should have asked for a deposit for such a large amount of t-shirts being made. Your Honors, as ruled in the case Engelberg versus Truck Sale, contracts made by minors for items other than necessities are avoidable and may be disaffirmed when the minor comes of age. In this case, the t-shirt was not a necessity because it was for a protest, it was for an activity, and she wasn't in dire need of it. Your Honors, in a similar case, the Bodley versus Mombasa case, where the plaintiff, after reaching the age of majority, exploded his key pass 119 times, which therefore affirmed the contract he made with the defendant when he was a minor. In this case, Ms. Flick, after reaching the age of majority, never received or contacted about the t-shirts, therefore disaffirming the contract. Your Honors, as stated in 16 Virgin Islands Code Section 265.
Don't you think as a mature young lady, ambitious individual, very excellent student, very active in school activities, don't you think she should have made contact with Tommy Z and at least disaffirm or at least inform him that she was no longer interested in making the purchase?
No, Your Honor, because at the time she was a minor, she had no legal obligation to do so, Your Honor. You can only
She didn't have a legal obligation to make the request either, and she made the request for the 200 shirts.
Well, Your Honor, she had a legal obligation, Your Honor, because she had no legal obligation, Your Honor, because she was a minor at the time of the contract, and therefore, since she was a minor, the contract was void, Your Honor. Your Honors, as stated in 16 Virgin Islands Code Section 261, that all persons are deemed to have arrived at the age of majority at 18 years, and thereafter shall have full control of their actions. Ms. Flick, after reaching the age of majority, had full control of whether to go pick up the t-shirts or not, but she couldn't due to lack of reasonable time. Your Honors, in another similar case, which is the Porter versus Wilson, it was ruled that a minor may disaffirm their contract and is not liable for benefits they have not received. Your Honor, Ms. Flick did not receive any type of benefits from the contract. She never received or contacted Tommy Z about the t-shirts, Your Honor, therefore disaffirming the contract.
The contract, the reason why she didn't, the t-shirts, wasn't that the reason why she didn't get any benefit from it?
Yes, Your Honor. She didn't get any benefits from the contract. The t-shirts are still in Tommy Z's possession, Your Honor.
But Tommy Z is stuck with 200 t-shirts that he can't sell. He's out a lot of money. She's out nothing. Shouldn't we consider those equities in making our decision in this case?
Well, Your Honor, that is his irresponsibleness as an experienced business owner. He should have secured a deposit to ensure if he was going to be compensated, Your Honor. And he, in fact, could resell the t-shirts because these t-shirts was for a protest that was for a situation that was occurring island-wide. So he didn't suffer any loss, Your Honor. Your Honor,
You could have sold the t-shirt to other schools that when students experience the same problem. Is that your argument, counsel?
well, Your Honor, he could have, yes, Your Honor, he could have, because it was an island-wide issue that was happening around the island, and he could have resold it to other people that was joining in the protest also.
Okay.
Yes, Your Honor.
So he could have mitigated his losses then?
Yes, Your Honor, he could have, yeah. Your Honors, this rule has been established to protect younger individuals who may not fully grasp the consequences of certain contracts. To conclude, Ms. Flick never showed up to the set pickup date and never contacted Tommy Z about the t-shirt, therefore disaffirming the contract. And this is the best common law rule because it protects minors from being taken advantage of and being deceived, and it protects them from entering into contracts with responsibilities and obligations that they may not be able to uphold or understand.
Thank you.
Thank you.
Thank you.
All right. Let me get Antilles appellee. Oh yeah, there is a slight change in what you're seeing. Instead of Antilles appellants right now, you'll be seeing Antilles appellees. And St. Peter and Paul, they are entitled to remain watching because they will not be competing any longer. Just a question. I know this is being shared with St. Thomas Seventh Day. Who will be in this room going forward? Do I need to move this into the waiting room? I suspect no one's in the room then. So I'm going to do that. All right. Judges? I'm through.
I'm finished.
All right. Please put your notices of appearance on the record.
Who are we dealing with?
It's still Antilles, but it's the appellees, not the appellants.
Okay.
All right. Please put your notices on the record.
Good afternoon, Your Honors. My name is Kashish Chinani. Kashish. Chinani. Chaini. And I'm from Antilles School. I represent the appellee, Tracy Flick, and I'll be addressing issue 1, whether the Superior Court erred in its finding that St. Croix North High School violated Ms. Flick's First Amendment rights.
Good afternoon, Your Honors. My name is Aisha Kimani. A-I-S-H-A Kimani. K-H-E-M-A-N-I. I'm from Antilles School. I'll be representing the appellee, Tracy Flick. I'll be addressing issue 2, whether or not the Superior Court erred when it determined that the best rule for the Virgin Islands was to allow minors to discipline their conflicts and avoid liabilities. Thank you.
All right, judges, you're all ready?
Yes.
Yes.
All right. As soon as you begin speaking, your time will commence.
Good afternoon, Your Honors. May it please the Court. Our position is that the lower court was correct when it found that Ms. Flick's First Amendment rights were violated when St. Croix North High School expelled her. The judgment of the Superior Court should be affirmed for 4 reasons. 1, the expression is protected because it's considered symbolized speech. 2, it was not substantially disruptive to the learning environment. 3, the language on the shirts was not vulgar. And 4, fear is not sufficient to take away someone's First Amendment rights. With the switch to virtual learning following the COVID-19 pandemic, Tracy Flick, along with many other students, got extremely frustrated with the unreliability of TEA. The students made their own t-shirts outside of school and outside of school hours without violence or profanity on it for her and other students to wear while they were off campus at home to voice their opinions against TEA.
Did you say while they were off campus?
Yes, Your Honor. The students...
Because of the virtual learning environment, would not the area where your camp was considered campus, a part of the campus?
No, Your Honor. It's our position that the students were off campus because they were still at home and under the supervision of their parents.
Okay.
Moving on to my first argument, the expression is protected because it's considered symbolized speech. In Tinker, the United States Supreme Court said that symbolized speech is protected by the First Amendment. The court also held that students don't lose their First Amendment rights while in school. In Tinker, the students wore wristbands to show their opposition to the Vietnam War. The court determined that articles of clothing are considered symbolized speech. So similar to our case, Tracy Flick and the other students wore t-shirts to show their opposition to TEA. In both cases,
Attorney Shanani, is the clothing in this case the same as the clothing and armband in the Tinker case? Is it comparable?
Yes, Your Honor, a t-shirt and armbands are both considered articles of clothing, therefore symbolize speech.
However, in this case, the T-shirt had writing on it that said, "Forget you, T, you suck."
Yes, Your Honor, the writing will still be considered written speech, and written speech is still protected under the First Amendment.
But it was written speech that could be interpreted as obscene, right?
No, Your Honor, it's our position that the speech was not vulgar. The students were just trying to peacefully voice their opinions and bring awareness to the big, substantial disruption that was being brought to their education by TEA.
But if you asked a group of high school students, what does FU mean? I won't reply what their answer would be, but I think we all know what it would be.
Your Honor, the shirt just said, "Forget you, TEA, you suck." This did not imply any vulgarity. It was just peacefully bringing awareness to the fact that TEA was being very destructive. The students were losing at least a whole school day every month because of TEA. And bringing this awareness to the school was very important for the students because the school is reliable for the students' education.
And was there another way that this matter could have been brought to the administration's attention, the school's attention?
No, Your Honor, it's our position that the students did this the right way because they were just simply peacefully wearing a t-shirt over Zoom. They did not engage in any loud or disruptive noise either, and therefore it is protected. If we look at the case Mahanoy, they ruled that schools can only regulate speech in certain situations, and they said that they can only regulate it when it's vulgar speech uttered during a school assembly on school grounds. In our case, the speech was not vulgar, it was not uttered, nor was it on school grounds. Therefore, the school cannot even regulate her speech.
Even if it's disruptive, Attorney Kujani, even if the speech is disruptive, you're saying that the school has no right, no authority to regulate a student's behavior?
Your Honor, the speech was not substantially disruptive. I understand that in Tinker, the court said that if a student's conduct was not substantially disruptive, it is still protected by the First Amendment. The students were just peacefully bringing this awareness to the school, and they were not engaging in any acts that were disruptive to the learning environment.
Well, there's evidence record.
Were they not basically on school property because virtual learning during the pandemic, that is the way that schools presented their programs, and wouldn't we not be correct in interpreting what happened in the virtual class as being on the school property?
Respectfully, no, Your Honor. We agree that she was on virtual learning, but that does not mean that she was on school campus. She was still under the supervision of her parents, which means that she was at home off campus.
But she was supposed to be wearing a school uniform. Was that not supervision by the school?
Yes, Your Honor, she was supposed to be wearing school uniform, but the speech is still protected by her First Amendment right. The courts in Tinker, Mahanoy, and JSD Blue Mountain also said that fear is not sufficient to take away someone's First Amendment rights. They said, and Principal Rooney directly said that Tracy Flick was dangerous to the other students and that he didn't trust her because she gave good kids bad ideas. This is not true because all of them agreed with this issue. All of them made their own t-shirts and all of them wore it. That's why the fear that Principal Rooney used to expel her was unconstitutional and therefore a violation of her First Amendment rights. If we look at JSD Blue Mountain, a student was suspended for creating a mocking internet profile for her principal, which she made on her personal computer. The court still determined that the actions of the minor did not constitute of a substantial disruption immediately or in the future. Similar to that case, Tracy Flick also communicated with her friends on TikTok on her personal device at her own time, and her actions were not disruptive immediately or in the future. Her symbolic speech was not even directed at any school official, while on JS the social media account was directly directed at the principal. Moving on to Cohen v. California, Cohen was wearing a jacket with vulgar language on it in public to show his opposition to the Vietnam War. The Supreme Court ruled that it was a violation of his First Amendment rights because Cohen had not engaged in any acts of violence, did not make any loud or disruptive noises, and his speech did not consist of fighting words directed at any reader. In our case, Tracy
Couldn't the words on the shirt here be considered vulgar and disruptive? And didn't in fact the school find it to be disruptive since the teacher was only able to get through 25% of his lesson plan along with other teachers?
Your Honor, it's our position that it was not disruptive because the teacher still engaged in discussion with the students, and First Amendment rights, constitutional rights, are very relevant to an AP government curriculum, therefore it was not substantially disruptive.
What about the other classes?
Yes, that was question, the other classes.
What about the other classes that were disrupted that were not AP government classes?
That was not substantially disruptive either because it was largely supported by all of the students, and those students were just peacefully bringing this awareness to the court. And if you look at how much the TEA was disrupting it, the students were losing at least a whole school day of class because of TEA's just unreliability, which is why the students voiced their opinions. And in Mahanoy, the court said that public schools have a duty to teach students that freedom of speech is essential to self-government. They also said that students are allowed to express their unpopular opinions even with language that is inappropriate or harmful. In our case, Tracy Flick's actions were neither unpopular, expressed inappropriately, or in a harmful manner, but by the precedent set in Mahanoy should be protected either way.
But couldn't she have requested the teacher's permission to discuss this topic in her class?
Yes, Your Honor, she could have, but the manner in which their issue was peaceful. They weren't being disrupted at all, which is why it is protected by their First Amendment rights.
Well, what aspects of the Superior Court's, the lower court's ruling that you disagree with, even though it ruled in your favor? The ruling was in your favor. Is there any part of that decision that you disagree with, even though the ruling was in your favor?
No, Your Honor, we agree with the lower court's decision, and we respect that you affirmed their decision to allow her to be reinstated and to receive the tutoring services. So, in conclusion, the Moot Superior Court was correct in ruling that Ms. Flick's rights were violated, and we respectfully request that you allow Ms. Flick to be reinstated and to receive the tutoring services. Thank you.
Thank you.
All right, I see the timekeeper froze, so, oh, there she is, all right.
Yeah, and did she have a difficulty? Did you go in and out a bit? Okay.
Somehow she got kicked out. I don't, part of that was my fault, because when I was trying to then do it, but that freezing, like, she was literally holding up the time and it froze mid-display, so I wanted to make sure.
All right, I saw the 30 seconds, but I don't think we saw the time. I'm sorry.
Yeah, it froze where only the very top edge of the paper came up, so. But you did well, very good. All right, judges, let's.
I just wanted to make sure it wasn't my system, my computer.
Nope, all my fault really there. Judges, let me know when you're done with the scoring.
Yeah, I'm finished.
I'm done.
I'm done.
All right, your time will begin when you begin speaking.
May it please the court. Our position is that the lower court was correct in ruling that minors can disaffirm their contracts and avoid liability after reaching the age of majority. This is for 3 reasons. Firstly, Tracy Flick didn't benefit from the agreement. Secondly, the t-shirts are a necessity, thus the contract can be disaffirmed. And lastly, Tracy Flick was 17 at the time that she entered into the contract. The Virgin Islands Code, Title 16, Section 261 states that all persons are minors until they reach the age of 18. We believe the court should apply Section 261 of the code to contracts. On April 13th, 2020.
Why should the court apply that to contract? Didn't the only case that decided by the Supreme Court regarding to relative to the majority, whether or not a minor attained majority, was that case silent as to whether the minor should be held liable for contractual obligation?
Your Honor, while the code is entirely silent on the liability of minors for contracts they make, we're providing this as a point of reference, not as something that's binding on this court, and we believe it should be highly persuasive, as the code mentions the conduct of business.
Okay.
Since there is no definite rule for the subject at hand in the Virgin Islands, the court must conduct a Banks analysis to determine the best rule for the Virgin Islands. A Banks analysis requires the analysis of 3 factors. The first one, how have Virgin Islands courts ruled on the issue? In this case, there is no case law or statute on point. The second, to consider the position taken by a majority of courts from other jurisdictions. And
what is that majority?
The majority is referencing the cases in terms of benefits, Porter versus Wilson from the state of New Hampshire. In terms of necessity, at Kiefer versus Fred Motors from the state of Wisconsin, and Engelbert versus Troxel from the state of
Is that a majority of state decisions, or are those just ones that go the way you would like them to go?
Those are the majority in the cases that we've been provided. The first thing to consider in deciding what is the best rule for the Virgin Islands is whether or not a minor has benefited from the contract. Courts have stated that it's within a minor's rights to disaffirm a contract without consequence as long as they haven't benefited from it.
But attorney, did Ms. Flick did not benefit from this contract?
She never went to pick up the t-shirts from Tommy Z, and so she didn't receive the product. Therefore, wasn't able to use it and didn't receive any benefit.
So she
look at poor Tommy Z. He has 200 T-shirts that he can't sell, and that it's out of his inventory. It's money down the drain. Shouldn't we consider his position?
While we understand it's a sensitive situation, we believe Tommy Z, as a capable adult, should have completed his due diligence on his client to see if she was able to pay for the t-shirts. This could have included things as asking for a credit card number or a deposit. We can't ask this of a minor, but we can definitely ask this of a capable adult. The court should also consider whether the contract was for a necessity. Courts have stated that minors can only be held liable for contracts that are for necessities. The t-shirts were non-essential, therefore Tracy Flick was free to disaffirm her contract with Tommy Z. The court should also consider relevant decisions out of Wisconsin and Nevada.
Isn't that inherently unfair that an individual like your client can disavow a contract that she made, an individual who is experienced, is very intelligent, is very active in student government, has goals to become governor? Shouldn't she learn from now to be responsible and be accountable for her actions?
While it is a sensitive situation, Your Honor, Tracy Flick was still 17 years old, a minor, and while she may have sounded mature, she still hasn't reached the age of majority. We believe the Virgin Islands should provide a safe environment for minors to grow up in, and this means providing them that environment to make mistakes and learn from them. So in terms of necessity, Your Honor, in Kiefer versus Fred Motors, the court held that Kiefer could disaffirm his contract with the car dealership because he was a minor when he purchased the car, and because the car was not a necessity. Additionally, in the case Engelbert versus Troxel from the state of Nevada, the court affirmed that contracts made by minors for items other than necessities are avoidable, and a minor may disaffirm their contracts after they had come of age. In this case, Engelbert attempted to disaffirm the sale of his mother's land once he had reached the age of majority. We argue that you should affirm the Moot Superior Court's decision to protect minors. Lastly, considering that there is no law on point in the Virgin Islands,
before you move on, counsel, if we're going to protect the minors, should their parents be responsible for assuming the debts of the minor?
No, Your Honor, the parents should not be responsible. And this is specifically in our case, Tommy Z had no contact with her parents. And therefore, they did not know about this contract until Tommy Z called them asking for payment. So it's important to note that the Virgin Islands Legislature has enacted VI Code 16, Section 261, which states that at the age of 18, one can be held accountable for their own actions in business. Tracy Flick was a minor at the age of 17 years old when she entered into the agreement with Tommy Z. We believe there is no reason to diverge from the established age of 18, seeing that the statute specifically references the conduct of business. In Bagley versus Mount Bachelor from the Oregon Court of Appeals, Bagley, a 17-year-old, purchased a season pass from Mount Bachelor, which included an agreement that released the ski company from liability if Bagley suffered injuries on the ski slope. Later, when Bagley turned 18, he sued the company after being injured while snowboarding over an artificial drop. In Oregon, a minor may disaffirm a contract within a reasonable time after reaching the age of majority. However, since Bagley had utilized and benefited from the ski pass after his 18th birthday, the court determined that he had affirmed the contract. Here, Tracy Flick didn't receive any benefit from or neither did she utilize the T. Therefore,
that was due to her own choosing. The t-shirts were ready as she ordered. She chose not to pick them up. Isn't that correct?
It is correct, yet she still received no benefit and the t-shirts were still in Tommy Z's possession. Therefore, she is free to disaffirm the contract. Therefore, according to the analysis seen in Bagley, she has every right to disaffirm her contract. A portion of the VI Code is adopted from the Oregon Code, making this case highly persuasive. In conclusion, it is the soundest rule for the Virgin Islands to allow minors to avoid liability and disaffirm their contracts. With that rule in mind, we respectfully request that this court affirm the decision of the lower court and find that Ms. Flick wasn't liable for the contract she entered into at 17 years old as a minor.
Thank you.
Thank you.
All right, I am admitting Charlotte Amalie High School right now. At this point, well, first I want to say that Kayla Bellew was the alternate for Antilles Appellee's team and participated in the program this year along with all of them. To the judges, I was thinking this would be a good time to take a 10-minute break, or would you like to do another round and then take a 10-minute break?
I would prefer to wait around if we could.
Okay.
Okay, all righty.
That works for me then.
Are we, where are we going? Who will be the next?
Next will be Charlotte Amalie High School Appellees is on the schedule.
So is the Antilles Appellants off the schedule?
No, they just got moved to where on yours you'll see Antilles Appellees.
I see, okay.
All right, then we will do that. All right, Charlotte Amalie, please begin getting ready to give your notices of appearance while the judges are finished scoring.
Adam?
Oh, yes. Stephanie is our new timekeeper. Mallory has to leave for the afternoon. So I'll pin her. Thank you, Mallory. Goodbye. Stephanie, please speak. So,
Hi, I will be keeping time.
all right. You should have been able to pin her there so that you see her.
Yes. I see.
All right. Okay, Charlotte High School. Are you ready?
Yes.
All right. Please put your notices of appearance on the record.
Good day, Your Honors, and all in attendance. I am Shade Richardson. That is S H A U D A E, Richardson, RICHARDSON. And I am representing the respondent, Tracy Flick, and I will be addressing the first question on appeal, whether there was a violation of Ms. Flick's First Amendment rights.
Good day, Your Honors, and all in attendance. I am Shania Martin, and that is SHANIA Martin, MARTIN, from the Charlotte Amalia High School. And I am representing the respondent, Tracy Flick, and I will be addressing the second question on appeal.
All right. Judges, are we ready?
Yes, I'm ready.
Ready. All right, your time will begin when you begin speaking.
May it please the court? Your Honors, my client, Tracy Flick, is intimately familiar with disruption. Actual, tangible, substantial disruption. In fact, every student residing in the United States Virgin Islands has experienced some form of upheaval or trauma in the past 5 years. Twin Category 5 hurricanes, the death of a friend, a world-altering pandemic, the TEA interrupting remote learning, and now a clear violation of her First Amendment rights when her entire class was simply expressing themselves and their frustrations in a respectful manner. The Superior Court correctly found a First Amendment violation, and rulings should be affirmed for the following reasons. Point 1. The speech of my client that is actually being punished, which is the idea she presented to her classmates, is off-campus speech. Point 2. No part of Ms. Flick's speech caused or would have caused a significant disruption. And point 3. Even if any part of her speech was considered on campus, a student's rights nor their speech does disappear at the schoolhouse gate.
Well, Attorney Richardson, is your client entitled to absolute First Amendment rights, free speech?
Yes, Your Honor. Any law-abiding citizen residing in the United States under the United States Constitution has the right to freedom of speech under the First Amendment.
So are you saying the school does not have any authority to implement limitations on the free speech, right?
Schools do have the right to limit what students can say and what they can do. But Your Honors, what was happening with the TEA did affect her education. And she has a right to stand up and speak against her frustrations for something that's prohibiting her learning.
Well, Counsel, I think the justices could see it as the must that she has a First Amendment right. However, should that right be so expansive so as to disturb the learning environment and this information of record that the civic teacher was unable to implement 100% of his lesson plan, and other students in other classes were disrupted. So wasn't it, in view of that, wasn't the principal correct in suspending the student?
Your Honors, let's look at Mr. Keating's lesson plan. When Mr. Keating taught the lesson plan and it was interrupted, he addressed the speech on the shirts of his AP students. He was able to teach the whole child and not just to a lesson. He addressed their social and emotional skills rather than the content outlined in the lesson. Now, for the other teachers, it never said that how they had to address the situation going on. They never said what manner was being addressed in, and it never said that it disrupted their lessons. In BL, JS, and Tinker, the armbands, the MySpace page, and the videos were seen as disruptive. Were not seen as disruptive no matter where they occurred. Therefore, the wearing of shirts by my client and her other classmates cannot be seen as disruptive in the same manner.
So your argument is that instead of being disruptive, it actually benefited the student because the civic teacher used the wearing of the t-shirt as an opportunity to discuss matters that are relevant and important to the student as American citizens.
Yes, Your Honors.
Okay.
To my first point, Your Honors, let's address the nature of my client's speech. The facts show that she utilized TikTok, which is a social media platform, primarily used by minors on cellular devices. She was also in her home. This alone shows that my client's communication, unrelated to her coursework in her 4 classes, is off campus. In both
excuse me, Attorney Richardson, didn't your client wear her t-shirts during a class that she was taking on a school-issued computer and a school platform?
Well, Your Honors, hypothetically speaking, let's say that you're on a schooling platform, Teams or Zoom, and you have, let's say, Teams open in one tab, or Zoom, for instance, and Facebook open in the other. You cannot prohibit what my client says in Facebook because it's in a different tab from what she's doing in Zoom.
But we're not talking about a hypothetical here. We're talking about what actually occurred in this case. Was she not on a school-issued platform and school-issued device participating in virtual learning arranged by the school?
This is true, Your Honors, but the only violation that was found by my client was the violation of the school's dress code. But Your Honors, when the Virgin Islands Department of Education put the dress code in place, it was just to ensure that they were in attendance. But my client, regardless of what she and her classmates were wearing, was still in attendance. Okay. In both Mahanoy VBL and JSD Blue Mountain, the students used social media, and although their speech did enter the school's campus, the speech itself was off campus. The shirt was not the start of my client's speech. It was the end of the conversation. A conversation that involved...
Excuse me, Counselor, in the cases where we talk about off-campus speech, were not these in schools or colleges where the classrooms were open, where students were going to class in the classroom? Now, because of the pandemic, students go to class virtually. But is it not logical to say that the school's jurisdiction over the students extends not only to in the schoolhouse rooms, but in the virtual rooms, in the virtual schoolhouse that has been created due to the pandemic?
Well, Your Honors, in Mahanoy VBL, in the concurrence, it said that off-premises speech that can be regulated as on-campus speech, it would have to fulfill the 4 regulations, but it only fulfilled 1, which is online instruction at home. So, Your Honors, that means that Tracy Flick was able to deal with the other components of off-campus speech, meaning the proximity and geographical location, meaning that the school was not operating in local parentis. The time and place was not there, and the school did not have an interest in allowing for unpopular expression, especially off-campus. Therefore, my client's speech is off-campus, and the school has no right to regulate from at home. A conversation that includes 25 students who profess their frustrations respectfully, quietly, and non-disruptively. That conversation was also not defamatory or obscene. In BL, the Snapchat video was explicit and was directed at the school's chair program and the chair team. In JS, the MySpace page was filled with crude and juvenile jokes. Nothing my client said is obscene, but like BL and JS, it occurred off campus.
Could the writing on the t-shirt be considered obscene, Counselor?
Excuse me, Honor, can you repeat the question?
Could the writing on the t-shirt worn by your client and others, couldn't that be considered obscene?
No, Your Honors. For instance, let's look in the case of Cohen v. California. Mr. Cohen wore a shirt that explicitly stated, F the draft. The Supreme Court ruled that the display of profane words in public places cannot be criminalized, at least not by itself. Mr. Cohen, like my client, expressed his feelings and frustrations towards something, but he isn't being held to such high standards of punishment as my client. Her shirt only said, forget you, TA, and she wore it as a collective with her classmates. It is my argument that you cannot punish an all-knowing mature adult for an act that is far more egregious than the act of my client, which is a minor. Ms. Flick did not antagonize the school, its staff, nor did she curse out the TEA. She stated the feelings and frustrations of many of her peers, hence why they, as a collective, decided to wear the shirt. To my second point, Your Honors, the purpose of the school uniform being worn at home with cameras on was to ensure attendance, not attire. My client was in attendance, actually. Her entire class was. Cameras on, all visible, all ready to learn in their homes. If there was any disruption, the cause was Mr. Keating, not his class and not my client. That statement is not to disparage Mr. Keating.
Didn't your client's conduct cause the teacher to deviate from his lesson plan?
Well, Your Honors, when Mr. Keating taught his lesson, he was able to take it from the theoretical to the real world. And this was approximately a month before the AP exams, so this actually benefited them greatly. I see that my time is about to elapse. May I please take this time to briefly conclude?
You have a few more minutes.
While the means of communication...
You can conclude at this time.
Thank you. While the means of communication, the locations of schooling, and the method of providing instruction may evolve in ways we may not expect, it is unmistakable that the right to students to speak freely, respectfully, and non-disruptively must be protected. It is for these reasons that this court should affirm the Moot Superior Court's ruling and maintain that necessary for protection. Your Honors, thank you for your time.
Thank you.
All right, Attorney Martin, please come up and be prepared to start while the judges are getting their scores completed.
I'm done.
Okay.
School section.
All set, Judge Mead?
Yes, I am.
All right, your time will begin when you begin speaking.
May it please the court. Minors need to be protected from crafty adults. Based upon his actions as outlined by the facts and the nature of his complaint, Tommy Z would fall into this very category. The infancy doctrine exists because even with the improvements in communication and technologies, minors are still minors, still learning, and protections must still be afforded to them. The Superior Court saw the need for these protections and provided analysis of the best common law rule. Their decision is correct, and that decision should be affirmed for the following reasons. 1. No matter the rule, this affirmance still exists for minors who come of age. 2. Ms. Flick was not provided the required time to disaffirm. 3. Even with another rule, Tommy Z remains in possession of the shirts. To my first point, the Moot Superior Court began by looking at restatements of contracts 12 and 14. They then analyzed Oregon statutes and code, which is what the Virgin Islands Code was initially based on. Both parties already agreed that the principles of restatements 12 and 14 have both been used in the Virgin Islands in the past, and that under a bank's analysis, this weighs heavily in the adoption of restatements second of contracts 12 and 14. Restatements automatically provide minors with voidable contractual duties until the beginning of the day before their 18th birthday. Ms. Flick's contract started on April 13, 2020, which gives her the right to void the contract. Ms. Flick, at the time of the agreement in question, was a minor, unable to assent to a contract. The day before Ms. Flick's 18th birthday was April 18, 2020. Ms. Flick still has the ability to disaffirm. Hiram v. Tolleson, a case that the Moot Superior Court referenced by name in their analysis, states minors can disaffirm their contract within a reasonable time after coming of age. If this was Oregon in 1915, 10 years would have been a reasonable time. Tommy Z didn't give her 10 days. As a matter of fact, he didn't give her 24 hours. As Ms. Flick fought a violation of her First Amendment right, he came seeking restitution for voidable, incomplete contract. That brings me to my second point.
But isn't he entitled to compensation for his work that he did? producing the 200 T-shirts that she ordered?
No, Your Honor, because my client did not affirm her contract. That brings me to my second point. Opposing counsel may say that my client had more than enough time to contact Tommy Z, but the fact shows that other events took priority. If we look at the timeline of events, Ms. Flick went from initial contact with Tommy Z to respectful and controlled sitting, to a meeting, to an expulsion hearing, to an expulsion, to a challenge before the Moot Superior Court, all within less than a week. Even her birthday was likely the last thing on her mind. These facts illustrate the exact reason why protections are afforded to infants. Even in cases where goods were exchanged like Kiefer v. Fred Hall Motors Inc., even an emancipated minor is afforded protections. In that case, Kiefer purchased a car and was able to return the vehicle in return for the money he paid. The contract was voidable by Kiefer, the minor. To tie this point to the first, the comments in restatements of contracts also states that minor need not take any action to disaffirm a contract until they come of age. In our case, Ms. Flick still would be able to disaffirm, but she was never provided the time to do so. So my final point.
But would Ms. Flick, in fact, have disaffirmed it? She seemed to have completely forgotten about the contract, and yet Tommy Z is left with 200 T-shirts that he can't sell. He's lost money. She was almost 18 years old. She was a mature teenager who understood what she was doing and why she was doing it, and then she just ignored Tommy Z, had no intention, I think, of ever picking the shirts up, and wouldn't have done anything at all about it unless Tommy Z had contacted her parents. Can't we, in reviewing this, balance the equities, balance Tommy Z's injury against the fact that Ms. Flick suffered no harm at all?
Your Honor, as stated before, my client had a lot of priorities at that time. She was getting expelled from school, which was the most important at that time. This shirt was custom made. They didn't have her name on there. They didn't have anything like that. These shirts could have been sold because it was a matter that the entire community was being impacted from. So my
as you just stated, it was custom made. I mean, it was made specifically at her request. How would anyone else be able to use it? And why wouldn't the Tommy Z be entitled to compensation, at least from her parents?
Your Honor, on the T-shirts, as I said before, it didn't have her name or anything like that. So he could have marketed the shirt and sold them. And Tommy Z didn't have a deposit system in place, so my client owes him nothing. The rule should be the one as outlined by the Moot Superior Court. Minors who disaffirm within a reasonable time can avoid liability. A majority of jurisdiction operates in this way. The jurisdiction in which the Virgin Islands Code was initially based upon operates this way. And even if another rule was used, Tommy Z does not benefit. Kiefer takes place in Wisconsin, and while a change could be made, that court provides that any act that shows disaffirmance is sufficient. In our case, Ms. Flick didn't arrive, and this could be viewed as disaffirmance. Moreover, Tommy Z showed up while my client was before the Superior Court. That court held that my client had disaffirmed, allowing her to void the contract within a reasonable time. If we went further away from the facts of the best rule for the Virgin Islands and looked to New Hampshire and Porter v. Wilson, and that court noted that it was in the minority, they required minors to make restitution to the extent that they received a benefit under the contract. My client, unlike Kiefer and unlike Porter, has not seen, and did not arrive to see Tommy Z's mediocrities. Ms. Flick received no benefit. What Tommy Z should have done was have a deposit system in place to recoup a proportion of potential loss, regardless if his contract was with a minor or otherwise. If he did this, no matter the rule, he would have a more sound business practice.
and would not be inviting trouble contracting with minors. In brief, Tamizi saw an opportunity and decided to jump on the bandwagon, adding to my client's stress in a trying time. The best rule is the one outlined by the Moot Superior Court, where no matter the rule, he receives no benefit. Ms. Flick can disaffirm, has disaffirmed, and has not seen or received any shirt to which she'd be able to provide restitution. We must defend against business owners like Tommy Z, who would seize the opportunity to take advantage of minors. It is for these reasons that this court should affirm the Moot Superior Court ruling. Your Honor,
do you think minors should bear any responsibility for the actions that they initiate, in this case that your client initiated? Does she have any kind of responsibility?
Your Honor, my client didn't affirm this agreement, but if it was in a case like that, my client still doesn't have to give Tommy Z anything, as seen in Kiefer. Kiefer paid for the vehicle. He still had the right, he still could have returned the vehicle and got his money back. Your Honor, thank you for your time.
Thank you.
All right. Shalimar High School, and they had an alternate on their team as well. Louisiana Coach Sheriff, she obviously didn't get to compete today, but we want to recognize her participation. Also, Shalimar High School is done presenting arguments, so they will remain here to observe. Judges, would you like 10 minutes now, or do you want to go another round?
I just assume take 10 minutes now, if that's...
All right, then we will be on a 10-minute break, and we will begin again at 3:28 p.m. In this time, please forward your score sheets to us. New update for us, please.
Who do you have coming in?
All right.
Good afternoon.
Good afternoon. Who's speaking?
Fine. I actually thought I had it on my calendar for 7, but 7:30 is fine.
Oh, I know where.
Alright, see you then.
Danny Phillips and Baptiste.
Yes.
Attorney Phillips and Attorney Baptiste. Okay.
All right.
Justice Ross, are you back yet? That's what we're waiting for.
I messaged her judicial secretary, but haven't heard anything either. Not that she's ridiculously over. I mean, how dare she take an extra 2 minutes?
They're getting more realistic lessons on being lawyers, waiting for things, waiting in a room for something to happen.
Yeah.
Waiting for the judge.
Waiting for the judge, waiting for the lawyers, waiting for the court reporter, waiting for the witness, waiting for the seaplane.
Yeah, there's a lot of waiting as a lawyer.
Waiting for Judge Moot to come on the bench because he's always late.
Oh, okay. I just heard they had some complications with forwarding the scores, and they're dealing with that. And I think we can all agree it is exceedingly important that the scores get transmitted and tabulated.
I concur.
Hopeless now as a result of TEA.
If it is, forget TEA.
Let me check my phone just a second.
All right, no worries.
Okay, I think it's my office and I saw I was here. So just start green. I'm done. I'm ready.
All right, then. If we could get your notices of appearance on the record, please.
Good afternoon, honorable justices. My name is Danny Phillip, spelled D-A-N-N-Y, P as in pan, H-I-L-I, P as in pan. I represent the St. Thomas and St. John Seventh-day Adventist School. I am here on the issue of whether the St. Croix North High School violated Ms. Flick's First Amendment right.
I'm sorry, could I get that name again, please?
My name is Danny Phillip, spelled D-A-N-N-Y.
Okay, I've got it, thank you.
All right, and Mr. Baptiste. Yeah.
Good afternoon, Your Honors. My name is Zion Baptist, spelled Z-I-O-N, B as in boat, A, P as in panda, T-I-S-T-E. I attend the St. Thomas St. John Seventh-day Adventist School, and I am here arguing the issue of whether minors are allowed to disaffirm contracts and avoid liability.
All right, thank you. Mr. Phillip. When you begin speaking, your time will commence.
Good afternoon, Chief Justice and Associate Justices. May it please the Court. Honorable Justices, the U.S. Virgin Islands Superior Court erred when it found that the state, vis-a-vis St. Croix North High, violated Ms. Flick's First Amendment rights when it expelled her from the St. Croix North High for organizing a protest among the students. Indeed, this court should review the Superior Court case decision de novo and look for errors in conclusion of law. In Title 48 of United States Code, Section 1561, the United States Congress extends the First Amendment right of freedom of speech to the U.S. Virgin Islands. However, it is well established that the individual citizen's right to free speech is not unlimited. Therefore, the U.S. Virgin Islands Superior Court erred that it found that the St. Croix North High School violated Ms. Flick's First Amendment rights for the following three reasons. First, the First Amendment protection of freedom of speech is not unlimited, and the U.S. Supreme Court has recognized circumstances where the state may regulate speech, mainly in institutions of learning. Second, the department's regulation was a time and manner, not content-based restriction, granting greater deference under constitutional standards. And lastly, Ms. Flick's actions in her attempt to express herself led to being substantially and materially disrupted.
Attorney Phillip, excuse me, the decision to discipline Ms. Flick, wasn't that made after the school administrators learned of the expected protests, and then they decided that this shouldn't happen, as opposed to some long-standing policy that limited free speech? Wasn't this geared specifically toward Ms. Flick?
No, Honorable Justice. There have been restrictions that have been set up in Tinker and Mahoney about what the restrictions are for school speech and what do they allow school officials to regulate. These speech are indecent lewd, vulgar speech, speech that promotes illegal drug use, school-sponsored speech, and speech that others may receive as bearing imprimatur of the school, like appearing in the newspaper, and lastly, if it disrupts school learning and imposes on the rights of others, or disrupts the school handbook policies. The last restriction is the restriction where Ms. Flick and the other students cross the boundaries stated of where free speech could protect them. St. Croix North High.
Attorney Phillip, how do they cross the boundary of free speech in the school context? Simply because they wore T-shirts that said forget you, TEA, and you suck? Does that somehow pierce the permissible fortress of free speech in a school?
No, Honorable Justices. The reason why is because they violated school policy and It was the time and place that they did it, not the content on these t-shirts. Which brings me to my second point. The St. Croix North High School's regulation of speech at the school constituted a time and manner restriction, not content-based. Indeed, the U.S. Supreme Court has decided on this issue on multiple occasions, recognizing that students are not emboldened to utter speech with no limits. Without restrictions, there would be chaos and no conduct during school. The teachers would not get to do their jobs and no learning would occur. In JS versus Blue Mountain School District, the Third Circuit Court concluded that a student could not have punishment for speech that occurred off school campus and off campus hours. In our case, however, the school has no problem with what Ms. Flick and the other students protest. Ms. Flick and the other students talk about TA's effect on student learning ability, which is the school's officials' responsibility. The problem is that it occurred at the wrong place and time. According to the
Attorney Phillips, this occurred in a classroom, a civics class, an AP class, government class. Wasn't this a teaching opportunity? And in fact, did the teacher take advantage of this to discuss the issues with this class, with his class?
Well, actually, on the contrary, John Keating could not have avoided this speech and had to address it for two reasons. First, the students were out of uniform, which is breaking school policy. School officials are in charge of keeping order and making sure that school policy is followed. So by John Keating stopping his class to talk about the issue, they are protesting. He is doing his job by finding out why they are out of uniform. This first action was a direct action of Ms. Flick and the other students' protest. And second, in reference to the Coleman case, the people in the courtroom could have easily looked away and avoid the symbolic speech taking place on Zoom, taking place in the courthouse. John Keating had to look at the screen and see 25 students with their cameras on and t-shirts saying, "Forget you, TA, you suck." He could not look away or ignore the speech like the people in the courthouse. John Keating was forced to acknowledge and talk about their speech. According to the record, these protests occurred during St. Croix North High School's hours in the school Zoom while their teachers were present. These things are the polar opposite of what happened in the JS case, because JS was home and not on school time. Ms. Flick was in school on school time. Her protest also interfered with the schoolwork since it was in school. These facts bring us to the third point.
Well, before you move to your third point, Attorney Phillips, wasn't there another method that the school could use to address the issues raised by Ms. Flick and the other students? And if so, why was it only Ms. Flick who was disciplined?
Well, to your first point, the school could not have done anything since it was TAA's fault and the school has no jurisdiction over dealing with power. Second, Ms. Flick was the prime organizer of this protest and she was the one who incited all these other students to protest. So, the school was just doing its job by regulating order and conduct.
Assuming that Ms. Flick did violate the school's policy, don't you think that the sanction was draconian, it was harsh, and don't you think that your client had some personal animus for Ms. Flick by the statement that both the principal and the assistant principal made prior to suspending Ms. Flick?
No, not at all. As Edward Rooney said, Ms. Flick gave good students bad ideas. So by inciting them to protest, he had an even harder job to do his job so that he can regulate order in school and not have students break school policy and cause great substantial disruption. Which brings me to my third point.
Well, before you get to your third point,
Judge Ross.
is there not there is some language, some protest that can occur in the school, is there not? As long as it's not vulgar, as long as it's not disruptive. And doesn't the protest that we see here, isn't that part of this permissible protest that you can have in school?
Could you repeat your question, Honorable Justice?
Is there not, are you saying that there's, well, let me break it in two. Are you saying that there's no protest at all that can occur at a school?
No, I am not saying that. Protests can occur in the school, according to JS, that if it does not substantially or materially disrupt school, it is allowed. And
but isn't this that type of protest where
no.
There was nothing vulgar or obscene said, where if there was any disruption of the expected class, it was simply to discuss this First Amendment issue, which is very important to all of us as American citizens, and does not this conduct then fall within the permitted protest that you can have in a school?
On the contrary, Ms. Flick's protest was very disruptive for several reasons. First, there were multiple teachers that had to stop their classes and address these teachers since they were a direct violation of school policy. Second, the AP Government and Civics teacher, John Keating, did not get to 75% of his lesson plan for those 2 days. Third,
but nevertheless, he got to talk about the First Amendment. Isn't that more important?
he had to stop what he was doing to address, because they were out of school uniform, and he had to find out, and he could not have ignored the speech like the others in the court.
But didn't he discuss important issues with the class? And so does it really make any difference that he didn't say what he had expected to say, but he still said something important?
Yes, it makes a difference, because the learning they are supposed to be receiving in their curriculum is not being taught.
Your time has expired, Attorney Phillips, but you may conclude your final argument.
In conclusion, Honorable Justices, the court erred that Ms. Flick's First Amendment right of freedom of speech was not violated because she went outside of the restrictions of freedom of speech for students in school. Ms. Flick organized and gave her protest at the wrong place and time. And lastly, Ms. Flick disrupted school learning and violated school policy by the actions committed that has been shown in the evidence. So the school being put in that position had to punish and deem her speech as not pure, so that learning and school order could continue. And that is why the expulsion did not in any way violate her freedom of speech. So for these following reasons, we ask that the U.S. Virgin Islands Supreme Court overturn this ruling in the favor of the Department of Education. Thank you.
Thank you.
All right, Mr. Baptist, please come up and get prepared while the judges finish scoring.
I'm done.
I'm done.
I'm done.
All right, Mr. Baptist, when you begin speaking, your time will start running.
Good afternoon, Chief Justices and Associate Justices. May it please the Court. Honorable Justices, I ask that this Court reverse the ruling of the Superior Court. While the state of law in the Virgin Islands may yet to be resolved, the fact of this case strongly weigh in favor of my client, Tommy Z. Your Honors, it is unfair for anyone to call a business, request a service, and refuse to pay. Business owners are already burdened with the challenges of business ownership and should not also have to deal with unpaying customers. Therefore, the Court should adopt a rule that protects business owners, in cases such as this. I have 3 reasons as to why Tracy Flick is still liable under the T-shirt contract. First, in weighing the factors as laid out in this court's holding in the Banks versus International Leasing's case, the best and soundest rule for the Virgin Islands is to allow minors to disaffirm their contracts within a reasonable amount of time. Emphasis on reasonable. Second, the Virgin Islands legislature has clearly manifested its intent to subject minors to liability upon emancipation, such intent being codified in Title 16 of the Virgin Islands Code, Sections 221 and 261. Third, the uncontroverted fact
How does the legislature show their intent for minors to be responsible after they turn 18 by those sections?
Your Honor, according to Section 261 of the Virgin Islands Code, it says, all persons are deemed to have arrived at the age of majority at the age of 18 years, and thereafter shall have control of their actions and businesses, and have all the rights and be subject to all the liabilities of the persons of full age.
But in this case, the alleged contract was created prior to Ms. Flick attaining the age of 18. So isn't she protected because she did not arrive at the age of 18 when she ordered the T-shirts?
Correct, Your Honor. She would have been protected at the time she made the contract. However, Tracy Flick is no longer a minor and has not sought to disaffirm the contract in any way.
So Attorney Baptiste, should the court look at the time when the contract was consummated to determine whether or not Ms. Flick was a minor? And the facts would indicate that at the time the contract was made, that she was still 17 years old.
Your Honor, it is correct that she was 17 years old at the time the contract was made. However, she did not disaffirm the contract, and because of this, and her reaching the age of majority, she is subject to all liabilities, including any contracts that have not yet been disaffirmed. Allowing Ms. Flick to disaffirm the T-shirt contract is neither reasonable, nor does it comport with the realities of the circumstances faced by my client.
Shouldn't Tommy Z, in the course of his business, be more careful about who he does business with, to take a deposit, to find out the age of a teenager who's talking to him? I mean, these are simple steps he could have taken that would have avoided all this problem. Shouldn't he be held to that standard of conduct?
Your Honor, the contract with my client Tommy Z and Mrs. Tracy Flick was made over phone, and he may have only known she was a minor when he reached out to Tracy Flick's parents on the 20th, and that is when they told him that she was a minor.
He contacted the parents. He must have known that she was their child. If she was their daughter living with them, shouldn't he have had some suspicion about what her age is? Shouldn't he have asked her for Tracy for a credit card or for a down payment? Weren't these steps that he could take to avoid the problem?
Your Honor, there were steps he could have taken to avoid the problem. However, the issue today is whether minors are allowed to disaffirm contracts or not. Because of this court's recent founding, not everything has a case or a law to say what the soundest rule for the Virgin Islands is. However, this court ruled in the Banks analysis that if a particular case does not have an example or for the issue presented, we must then look to what the majority of jurisdictions are doing, and then decide the soundest rule for the Virgin Islands. Because there is no case law on our particular case today, we must look at what the majority of jurisdictions are doing. In the Bailey versus Mount Bachelor case, taking place in the Oregon Appeal Court, the court held that because Mr. Bailey did not act in a reasonable amount of time, he was liable for his contract. Now, in the opposite manner, in the Engelbert versus Troxel case, taking place in Nebraska, the court held that because Engelbert acted in a reasonable amount of time after being emancipated, the contract can be disaffirmed.
But did Ms. Flick act in a reasonable amount of time after she attained the age of majority to disaffirm the contract?
No, Your Honor. Tracy Flick did not act in a reasonable amount of time to disaffirm the contract. On April 14th, that is the day she decided she would no longer need the t-shirts she had my client Tommy Z picked. From April 14th through April 19th, Mrs. Flick was still a minor and could disaffirm the contract and did not seek to do so. On the 20th, when she was an emancipated adult, is the day that my client Tommy Z reached out to her parents so she could pay the contract. However, her parents said that she would not be paying the contract because she was a minor at the time, but they could not disaffirm the contract for her because she was an emancipated adult.
Why do you think, Attorney Baptist, that the legislature did not make any exception to the statute that says, that you have to be 18 years old to enter into a contract, as they have with respect to minors being charged as adults or treated as adults in certain criminal cases?
Your Honors, minors are allowed to enter into contracts. However, they are not bound to the contracts because of their immaturity.
Why hasn't there been an exception made? Do you think this court should make an exception when the legislature has chosen not to do so?
I believe Tracy Flick should be held liable for the t-shirt contract, considering she is now an emancipated adult, and according to Section 261 of the Virgin Islands Code, she should be held liable as a person of full age would be.
Now that she's emancipated, you're saying?
Correct, Your Honor.
So you're saying minors should be held accountable for their actions taken as minors when they become adults?
They should be accountable for their actions if they have not disaffirmed contracts, Your Honor. And Tracy Flick did not seek to disaffirm the contract in any way.
Would this apply to all minors or just to your client because of the close time in which the contract was made and the time she attained the age of majority?
Your Honor, all minors who made contracts and does not want to be held accountable for them will have to disaffirm the contract within a reasonable amount of time. On April 19th, 2020, Ms. Flick turned 18, and the day after, my client, Tommy Z, contacted her parents so that Ms. Flick could pay him and she can receive the t-shirts. However, the parents said that she would not be paying anything, considering she was a minor at the time the contract was made. However, because Tracy Flick turned 18, she is now an emancipated adult. Now, within the span of the Monday Metro pickup, and when my client Tommy Z contacted her parents, Ms. Flick never tried to contact Tommy Z in any way, nor did she try to show any intent to disaffirm the contract. Because of this, as well as the fact that inaction does not equate to intent to disaffirm, Ms. Flick should be fully liable for the t-shirt contract she entered into with my client Tommy Z. Your Honors, I see that my time has elapsed. May I briefly conclude?
You may.
Your Honors, the legislature is the best suited forum for the development of the public policy in the Virgin Islands. However, because of this court's recent establishing, not everything has a case or a law to say what the best course of action may be. We understand that no two parties can enter or exit a contract without showing intent to do so. However, the law does not support that inaction is equal to intent to disaffirm. What is clear, however, is that Tracy Flick did not take any steps to manifest her intent to disaffirm the contract while she was a minor, nor after she became emancipated. Accordingly, this court should reverse the Superior Court's holding and find Tracy Flick liable under the t-shirt contract. Thank you.
Thank you.
All right. That is the last argument for St. Thomas St. John Seventh-day Adventist School, and they will remain in the conference. Antilles appellants are next. This is the change that we had in the schedule. Let me know when you, judges, let me know when you are finished with your scores, and we will get notified.
I'm done.
I'm done. All right. Please put your notices of appearance on the record.
Good afternoon, Your Honors. My name is Ronit Tatwani. R-O-N-I-T, first name, and last name, T-O-T-W-A-N-I. And I'm from Antilles School. Today, I will be representing the appellant, St. Croix North High School, and I will be addressing Issue 1, whether the high school violated Ms. Flick's First Amendment rights. Good afternoon, Your Honors. My name is Ritesh Alwani. First name, R-I-T-E-S-H. Last name, Alwani. A-L-W-A-N-I. And I'm from Antilles School. Today, I will be representing the appellant, Tommy Z, on Issue 2, whether the Superior Court erred when it determined that the best rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability. Good afternoon, Your Honors. May it please the Court. Our position is that the judgment of the Moot Superior Court should be reversed because Ms. Flick's First Amendment rights were not violated by the school for 3 reasons. First, Tracy Flick's message on the t-shirts was vulgar. Second, Tracy Flick was substantially disruptive to the high school. And third, Tracy Flick organized this protest during school hours. And it also occurred during school hours. The t-shirts designed by Tracy Flick for the protest contained vulgar language, and Tracy Flick, as well as the many other students that she convinced to wear, wore those t-shirts on school grounds. Therefore, according to the Supreme Court case in Mahanoy, the school can regulate this form of speech. In Mahanoy, the court ruled that a school can regulate speech if it is indecent, lewd, or vulgar speech, and if it occurs on school grounds.
If I look at the t-shirts, I see nothing vulgar or indecent in what is said.
Your Honor, the vulgarity in the message lies in the fact that the first 2 letters of the first 2 words were disproportionately large. Clearly, the large nature of these first 2 letters of these first 2 words indicate that the students were trying to send the 4-letter expletive, a vulgar message across, rather than just the simple forget you. Additionally,
Attorney Tadwani, didn't this protest occur off campus? And would the school policies still apply here?
Your Honor, while they may not have been physically on campus, we encourage the court to consider the unprecedented circumstances of this global pandemic, in which students cannot physically attend campus, and going to school virtually is their only means of getting an education. Therefore, since this happened during school hours, on the Zoom, on the virtual screen, this had the same capacity to cause a substantial disruption as a protest would if it had occurred physically on campus.
And can this be considered a substantial disruption? You know, there was no riots on the school campus. You know, there was a silent protest. Why is this considered a substantial disruption?
Your Honor, this is considered substantial disruption because according to the ruling in Tinker, the Supreme Court held that schools have the right to regulate speech that materially disrupts classwork or involves substantial disorder or invasion of the rights of others. It is our position that Tracy Flick not only disrupted classwork, but extremely caused classes to not even be able to be continued.
But Attorney Tawani, did not the civic teacher use the protest as a teaching opportunity to discuss important matters as an American citizen's First Amendment right. In the court's opinion, that would help the school as opposed to disrupt the school.
Your Honor, if this had been an isolated incident in which the student requested to have this time, or if it had just been simply one class, this may have been the case. However, this substantial disruption extended not only to the first day, but to many other days after, and also extended to multiple different classes, and multiple teachers were not able to complete their lesson plans.
By their choice. I mean, the protest lasted for 2 days. Am I not correct?
Yes, Your Honor.
And the other classes that, quote unquote, were disrupted, wasn't that as a product of the free will of the teacher? Then the teacher make the decision rather than the disruption was caused by Ms. Flick's demonstration?
Your Honor, these students wearing these t-shirts prompted these discussions, and the students were sharing screenshots, photos, and other stories on social media, and causing this disruption to extend further.
And were they doing this during school time?
Yes, Your Honor. This all was occurring during school hours, in which these students were, instead of engaging with the class material, were on these protests in which Tracy Flick was the main leader and facilitator of.
But wasn't the teacher also engaged in discussion with the students? Did he alter his lesson plan to address the issues before him?
Your Honor, while the AP government teacher did have a discussion, other teachers were forced to halt and address their protest, meaning that they wanted to get a different lesson plan across, and yet they were not able to do so because these t-shirts were being spread and worn and talked about so much.
Wasn't this a good life lesson that, you know, things change in life and you have to adjust?
Your Honor, while this may serve as a good lesson for these students, these public schools also have an obligation to give an education to students of a variety of socioeconomic backgrounds. And these public schools were not able to complete their duty because of this disruption, and it extended so far, especially in circumstances in which students were attending on Zoom, and they were not being able to be engaged to the normal degree in the first place. This added and amplified to the disruption. Your Honor, to detail more on the specifics of the disruption, the AP government teacher was not even able to complete 25% of his lesson plan during these protest days, due to the distraction and disruption it caused. Additionally, Your Honor, other classes had to address their issue and discuss this issue, which caused a greater disruption to the learning environment. Additionally, Your Honor, the court case that defined what substantial disruption is, Tinker, was very different and ruled in favor of the students, was very different to the case which we are discussing today. Because in that case, in Tinker, students wore black armbands as an expression of their feelings on the Vietnam War, and the court ruled that they had a right to do so because they did not cause any material disruption or substantial disruption to the operation of the school. One of the reasons for that may be due to the fact that in Tinker, there were no words on the t-shirts, and there were no words on the armbands, unlike the vulgar words which were on the t-shirts today. Furthermore, Your Honor, the school was an improper venue for this protest, because despite being extremely disruptive and causing many students harm due to the fact that they were not able to get their education, this had no effect on TEA. Instead of approaching TEA directly, Tracy Flick organized this protest at school. The school had provided the students with many resources, such as laptops, MiFis, individual wireless access, and a virtual whiteboard platform for them to collaborate and share their ideas. Instead of recognizing that the school made every effort to foster a good learning environment for the students, Tracy Flick continued to harm the school and do a disservice to her classmates by organizing this protest on school hours and thus disrupting the learning environment.
Well, could the school have also assist in the learning by implementing a progressive disciplinary action rather than the extreme action of expulsion?
Your Honor, It is our position that the substantial disruption caused by Tracy Flick was so extreme in these unprecedented times that expulsion was warranted. As also, Your Honor, the degree of punishment is something that is not under our issue today, as we are addressing whether the school violated Ms. Flick's First Amendment rights. The degree of punishment is up to the school to determine. Your Honor, this provides for empirical evidence of the disruption that Tracy Flick's action caused, and based on the ruling in Tinker, the school had the authority to regulate her speech. Your Honor, not only did Tracy Flick organize this protest during school hours, she used the school facilities to do so. Therefore, it is contrary to the ruling in Mahanoy, in which the student used profanity off campus on a Saturday, in which she did not have the power to cause substantial disruption. In contrast,
Did other students also participate in this silent protest and were equally disruptive?
Your Honor, while other students may have participated in this protest, they were not an equal part to this. Your Honor, I see that my time has concluded. May I finish my answer to your question?
You may finish your response and conclude.
Thank you. Your Honor, the other students did not play an equal part because Tracy Flick facilitated this protest and spread this protest and continued to spread it throughout social media throughout all of these days in which they had virtual learning. Now, she facilitated the protest and she was the main leader of the protest. Your Honor, may I conclude?
You conclude, please.
In conclusion, we respectfully request that this court reverse the decision of the lower court and find that Tracy Flick's expression was not protected by the First Amendment.
All right.
Thank you.
Mr. Alwani, please come up and be prepared. Judges, let me know when you're done recording your scores.
Done.
All right. When you begin speaking, your time will commence.
May it please the court. Good afternoon, Your Honors. Our position is that the court erred in finding Ms. Flick not liable for damages. Ms. Flick's decision to completely and utterly disregard her agreed-upon contract violated my client's contract rights. Your Honor, my client Tommy Z is a hard-working small business owner that prints customized designs on t-shirts. On April 13th, Ms. Flick called my client Tommy Z to negotiate a contract for the purchase of 200 t-shirts with the words, "Forget you, TEA, you suck." A design made specifically by Ms. Flick for her own use. Understandably, Tommy Z, as a businessman, agreed to terms as Ms. Flick presented herself as a capable adult. It is not unusual.
You're saying, do we have in the record how she presented herself as a capable adult?
Well, Your Honor, the actions that Ms. Flick took to purchase these t-shirts from Tommy Z were some actions of a capable adult. She negotiated the price with my client and provided a design to my client. Continuing on.
Did your client have an obligation to inquire of her capability or ability to contract? Get an ID, get a credit card, get a deposit?
Well, no, Your Honor, as that is not normal business operations for my client. Normal business operations for my client consist of someone calling up my client, requesting for their customized design on a t-shirt, which are all the steps that Ms. Flick took. The payment comes when the person picks up the t-shirts.
So your client usually then takes this risk of taking orders without payment and verification of who he's doing business with.
Well, yes, Your Honor, you may consider it a risk, but it is just normal business operations for my client.
Attorney How do you pronounce your last name? Adwan?
Yes, Your Honor, Alwan, yes.
Are you asking this court to, in overturning the Superior Court's decision, are you asking this court to totally ignore the legislature of the Virgin Islands, who is empowered to make the public policies of this Virgin Islands, when it enacted Title 16 of the Virgin Islands Code, Section 261, which clearly states that the age of majority is 18 years old?
Your Honor, if I may draw your attention to the case of Gallivan v. Hess Oil VI Corporation, as it must be considered in this determination. The case determined that statutes cannot be amended by implication, meaning Title 16 VI Code Section 261 simply does not say anything about entering upon a contract.
So it is silent as to whether or not a minor is obligated to fulfill a contractual obligations. It is silent as to that. So if it is, what guidance should this court use to determine whether or not Ms. Flick should be held liable for the contract she entered into with your client?
Well, Your Honor, in determining the validity of a contract entered into by minors, the court should consider the totality of circumstances of the case. Some of the circumstances in this case at hand would be the maturity of Ms. Flick, as well as Ms. Flick being less than a week old away from 18.
So in other words, the court is supposed to ignore the mandate of the legislature and look at other factors as to Ms. Flick's maturity, because the record will indicate that she had some mental maturity because she had extracurricular activities and she had ambition, which indicate that she was mentally mature. You're saying the court should forget about Section 261 because it is silent as to whether a minor is liable for a contractual agreement, and look at the minor's behavior to indicate whether or not the minor is so mature mentally that she should have understood the import of her action and thereby holding her liable?
Your Honor, I'm not asking you to completely disregard it, but just to consider the totality of circumstances presented to the court.
Okay.
Continuing on, Your Honor, due to the circumstances of the case, it is quite apparent that Ms. Flick has wronged my client Tommy Z and should be held liable for damages. There being no definite rule for the subject at hand in the Virgin Islands, the court should conduct a Banks analysis to determine the best rule for the Virgin Islands regarding contracts entered into by minors. The Banks analysis requires 3 steps. 1. Has a VI court adopted a particular rule? 2. What is the position of the majority of courts in other jurisdictions? And 3. What is the best rule for the VI? First, whether any Virgin Islands courts has previously adopted a particular rule. Your Honor, the answer is no. In Innis v. Innis, the court determined that although sections 261 and 221 of the VI Code define the age at which a person is emancipated as 18, the VI Code is completely silent on the liability of minors for contracts they enter. Your Honor, there is no rule in the book, but we know maturity doesn't magically come when one turns 18. At the age at which one person should be considered mature is the actions that speak about their maturity.
But Mr. Attorney, direct the court's attention to the rulings in other jurisdictions which permit a minor to be held liable for her contract. What other jurisdiction have adopted that rule?
Well, Your Honor, there's no jurisdictions that have specifically adopted that rule. It is our position that that would be the best rule for here in the Virgin Islands.
But if no jurisdictions, no jurisdiction has adopted, or the majority of jurisdictions have not adopted a rule, why wouldn't it be the best rule for the Virgin Islands?
Well, because that would be the soundest rule for the Virgin Islands to protect small businesses some of what might consider the heart of the economy of St. Thomas. As my client,
So you believe that it's better to protect small business than a public policy that protects children of the Virgin Islands?
well, Your Honor, it would not be not protecting small children, but just giving them responsibilities that they are capable of dealing with. Although there are many jurisdictions that allow minors to disaffirm their contracts, let me draw your attention to the jurisdictions that look at the actions of the minors after contracting with the vendor. For example, in Badgley v. Mount Bachelor, where the court determined whether Badgley intended to either disaffirm or let the contract stand. In this case, the intent of Badgley to let his contract stand was very clear with his extensive use of the mountain pass 119 times after he had reached the age of majority. The court showed that there must be some affirmative action, and the same goes for a disaffirmative action.
But isn't that case, sorry for interrupting, Counsel, but isn't that case factually distinguishable from this case? In that case, the minor used the pass how many times? 100 and something times. In this case, after he had attained the age of majority, in this case, Ms. Flex did not get any advantage of the use of the T-shirt after she attained the age of majority. So does it not make this that the case you have cited factually distinguishable from this case?
Well, Your Honor, I agree that the facts may not precisely line up, but the analysis that was determined by the court should be applied here. Ms. Flick has shown zero intent to disaffirm her contract. The only intent that she has shown is an affirmative intent when she called my client and she negotiated this contract. Moving on, ALMD State, another case, ALMD State. It is not unusual for courts not to adhere to the standard of age set by a statute. In ALMD State, the court discusses Alaska's age of majority to possess marijuana as 19 years of age. When Alien was caught rolling a marijuana cigarette, he was 18 years of age. The court determined that his argument was not sufficient to avoid him being charged criminally as an adult. The court said, minority is not shed like a cocoon by the child on his or her 18th birthday. This is the same view I ask you to consider today. Ms. Flick did not enter into this contract unaware of what she was doing. She initiated the contract with my client and provided the design to my client. Ms. Flick was mature and aware of her actions, and she should be held liable for damages.
But Attorney Tuani, the case that you've just cited, the Alaska case, is a criminal case.
Correct.
Is it not? And this case is a civil matter in terms of the contract.
Correct.
Okay? So, and the Virgin Islands has already enacted laws or set the public policies of the Virgin Islands that a minor or someone who is below the age of majority as mandated by 261 can be subjected to criminal liability for certain crimes. So there's a clear, the legislature clearly believes there's a difference between a criminal action and a civil action. So this matter is a civil action, so why should the court apply policies that govern criminal matters to a completely and purely civil matter? That is, enforcing a contract.
Well, Your Honor, it is our position that the analysis of that case and the analysis of those criminal cases should be applied to civil matters. The 200 T-shirts that my client has printed traumatically affected his economic status. It is of the extreme where we should apply that analysis to the case at hand.
I don't find what you're saying
some responsibility. Judge Ross.
I don't find what you're saying convincing that we should apply criminal rules to a civil case. I mean, you say this is the difference, but criminal law is so different from civil law. Can you give me a better reason?
Well, Your Honor, I'm not asking you to apply all the criminal law to civil cases. What I was trying to get at is the analysis of the case coming out of Alaska, where they they considered that minority is not shed like a cocoon by the child on his or her 18th birthday. That is the analysis that I was asking you guys to apply to the case at hand and consider.
Yeah.
I see that my time has run up. May I please conclude?
You may conclude.
In conclusion, we request that this court reverse the decision of the lower court and considering the totality of circumstances presented to the court today and remand this case to the lower court to determine damages in favor of my client.
Thank you.
Thank you. All right, thank you very much. All right, we are to the last competitors of the day. Eudora Kin, are you in the room?
We are.
Where? There we go. All right. Judges, let me know when you're done scoring, and we'll move on to notices of appearance. I'm done.
Anything?
I'm done.
All right, please put your notices of appearance on the record.
Good afternoon. Representing Irene Eudora Kin High School, my name is Mariah Liu. MariahLoo. I represent appellee Tracy Flick and will be addressing the first issue of one of the Moot Superior Court and in its finding that St. Bernard High School violated Ms. Flick's First Amendment rights.
Good afternoon. My name is Anissa Wallen. ANISSAWALLEN. I represent the appellee Tracy Flick. I'm arguing issue 2, whether this Moot Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability.
All right, your time will commence when you begin speaking.
May it please the court. This case is on appeal from the Moot Superior Court of the Virgin Islands. Your Honors, I ask that the judgment of the Moot Superior Court be affirmed because of 3 reasons. The first is that Ms. Flick's First Amendment rights were disregarded when the administrators of St. Bernard High School expelled her in response to her pure speech. The second, as there were no substantial disruptions, Ms. Flick's actions did not rise to Tinker standard. And third, American public schools must protect the unpopular opinions of students, as these schools should be interested in producing well-rounded individuals. With respect to the first and second points, Your Honors, it is incontestable that pure speech should be given comprehensive protection through the First Amendment of the Constitution. Ms. Flick's speech was in its purest form and was used to express her views on a topic she felt strongly about. In the
Attorney Liu, is the pure speech guaranteed absoluteness?
Your Honor,
is entitled to absolute free speech rights on a public school campus?
Your Honor, I believe that in terms of pure speech, she is guaranteed the right to express it freely, considering that free speech is expressing an opinion on an issue of public concern.
I'm sorry. Even if that speech is disruptive?
Exactly.
Well, Your Honor, I believe that a speech being disruptive depends entirely on how a teacher or an administrator responds to that supposed disruption as it occurs.
Well, in this case, the teacher said that he was unable to complete his lesson for the day, only completed about 25% of it because of the disruption. There's 25 students wearing these T-shirts with the writings on it.
While yes, Your Honor, I acknowledge that only a portion of Mr. Keating's curriculum was taught, he did not need to follow that curriculum in its entirety for the class to be productive. The discussion Mr. Keating chose to have also directly relates to the general content being taught in the class. The students wore the shirts to an AP Government and Civics class, a class where the rights afforded to citizens are discussed.
But didn't the students also wear the shirts to their other classes, and weren't those classes disrupted?
Your Honor, as for the other teachers who addressed the shirts in their classes, the record does not state that Ms. Flick and her counterparts wore the shirts to these additional classes. Nor does the record state that the protesters were the ones who initiated the discussions that were held. And thus, much like Mr. Keating, these teachers are the sole individuals responsible for the disruption caused in their classes. In the holding set forth in John F. Thinker v. Des Moines Independent Community School District, the Supreme Court recognized that minors do not abandon their right to speak freely when they enter a school's campus, or in this instance, a school's online platform. In exercising her right to speak freely, Ms. Flick made no substantial disruptions in the school's ability to teach and maintain order, nor did her speech substantially prevent any student from attaining lessons. Based on the holding set forth in the Hanoi Area School District BBL, the minors' vulgar and indecent language, which included the F word and an image of a middle finger, did not rise to the Tinker standard. And while yes, Ms. Flick's use of suck may not be entirely appropriate for school, Justice Alito's concurrence in Mahanoy stated that, and I quote, speech may not be suppressed simply because it expresses ideas that are offensive and disagreeable, end quote. The offensiveness of opinions expressed and diction used in all speech are subjective. As for my third point, St. Leonard High School is a public school on American soil, a school that should be interested in listening to what its students have to say, especially if opinions expressed by the students differ from the majority and/or address a public issue. The principal and vice principal's disagreement with how Ms. Flick chose to express her views is not a sufficient reason for permanently removing her from a learning environment. In Thinker, the Supreme Court recognized that, and I'll quote, in order for the state in the person of school officials to justify prohibition of expression of opinion, it must be able to show that there was more than a mere desire to avoid the discomfort that always accompany an unpopular viewpoint, end quote.
How do you compare Tinker, where there was an armband being used as a way of protest, to, in this case, a T-shirt that was considered offensive with writing on it that said, "Forget you, T, you suck"?
Your Honor, in Thinker, the students wore armbands to school in protest of the Vietnam War, a war not happening in their presence. In this similar fashion that Ms. Flick and her counterparts are protesting TEA. The school officials...
Was there language, though, that created a disruption and was a basis for the disciplinary action taken?
Your Honor, as for Ms. Flick's language and the actions taken to regulate this language, as previously stated, the offensiveness of opinions expressed and diction used in all speech are subjective. On the day of Ms. Flick's expulsion, it had already been 2 days since the students wore the shirts. Administrators had no reason to anticipate that any further actions from Ms. Flick during the rest of her mandated time in high school would substantially interfere with schoolwork or impinge upon the rights of staff and students. To conclude, Ms. Flick's expulsion was a gross violation of her rights. A high-achieving high school student frustrated by the irregularities of an agency interfering with her classwork should not then be entirely removed from her learning environment.
Is there, although the Superior Court ruling was in your favor, is there any part of the ruling that you disagree with?
No, Your Honor, there is no part of the ruling that I disagree with. Ms. Flick's education and rights are not less valuable than any other individual solely because she decided to express her opinion on an issue of public concern. For these reasons, this court should affirm the judgment of the Moot Superior Court in favor of Tracy Flick.
Thank you.
Thank you.
All right. Well, the judges are scoring. We get Ms. Waylon Wallen up to be prepared.
I'm done.
I'm done.
I'm not done, I'm finished.
Oh, Mr. Stupid drilled the difference between those two in my head in 6th grade, man. Ah, harsh. All right. Ms. Wallen, when you begin speaking, your time will begin.
May it please the court. Your Honors, we ask that you affirm the Moot Superior Court's final judgment in favor of Tracy Flick. As both parties agree to the first and second factor under the bank's analysis, I submit that the best common law rule for the Virgin Islands should be to allow minors to disaffirm their contracts for 3 reasons. First, the legislature has not directly amended statutes concerning age of maturity as it relates to contracts. Second, the onus should be on the adult vendor who seeks to benefit from the contract to ensure its enforceability. Third, minors should be protected due to their immaturity. As to the first issue, Title 16, Section 261 of the Virgin Island Code states that all persons are deemed to have arrived at age of majority at 18 years. After 18, a person shall have control of their own actions and be subjected to all liabilities of persons of full age.
But Attorney Wallen, sorry for interrupting you. I think the record is clear that at the time Ms. Flick entered into the contract with the company, she was below the age of majority. She was less than 18. Okay? However, her activities, as contained in the record, indicate that she was mentally mature, extremely mature, so that a permissible inference can be made that she fully understood what she was doing and the import of her action. Would you not agree with that?
No, Your Honor. Ms. Flick was a minor at the time she entered into a contract under the contract. And under the legislation is who determines the age of majority in the Virgin Islands. The judicial branch should leave the determination to the branch of the government. Her mental capacity or the fact that she was about to turn 18 is not relevant when she is determining the best common law rule for the Virgin Islands. The rule will protect all minors in the Virgin Islands. Ms. Flick was 17 at the time she entered into the contract with Tommy Z Mediocre T-shirts, and thus had not reached the age of majority. In Galvin versus Hess-Ohm, the Third Circuit stated that if a legislature has not directly amended a statute, it is only in its rarest case that the court should rule the statute amended. There is currently no statute in the Virgin Islands that would allow for minors to enter into a binding contract.
Yeah, but Attorney Wallen, is this court compelled to follow the dictates of the Third Circuit Court? Is it mandatory authority or persuasive authority? And did not the Supreme Court of this jurisdiction asks courts to do a bank analysis when there is no existing precept related to a particular issue to determine what law would be the soundest law for the Virgin Islands?
Your Honor, the bank's issue has been, a stand majority still use the jurisdiction today, the principles today, and the principles of the restatement has been applied before. So as you have stated, yes, since the legislature has put the age of majority as 18 years. So as they have set that bank, they cannot, Ms. Flick entered into the contract as a 17-year-old. So she entered into a contract as a minor.
So the court should solely look at her age when she entered into the contract and make a determination that since she had not attained the age of majority, she has no obligation to comply with her contractual agreement. Is that your argument?
Yes, Your Honor.
Well, okay.
But what about Tommy C? He's got 200 T-shirts that have been printed up according to Ms. Flick's orders, and there's nothing he can do with them. He's lost that much amount of money. Shouldn't we weigh the equities in a situation like this?
Your Honors, as Mr. Tommy Dean was an adult vendor that wants to benefit from the contract, it was his responsibility to make sure the contract he entered into with Ms. Flick was binding.
In other words, he was careless. He assumed the risk because he did not exercise good business judgment when he entered into the contract with Ms. Flick without ascertaining whether or not she was a minor or whether or not she had the ability to pay. That is correct, right?
Yes, Your Honor.
Okay.
Yeah. Attorney Whelan, Ms. Flick is known to be very active in extracurricular affairs, very an astute, excellent student, has great ambition, has been involved in organizing other activities. She seems to be an experienced young lady. Shouldn't she bear some responsibility for initiating the purchase of these T-shirts? And shouldn't she be accountable for it? Doesn't she exhibit sufficient maturity?
No, Your Honor. As I stated before, her mental capacity or the fact that she is about to turn 18 is not relevant. Is not relevant.
And is that the very basis for which the law right now says that only persons over the age of 18 has the capacity, that those under 18 don't have the capacity? So isn't capacity an issue?
Ms. Flick entered into the contract as a minor. So she did not reach the age of capacity when she entered into the contract with
Okay, so just because she wasn't 18, you're saying that she didn't have the capacity?
Yes.
And so should we ignore or disregard all her other activities and her level of maturity in determining whether she should be held accountable?
Yes, Your Honor, because the legislature has set the statute that the age of majority is 18 years. Secondly, the court should affirm the Moot Superior Court because it is a vendor's responsibility, as stated before, in the case of Thomas Z, to identify the age of a person they conduct business with. In Kessler versus Fred Howell Motors Incorporation, the court found that when an appellant does not take affirmative steps to determine a person's age, they cannot claim misrepresentation. There is no evidence in the record that Thomas Z asked for his fixed age, an ID, or a driver's license. Lastly, minors should be protected because they lack the experience in contracting before the age of majority, as there are very few instances where minors will find themselves entering into contracts on their own behalf. Thus,
so you're saying that law should be viewed absolutely and there should be no exceptions?
Your Honor, there are only two exceptions in which a minor would be liable to a contract. if he or she contracted in for necessities, which Engelbert, in Engelbert versus Troxel, Supreme Court of Nebraska, contracts made by minors for items other than necessities are voidable and may be disaffirmed when the minor comes of age within a reasonable time, or if a minor receives benefits from the arrangement. In Arthur E. Potter versus Roy C. Wilson, Jr., Supreme Court of New Hampshire, a minor has a right to disaffirm his or her contract if they don't derive any benefits. Thus, as a direct result of their age, minors are at a severe disadvantage in terms of negotiating skills, experience, and power. In the light of this imbalance, minors should be allowed to disaffirm their contracts prior to the age of majority. Minors are a vulnerable population that can be taken advantage of by more knowledgeable vendors. Here, Ms. Flake entered into a contract under the age of 18, and upon reaching the age of majority, disaffirmed that contract when she intentionally did not show up to pick up the t-shirts from Tommy C. Additionally, as Ms. Flake,
don't you think that was improper of her to just intentionally not show up to pick up an order which she made?
Your Honor, an infant need not to take any affirmative actions to disaffirm a contract within her comes of age.
And what about the responsibility of her parents? Do they bear some responsibility for at least paying the cost of the contract?
No, Your Honor, because it would be the responsibility of Tommy Z to make sure the contract that he entered into was binding. Her parents had no knowledge of the contract beforehand. Additionally, as Ms. Fick and other students bought shirts from Kmart to confirm their protest, she never received any benefits from Tommy Z. To conclude, the court should affirm the Moot Superior Court's decision that the best common law rule for the Virgin Islands is to follow the reinstatements 12 and 14 and decline to. I see my time is up. May I finish?
You may conclude your statement.
Virgin Islands is to follow the reinstatements 12 and 14 and decline to hold minors to a binding contract because the onus should be on the adult vendor seeking to enforce their contracts. Thank you.
Thank you.
Thank you.
Wow, that was an impressive showing today, everyone. Well, the judges, well, the judges, first off, nobody who's been here before panic. We will give the judges time to give you feedback. But while they're scoring, we're going to transition into our keynote address. We have Professor Atiba R. Ellis. He is currently a professor of law at Marquette University School of Law in Milwaukee, Wisconsin. He earned his Juris Doctorate from Duke University, and he clerked for Judge McKee at the Third Circuit. He began teaching in 2006 and currently teaches classes on voting and civil rights and lectures on economic barriers to voting, felon disenfranchisement, and the impact of Supreme Court decisions on these areas. And he has the unfortunate distinction to have served as my supervising professor during my Dean Fellowship for an entire year. With that, I'll turn it over to Professor Ellis to share with us today.
Well, thank you very much, Attorney Thorpe. And let me start by saying how great of a pleasure it is to get to see you as an attorney, a leader in the bar, and a former student of mine, as he noted. And yeah, thank you for this invitation. And to all of you out there, I realize that the majority of my audience here is high school students, but certainly also members of the bar and judges of the Third Circuit and of the Virgin Islands. It is a pleasure to be here and to get to talk to you today from Milwaukee, Wisconsin. And as I have to confess that first and foremost, I wish I were with you in person. So, and hopefully we can do that one day. I have a PowerPoint that I put together to help facilitate this conversation. So give me just a moment of leave here to see. I see we've disabled screen sharing. Well, we'll just go without the PowerPoint, and I will just talk through my thoughts with you today. So my talk, I call Free Speech and Student Grievance, the Decline of Tinker and the Protest of the Future. So my idea with you here today is to talk from the perspective of a professor who teaches constitutional law in a variety of contexts, including specifically around in the voting context, to talk about the meaning of the First Amendment, the meaning of Tinker, and to talk for a while in particular about how in this day and age where we have seen through the Black Lives Matter movement, the protest around George Floyd in particular, probably the greatest period of mobilization around civil rights and the rights of individuals to be free from racial discrimination since the civil rights movement of the 50s and 60s. And we all, can think of Dr. King, and we can think of that movement that led to the Civil Rights Act of 1964, the Voting Rights Act of 1965, the Fair Housing Act of 1963. Now, these laws and their titles may or may not be familiar to many of you, particularly if you're students. But the point is, when it comes to the history of the law in America, these acts corrected the long legacy of slavery and colonialism that plagued the United States up until the mid-60s. But at the heart of this was the ability to protest, and to even protest in the face of laws that made such protest illegal, and thus created a challenge for American society. The pressure of protest is the thing that moved social change.
I hate to interrupt, but you can now share your screen. We gave you permission.
Great. Let me just take a second to pull up my presentation, and I will hit share and hit start. So there is our slideshow, and you can see me over here in the corner, hopefully. So I want to talk about this long trajectory, and I'll spend some time talking about Tinker as precedent and situate it within this not only legal history, but the social and cultural history around protest and how protest has been an engine to change America. And what I also want to do is raise reason to be concerned that in the 21st century, and particularly in thinking about the Black Lives Matter movement and how we've already seen it as an engine of protest that has helped start conversations about social change, we are at the same time seeing a retreat from Tinker, a retreat from what scholars like to call the marketplace of ideas, where we get to hear each other's ideas and feel the social pressure that comes from those ideas and make up our own minds and ask that our elected representatives make a change around what we find distasteful. In other words, what I want to get to in the course of this conversation is that there is a tension between hearing protest and maintaining social order that has existed throughout American history. But the debate about Tinker and the freedom to speak in schools held by students has gained and receded, and that this should give us some pause about how we want to have our democracy managed, and what kind of place we want to give to our democratic values around free speech. So I want to proceed in this way. I want to do a little more introductory work. We've already sort of started into it a bit, but then I want to say a word about the First Amendment generally. And then I want to get into that history of civil disobedience, and then talk about Tinker in particular and its progeny, and then get into these two questions of what does it mean in particular around the Black Lives Matter era, and then end with some thoughts about what I'm calling here democracy and discontent, and the importance of protest in American society. But I also realize that there are students, in talking to you, I want to start by introducing myself a little bit. Attorney Thorpe introduced me certainly at the beginning, but I want to take a second to not only point out that I teach at Marquette Law School, I want to talk about what I talk about in class. And in fact, by giving you my social information, my Twitter here and my website here, I want to start, because it's so easy to forget this, but I want to offer an invitation to be in dialogue with you all as you think about your rights, as you think about where you want to go with your career from high school forward. And I want you to know that I'm a resource. And I also want to share a little bit of my life, simply because oftentimes these conversations might be about lectures and the law, but we don't take a moment to talk about where we come from. So I want to talk a minute about where I come from. I was the son of a Methodist minister in rural eastern North Carolina. Adam mentioned that I went to Duke and got my law degree there, but I also studied history there as an undergraduate and a graduate student. And I practiced law first as a law clerk, as noted with Judge Theodore McKee on the Third Circuit. And then after that, I went and practiced in Washington, D.C. At the law firm of Aiken Gump. And then I've taught law. Attorney Thorpe I met at Howard University School of Law. And then I taught law at West Virginia University College of Law. And now I'm at Marquette. And I just want to acknowledge that when I was the age of all of you in high school, I didn't necessarily think that I would get to do this. But through finding mentors, through seeking opportunities, I got from rural eastern North Carolina to teaching law today. And I just want to share that with you at the outset. And I don't want it to be forgotten because it's so easy to forget. Anyway, with that said, let's talk about the substance. So when I teach law school, I often remind my students that the law has sources. And in this context, the number one source here is the First Amendment. So I want to start with the text. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, in thinking about the First Amendment, the text tells us a number of things. First, that this is about the government, that the government shall not interfere with this long list of rights, the right to people to practice their religion as they so choose, that the people cannot use the government to establish a religion or create a state religion, or to deny the press the ability to report on the news of the day, or for the people to assemble, or the people to petition and ask the government for a redress of grievances. Now, I skipped the free speech clause because this is the heart of what we're here to talk about today. But I want to put that in context with the right to petition the government for redress. And this often doesn't get enough attention, but I think it's worth taking a moment to say that within the text of the First Amendment, when it was passed in 1791, it was intentional for this idea of redressing grievances to be placed within the context of how to think about the rights protected as being essential to American democracy. And in fact, the Bill of Rights, the first 10 amendments to the Constitution, including the right to bear arms, to prevent quartering of soldiers, to prevent unwarranted searches and seizures, and all of these things, all of these rights were at the founding of the United States deemed necessary and essential for the working of the government. And I don't want to repeat what you've learned in civics or American history, but suffice it to say that part of the condition of passing the Constitution was the passage of this Bill of Rights. So once the Constitution was put into force, the very next thing that happened according to this deal was the passage of these amendments. They were deemed essential, foundational, in fact, to the way American society is supposed to work. Now, when it comes to free speech in particular, I want to emphasize again, because we often hear this mistake when people are talking about free speech in the context of their rights. The right to utter and say things and to receive criticism for things is a different thing than the right protected in the First Amendment. It is the right to be free from government interference with one's ability to speak. This does not prevent one from suffering from the consequences of their speech when other people in the community may disagree with that speech. This does not prevent the consequences of being judged by one's speech that one utters. And so we see this playing out in particular in the civil rights context, what the First Amendment is versus what it is not, because the marketplace of ideas is supposed to be protected by the First Amendment, but the marketplace of ideas then functions in terms of the people who participate in that market. Your ideas often get supported by others, and groups get to come together to form their ideas and speak to the issues they deem important. And by doing this, and first and foremost, I'm a law of democracy person. I write about voting rights. I write about how our right to vote and how our participation in democratic process shapes who we are as a society and why we need robust participation by all of us. And in this sense, the First Amendment is about protecting that democracy, right? It is about allowing people to participate in the way they wish, to say the speech that they wish, so that they can persuade others to join together and to make choices about who they want to have lead them and how our government should do what we, the people, desire it to do. So oftentimes you hear about the right to vote, for example, being talked about as a First Amendment right, allowing for that freedom of speech and allowing for that freedom to ensure that the government is responsive to us. So the First Amendment is critical. One other thought before we talk about protests specifically. This ability to ask for redress of our grievances. Notice, the First Amendment, by its terms, contemplates that the people will be dissatisfied and therefore will seek redress for the things that they are dissatisfied about. The First Amendment is meant to make sure that our government is responsive to us. This is why political speech, speech on matters of public concern, as the case law puts it, is so highly protected under this doctrine. So, given that idea, there is speech that might be deemed acceptable redress, but then there is speech that is unacceptable, that might be about a kind of protest that is outside of social norms that are agreed to. And this poses the problem that you all have been confronting in this moot court competition in these last 2 days. So let's talk about civil disobedience and the moral imperative. Now, I have several images here. To the left of your screen is a picture of Henry David Thoreau and his famous essay, Civil Disobedience, established in the 1840s, along with others of the Transcendentalist movement, a desire to motivate people to protest against laws that they found that were immoral and unjust. Thoreau, Emerson, and others, and as I understand it, you've already been briefed and you've had an opportunity to read Disobedience, so I don't want to do, a book report on things that you have already encountered. But I do want to talk about the idea that in the Transcendentalist movement, that there has this underpinning of the desirability that there is for ensuring that things that are immoral, that are against the law and the higher moral law, can be protested against. And I'm hearing a little bit of interference, so folks, if you have the opportunity to mute your mics, that would help me with the presentation, because I'm getting a little bit of echo. But back to the point at hand. The idea that Thoreau put out there was powerful, because to take it as he put it, or to take it as Martin Luther King, the next image that is beside his there, took it, the idea is that there might be moral standards out there that are far more important than what a particular law might speak to. And so if that law is immoral in that sense, then there is a right to disobey it as a means to protest the law and call for a higher reckoning or a fixing the situation so that there is a remedy and putting the law in line with moral callings, right? As a law professor, I don't get to often talk about moral calling, but I happen to be at Marquette, a Jesuit Catholic university. And this conversation about the moral dimension of law is something that often comes up in my teaching. And so in this sense, this idea was the foundation for social protest in the way that we have seen it from the late 1840s through to today, right? In the 1840s and 50s, the protest was about slavery. The protest was about the notion that it was immoral to hold people in bondage without freedom, without citizenship, without a sense of being where they could own themselves, right? Slavery was the immoral law. And the Transcendentalists, along with others in the various parts of the abolition movement of the 1840s and 50s, were grounding their thinking in this vision of moral protest. My colleague David Papke has written about this kind of moral protest as a thought of directly commenting on and thinking about the consequences of law itself. So I am not a minister, so I'm not qualified to talk about the moral calling of God, but the Transcendentalists and the work of civil disobedience and other works in the Transcendentalist literature are all about critiquing the law and making the law work the way that it should. And of course, this was part of the energy that led to the protests and rebellions and the back and forth that ultimately led to the Civil War. And then after the Civil War, the Reconstruction Amendments. So if we think about this tradition of protest as an engine for social change, it was the work of the Transcendentalists, among others, and the protest of illegal laws that led to the idea that slavery ought to and ultimately was abolished, and that we are all guaranteed equal protection of the law, and that we should be treated equally by the law and have an equal say in who gets chosen to make the law, i.e. the right to vote. So this is an important engine of change for our society. Now, I put beside these pictures a picture of the students who sat in during the 1960s. And this is Woolworth's, this is Greensboro, North Carolina in the 1960s. And the sit-in movement that was part of the engine of social protest that led to the civil rights revolution in the 1960s. And think about it from the broader perspective, right? The idea here is that even with the abolition of slavery and the guarantee under the Constitution in the 13th and 14th and 15th Amendments that we are all equal citizens and that we are all granted our rights, there was nonetheless, after that period, which we all call the first Reconstruction, that those rights were effectively taken away for people of color during the Jim Crow period through things like the Black Codes and segregation. These rights were on paper, but the structure of the enforcement of the law was such that they had no real meaning in practice, particularly in the South. but also in the North as well, because there's a long history of what I would call the bullying of racial minorities when it comes to the exercise of their rights to live equally, to cast their votes, to work and enjoy their lives. So across the country, we had a second period of racial subordination, the first being slavery, the second being Jim Crow. But it took that moral protest, including the sit-ins, the movements of Martin Luther King and all those who were allied with him, Fannie Lou Hamer and many, many others, John Lewis, who you know was an advocate for voting rights in particular. It took a movement of all these folks in order to protest this. And this was too civil disobedience. And indeed, King invoked Thoreau and other transcendentalists and Gandhi and other thinkers of civil disobedience to talk about having that conversation of the moral dimension of the law and the unwillingness to follow an immoral and an illegal law. All you need to do is read a letter from a Birmingham jail in order to see King thinking through and distinguishing moral laws from immoral laws as grounds for protesting and demanding that society change. And in fact, I have an excerpt of that here where, and just give me, but the point though is that this energy, this thinking is the thing that changes our society. So in King's words, in no sense do I advocate evading or defying the law as the rabid segregationists would do. That would lead to anarchy. One who breaks an unjust law must do it openly, lovingly, not hatefully as the white mothers did in New Orleans when they were seen on television screaming, well, the N-word, and with a willingness to accept the penalty. I submit that an individual who breaks a law that conscience tells him is unjust and willingly accepts the penalty by staying in jail to arouse the conscience of the community over its injustice is in reality expressing the very highest respect for the law. So that's the vision of civil disobedience and the moral imperative. As King put it, it is the highest respect for the law to protest immoral laws. And as I'm arguing here, this immorality being protest triggers our conscience and creates a path to change. Now, the Tinkers did the very same thing as students protesting the Vietnam War. As you can see, here is a picture of the Tinkers, brother and sister, who wore these black armbands with peace signs on them to school. And they wanted the war to stop. They did not disrupt the circumstances of their schooling. They simply wanted to have their protest. So the Supreme Court, and you all have read Tinker, so I don't need to spend too much time talking about it, but the principle here, of course, all these other examples that I've given you to this point, you know, the sit-ins were not during school hours. King and others are adults marching and talking about their protest. But when it comes to students, The Tinkers are the example of people who wanted to make their protest. And as the facts point out, the Tinkers wanted to wear these armbands. The administration of their school got wind of this and decided that it would be policy of the school that any student wearing an armband would be asked to remove it. And if they refused, they would be suspended until they returned to school without the armband. So when the Tinkers wore their armbands, they were asked to leave, and they did not return until their protest was followed through. They protested for about 2.5 weeks. Of course, their case went all the way to the Supreme Court. They were represented by the American Civil Liberties Union, and the U.S. Supreme Court reasoned that suspending the Tinkers for wearing their armbands violated their First Amendment rights because the armbands were a valid protest, and as students, they have the right to protest. They do not check their First Amendment rights at the door, so to speak. And because their protest caused only discussion and not disruption, a distinction that will become very important as we continue this conversation, there was not enough of a justification for the school to suspend the Tinkers. So the Tinkers' peaceful protest was protected by the First Amendment. So think about the elements of this, because as a law professor, I always have to point out a legal test works by demonstrating what are the standards that have to be met, and then as a lawyer, we argue that the standards are met as reflected in certain facts. And you all have had practice in this. And the little bit of argument that I got to hear right before this lecture shows me that you all already know how to reason well. But let's be clear about the standards here, right? The forbidden conduct of the protest must materially or substantially interfere with the school's ability to manage a school setting, right? So if the protest interferes with the educational mission of the school, then the school has the right to ban it. But on the other hand of the measure, if it does not substantially interfere, then the students have First Amendment rights. And as we see here, and I put this in the text in the side, right? It must be a significant and material disruption to the school or the students, or be reasonably foreseeable to cause such disruption or invade the rights of others. And the school must show, right, that the action was caused by actual fear of disruption, mere apprehension or discomfort regarding an unpopular viewpoint is not enough. Now, this is one of the things about the First Amendment, right? And this is why I said the First Amendment protects the marketplace of ideas. To sanction speech because you disagree with the speech is referred to as viewpoint discrimination. The government is, in essence, imposing its idea on the student by silencing certain points of view or by promoting certain points of view. When it comes to individual speech, the government is supposed to be neutral and be withdrawn in the sense of not taking a stand as to the rightness or wrongness of an individual's belief or perspective or idea as they state it. And Tinker articulates this principle as a matter of course. again, students do not check their First Amendment rights when they enter into the school setting. And indeed, the court says prohibition of student speech is the exception, not the rule. And the school can only prohibit speech in ways that are articulative of specific concerns about materially or substantially disrupting the ability for the school to operate safely and properly. So, what the court is saying, in my view, is that the default is students get free speech unless we can have an actual disruption or a reasonably foreseeable disruption at play in school. Now, of course, if we just stop there, that would be the end of the conversation, but the problem is in the details. So after Tinker was decided, the court adjudicated a number of other claims around free speech. And I would argue to you that these free speech claims by students protesting in their schools oftentimes limited what free speech was ought to mean, to the point of creating a kind of de facto deference to schools and their judgment as to what is and what is not disruptive, rather than what I've just suggested, which is assuming at the start that students have free speech rights, and then the school has to alternatively articulate a specific disruption, right? So rather than centering free speech rights, the post-Tinker Supreme Court precedent would suggest that the analysis seems to be shifting more towards what the school says is disruptive. And the danger here is that what is being said is disruptive is based on speculation by the school rather than those specifically articulable facts. So, our three examples here. First, Bethel School District number 403 versus Frazier, a decision from 1986. So, Frazier was a high school student and he was punished for lewd speech, nominating a classmate for a school-wide election. Now, the court is not clear about what lewd speech was at play, but Frazier was suspended for 3 days and penalized by not being a graduation speaker. His parents and he sued the school district, arguing a violation of his First Amendment rights. The court, in the voice of Chief Justice Berger, basically characterized Frazier's speech as, quote, inappropriate sexual innuendo, and Berger explained that such speech can be punished given the critical missions of the school to teach appropriate behavior to students. Or as the justice put it, the determination of what manner of speech in the classroom or school assembly is inappropriate properly rests with the school board. Berger distinguishes Frazier's case from Tinker by arguing that even though students don't leave their First Amendment rights at the door, the First Amendment at the same time is not automatically coextensive with the rights of adults in other settings. And so the judge here seems to be arguing to me that there are certain points where disciplining the speech is the educational mission, maybe, because determining proper speech is part of the teaching that schools do. So here is this movement to a kind of deference that subsumes the types of speech. Now, it's a hard balance because there is speech in the First Amendment context that might be lewd or crude or inappropriate, and that in and of itself can be struck down for societal grounds. But my point here is that one might disagree about what is offensive and what's not offensive. And Justice Brennan, in concurrence, does not call this lewd or offensive, but his point was that it was disruptive. But notice the idea that how we characterize the speech and determine what weight we give it. Now, the second example, Hazelwood School District versus Kohlmeyer. So in Kohlmeyer, 3 journalism students wrote articles for their school newspaper, writing stories about the pregnancies that had taken place in the school district. And again, this is the late 80s, 1988. And they also wrote about the impact of divorce happening in families and how that impacts students at the school. The teacher supervising the school newspaper approved these articles, but the principal cut the articles. The Supreme Court upheld the principal's decision. Justice White, in this case, deferred to the school's decision to determine what manner of speech is appropriate for a newspaper published as part of the school curriculum. And he reasoned that schools were entitled to regulate the content in any reasonable manner. And he argued that what distinguished this from Tinker was, quote, Tinker addressed educators' ability to silence a student's personal expression that happened to occur on the school premises. But in Kohlmeyer, the justice writes that it dealt with, quote, educators' authority over school-sponsored publications, theatrical productions, and other expressive activities. So once again, by locating this, in this instance, as part of curricular judgment, what was implicit in Frazier is made explicit in Kohlmeyer, that because it's part of the curriculum, educators get deference. And then there's Morse versus Frederick. It held that schools can suppress student speech at a school-sponsored or school-sanctioned event that advocates or promotes the use of illegal drugs. And so the idea was that during a school assembly, some students rolled out a 14-foot banner that said, "Bong hits for Jesus." And this was broadly displayed in the assembly. And by the way, this is from 2007. And so the school officials confiscated the banner and suspended the students for 10 days. And so in this opinion, now Chief Justice John Roberts, writing for the court, says 3 points. First, that the student's speech was at a school-sponsored event. Viewing the torch was, quote, sanctioned by the principal as an approved social event. So the event was sponsored by the school. Second, the banner promotes illegal drug use. And so even though the message bong hits for Jesus could be interpreted in different ways, Chief Justice Roberts agreed that the banner endorsed drug use and thus created a problem. And the third point here is that because it advocated drug use, which was in and of itself against school policy, it was not protected student speech. And so the other positions on the court are notable for concurring with this idea, and in particular, the extreme position of Justice Thomas that advocated that Tinker in and of itself should be overruled. And so that there be wholesale deference to school officials and their judgments on how to police student speech. So, even though these examples happen at the fringe, notice that the court over these three cases is suggesting, to the extent that any speech could be located as disruptive or as part of the school's mission, it can be seen as within the sphere of school officials to control the speech and thus sanction students for exercising speech that it found as forbidden. But this, to me, raises several questions. And these three questions: who decides what is disruptive conduct? Who decides when it's disruptive? All feed into this question of deference to school officials' judgment around the speech. So, who decides? The school officials. And their discomfort can plug into what is illegal, as we've seen from these cases, or what is socially dicey. Now, one could argue that this fits into the definitions laid out in Tinker itself. Is it reasonably foreseeable to be disruptive? Or is it simply uncomfortable speech about sensitive topics that might foster important conversations, but nonetheless should be protected under the Tinker principle? This line seems to be blurry in light of the following precedent. And what counts as disruption seems to be another key question. Exposing a banner and having a reaction that is public may or may not be disruptive depending on the circumstances. In fact, in your own fact pattern, having a t-shirt being worn during a Zoom meeting could be disruptive if there is a material manifestation of that, or not if, like in Tinker itself, the students just sat and wore the article of clothing and simply silently expressed their speech, right? This line to me seems slippery and subjective. In other words, if it's all about what the school district or what the principal might decide is disruptive, that judgment then presumes the disruption rather than articulating the specific facts that demonstrate the disruption that Tinker itself says should be the case here. So, this raises the third question in my little bullet point here. Is this really about deferring to social order and wanting to silence disruption and protest? Or is this about having an adequate space for students to have speech and only restricting that speech when necessary? That latter idea is what Tinker calls for, but I think there is a danger, given the precedent, that deference to whatever the school district defines as social order becomes more and more like the norm. And of course, and I am not just getting this criticism about this for myself. I would point to other scholars, including scholars in the critical race theory oeuvre like Derek Bell, who would point to this kind of restriction of rights as a tool to suppress civil rights advocacy and to suppress arguing about racial injustice. But we don't need to look back at the 60s to think about that. We can look at the modern era. Now, here's another example for which I don't have a court opinion, but I do have news stories about. So here is a picture of Mariah Havard, who at the time in 2016 was 16 years old. And here's a picture of her and friends. They all wore these Black Lives Matter t-shirts to their public school on picture day. And yet, before she could take her school picture, a security guard escorted her to the administrative office where the vice principal demanded that she change out of the Black Lives Matter t-shirt into a plain white t-shirt. She didn't object, but another friend of hers wore a Black Lives Matter shirt the next day, but was also told that she had to change. The NAACP, the ACLU, and other civil rights groups sued, and the answer of the school board was that the school was trying to remain politically neutral while still allowing student expression. But the school board also argued that wearing these sorts of shirts was inherently disruptive. And as a threat to the learning process, the wearing of the shirts had to be addressed. So if that's the justification, this seems to be wholly out of line with Tinker's admonition that explicitly peaceful political speech, like the wearing of a t-shirt, like the wearing of an armband, ought to be protected. The school here tries to pay lip service to Tinker, but its actions seem out of line with Tinker. There's no discussion of what it is exactly about the wearing of these shirts that would be disruptive. And so this story strikes me as problematic. And this story was simply 5 years ago in 2016. Even last year in Oklahoma, Ben Herbert, an 8-year-old African-American student, was banned by his elementary school principal from the cafeteria and from recess for wearing Black Lives Matter t-shirts. After being forced to sit in the office for 6 hours facing the wall, the principal told Mr. Herbert and the other boys that they had to wear the shirts inside out in order to rejoin their class. Herbert's mom followed up with the school superintendent, but she was told that, quote, students cannot get in trouble for wearing Black Lives Matter t-shirts. And at a different school, Herbert's older brother did not get into trouble for wearing a similar t-shirt. So this issue, and I realize your fact pattern is similar, but if we situate it within the history, and if we think about it through the lens of what Tinker is supposed to accomplish, what I would argue here is that in the Black Lives Matter era, we have this concern once again of subjective judgments being deferred to with little investigation, with little articulation of what it is precisely that is disruptive, that is being targeted at matters around which people of color seek to protest. So it's a particular tinker problem, a problem of, is this masquerading as racial discrimination because of the advocacy by people of color for matters that represent their concerns. So, in other words, the vagueness of these complaints might be more about the reactions of the teachers and their beliefs, as opposed to a reaction based on a reasonably foreseeable act of disruption. That, in the context of court precedent that would tend to defer to teacher judgments around these issues, would suggest that despite the existence of tinker, scholars like Bell and Erwin Chemerinsky and others would say, how much of tinker is really left? How much protection of student speech is there really in American society under these precedents? Now, let me wrap up by saying a word about what the consequences are for this. And I only have about 5 minutes, so I can't really touch all of these topics. But we can see how, from your fact pattern, protest in the COVID era, where we have to rely on this type of interaction until the pandemic passes, raises questions of what is it that we can and cannot do, and what does it mean to be disruptive in the internet era? I'm sitting in my office right now. I'm going to turn my camera a bit. I have a picture. I have a little model of Darth Vader and the USS Enterprise. I'm a little bit of a Star Trek nerd. But what if a Darth Vader helmet sitting in the corner is disruptive? What if, under this sort of subjectivity, we have this problem of claims of disruption that seem more related to what it is that we might fear is disruptive, as opposed to what actually is reasonably foreseeably disruptive. And it's not just sitting in class, right? With the emergence of Instagram and TikTok and its ubiquitousness across, platforms, especially for folks who are, a fourth of my age. Yet the ability to choose this speech and to play it in the school might well be free expression, but would it be subject to these analyses? This strikes me as also a challenge in this kind of post-Tinker era. And I think, too, there's been a lot of debate about what I'm calling here respectability politics. And sort of like, the idea is that one can protest, but one shouldn't be disruptive, or one shouldn't take on certain aspects, even if one is being peaceful. One shouldn't wear a t-shirt wearing Black Lives Matter, or one shouldn't share certain web pages or what have you. I mean, that kind of choice might be what's going on. The court saying, well, instruction about how to talk in public is part of what we ought to do. Well, that could be read as there are some topics that are respectable to talk about and some topics that are not. But these same criticisms were levied against those civil rights protesters, against Martin Luther King. He was in the Birmingham jail precisely because people in Birmingham, Alabama did not find his commentary respectable. Of course, King says, well, if you're breaking a law, you have to suffer the consequences. But my concern is about the students wearing Black Lives Matter t-shirts who are breaking no law, but get treated as breaking the law because of the subjective views of some. The point of protest is to get you to think about your world, to get you to think about your circumstance. Protest also makes you invested in the community, to get others to help you to advocate for your point of view, think about your circumstances together, and to change them for the better. If we shrink the scope of lawful protest, as I am afraid we are doing in the diminishment of Tinker, then we dissuade that involvement. And that involvement of going out and caring about what your fellow citizens do and participating with them to make our society better by voting, by asking the government to redress our grievances, by finding a better way. This kind of doctrine can discourage that. And if we discourage that as a product of our education, even though we say we're trying to educate, then what kind of society are we really living in? What kind of democracy are we really participating in when we overly disrespect student speech? Now, this should not be taken as me being a fan of something illegal or immoral, but within the realm that Tinker itself draws, that space for speech is as important to all of you as students as it is to me or anyone else who is part of our society. It is our voice, and our voice needs to be protected. I want to thank you for your time and your attention, and I wish you all well in the rest of your competition.
Do you have to end your share screen, Professor Ellis?
Yes, I am happy. I'm going to put my info up for about 10 more seconds if people want it, and then I will end my share.
All right. Judge Roth, are you around? We'll get you good.
Yes.
Yeah?
Yes.
All
I'm
right.
here.
Okay. Do you want me to share the Judge Hasty handout, or do you want to have your face showing while you speak?
I never really thought about it.
I mean, I've emailed it to everyone, so I think it would be better more engaging to just have you speak for your 5 to 10 minutes.
Okay, great. Wait, I've got my notes on the other side of the table.
All right, I'll do a bit of an introduction then. We've, in addition to wanting to expose the students to the Third Circuit in general, we specifically asked Judge Roth because her appointment to the Third Circuit came shortly after William H. Hasty had left the Third Circuit. Judge Hasty was the only judge from the Virgin Islands to ever be appointed to any federal circuit court or appellate court. And we wanted to expose the students to this, to let you know that there are these possibilities. And I asked Judge Roth to give us her thoughts on Judge Hasty, his impact on the jurisprudence in the Third Circuit, and just him in general, because she was so close in time and a lot of her contemporaries were friends with him and knew him very well. So with that, Judge Roth, it's your show.
Okay, thank you. As you said, I did not personally know Judge Hasty, but certainly I have known of him and known him as a beacon that the judges on the Third Circuit follow. We have some stellar judges, and he is one of them. And I think the thing to start out that we can say, the best thing, the most striking thing to me reading about him was his perseverance. The fact that he had goals in mind and he didn't always reach them immediately. He stuck around. He looked at how things could be accomplished, and if he found that he was in a dead end, he moved. He was working with the government during World War II to integrate the military services, and he found that the people who were supposed to listen to him and communicate with him were not doing that, and rather than stay in a position that was a dead end, he pulled out. He went to Howard Law School as the dean, and he used his energies to accomplish other goals. So I think he is a wonderful example of someone who accomplished a lot, but someone who met a great deal of difficulty in his life in meeting what were goals that were excellent goals, but for reasons were being frustrated. And rather than sitting and staring and saying it's not fair, he took himself and all his talents to another area where he could continue to forge forward in his career in the law and in the opening of the law to black lawyers and black judges. You have I think the basic information on Judge Hasty. He was born in 1904 in Knoxville, Tennessee. He moved to Washington, D.C. as a boy and considered D.C. his home until he went to the Virgin Islands in 1937 to the district court there. He graduated from Amherst College in 1925 as class valedictorian, and yet he suffered a great deal of obstacles as a black student there, that he didn't have access to all the facilities or to all the opportunities, but he nevertheless stayed there, was valedictorian of his class, got from Amherst what he needed to move on. He began in first earning money to go to law school, then went to Harvard Law School, where he joined the Law Review, had a stellar record there at Harvard Law School, and following law school, he joined the faculty at Howard Law School. He began in the 1930s to participate in the NAACP's fight for racial justice. He was lead attorney in the NAACP Equal Pay for Black Teachers in North Carolina. In 1937 to 1939, he was the first black judge in the district in the Virgin Islands, and he did that through his contacts in Washington, D.C., and the impression, the reputation he had for legal knowledge and for the ability to step into difficult situations and not let the difficulties upset him in reaching his goals. He left the Virgin Islands in 1939 because he was asked to return to Howard Law School as dean, and he stayed there during World War II. He also worked to promote integration of the military. As I mentioned, he found that very frustrating at times, and in 1942, he went back to Howard and devoted his efforts there. In the course of this, he'd gotten to know Harry Truman, and they became firm friends. And so it was Harry Truman then who suggested to Hasty that he become governor of the territory of the Virgin Islands. And in 1946, he went back to the Virgin Islands in that capacity. Then in 1949, Truman nominated Judge Hasty to the Third Circuit Court of Appeals, where, as I have said, he left a really strong impression of an intellectual judge, but a judge who understood where he was going and why he was going there. He was the first black federal court of appeals judge, and he served on the Third Circuit until his death in 1976. He was also chief judge of the Third Circuit from 1968 to 1971. That's a position that at a certain age it terminates, and so he left the position of chief judge, but he stayed on the court as a judge. So you see that this is what people would consider to be a very, very stellar professional life. It was not a meteoric rise, so it was a rise that was accomplished through a long trail of hard work, promoting racial equality with the NAACP, with the Department of the Interior, with the United States military, during World War II, with teaching at law schools, and with his familiarity with the executive branch of government as well as with the judicial branch. He was admired for his perseverance, not only by black men and women, but also by white men and women. And I think it is very interesting to consider some of the things that were said about him. Earl Warren, the Chief Justice of the United States, said that William Hasty was one of the ablest judges ever to sit on our courts. Now that is an accolade that many of us would like to hear and few of us get to hear. And as a Third Circuit judge, I am proud to have one of my colleagues have that praise given by the Chief Justice of the United States. Robert Nix, who was the Chief Justice of the Pennsylvania Supreme Court, commented, "Bill Hasty never lost his faith in America. He did not resort to bitterness. He rejected the arguments of those who preached separatism. He recognized that America would inevitably be required to embrace all of her children, and he dedicated his life to the acceleration of that realization. He was a teacher, but he taught more than the subject matter of the courses. He taught his black brother, both by work and deed, that the dignity of man was not dependent upon the color of skin, but rather upon the worth of the individual. As a lawyer, he was one of the prime architects in the civil rights movement, which resulted in landmark decisions which have become significant markers on the road to freedom. As a judge, he appreciated the need for conformity, but never lost sight of the uniqueness of the individual. He proved to many that faith and commitment are still more effective than hate. He was a firm believer that the failure of America to provide equality for all of its citizens would not simply be a loss sustained by the deprived groups, but even more important, it would be the demise of America, of an impossible dream. In other words, a loss for all Americans. Bill Hasty maintained his faith in that dream until his death. Whether or not it will become a reality, not just for blacks, but all deprived groups in America, will depend upon whether we too are willing to be as committed and devoted to this goal as was Bill Hasty. There are many, many more things I could write about him, read about him. As I say, He is an admired judge among all legal scholars, particularly in the Third Circuit area. But let me read something that he wrote just a week before he died. He said, "Yes, our political legacy includes intractable problems, yet we continue to believe that the genius of the founders of our nation lay in the devising of political institutions that would both command respect and loyalty because of their decency and exhibit flexibility enough for effective adaptation to the needs of other and different times. For that, we cannot give them too much credit. Yet our belief in the excellence of their work is also the measure of our responsibility to make those institutions serve the people well in our times." I think if our students today can think about what he has said and the perseverance that he had to show in his life, it will give them some inspiration as if they choose to go into the law, study the law, and it can be a long, hard slog, but just remember from the Virgin Islands that you have Bill Hasty down there as an example for you, and let him inspire you to perfect that legal ability that all of you showed in your arguments today. Thank you.
Thank you so much. I always enjoy when, however unplanned and unintentional, all of the speakers create a beautiful arc to the program. We started with Attorney Udwani talking about never let someone tell you what you can't do. We had Judge Ross share her experience. We talked about Sandra Day O'Connor. We talked about the challenges with Professor Ellis that all of the people who seek change face and what they have to face with it. And then you hear, the parallels of Justice O'Connor, Hasty left the military because he wasn't accomplishing what he wanted, and he wanted to achieve it. I just, absolutely a remarkable run of speakers today. With that, I would ask Judge Mead if he has any commentary to share today.
Concerning the students' performance?
Of course, yes.
Well, to be quite candid with you, I was impressed with each and every one of the students. They seem to be real lawyers. They were on point. They respond to the questions appropriately, and the question did not deter them because after they answered the question, they went right back into their arguments. And I was just sharing with another judge in the Superior Court on St. Croix that, wow, the legal future in the Virgin Islands looks great. Because if these students that argue today were to go to law school and come back to the Virgin Islands and practice, it would be so, so fantastic. I don't really want to single out any particular student, but I was just satisfied with the arguments of all of the students, and I think all of them are winners. They will go far.
Agreed, and I'm looking forward to the same day. I cannot wait for the day I'm standing at a swearing-in ceremony and I see my former Moot Court students becoming lawyers in the Virgin Islands. Chief Justice Watlington, do you have anything you'd like to add today?
Wow. It has really been a spectacular day in more ways than one, and historic. I mean, Judge Ross informed us earlier of the historic confirmation of the first Black Supreme Court Justice, Ketanji Brown Jackson. And it's so fitting that it occurred today on the very day that we are doing the 28th annual Moot Court competition, because these students should remember this day, and she should be an inspiration for all of them. I am so proud of the way they handled themselves today. They answered tough questions. They stayed focused. They stayed poised. And they showed their competence, their eloquence, and graciousness. And I do also concur that they are all winners, and I really, really wish, if I had any doubts earlier when we said at the beginning that they're all winners, I have absolutely none at the end. It was a very hard task today to rate these students. They were just all so outstanding, and I am just so inspired and remotivated. And my belief in the young people of this community have been reignited, and the future, whether these students pursue a career in law or any other career, because I believe this experience prepares them for so much more than just a career in law. But of course, I'm looking forward to more lawyers coming before the court. We need good lawyers to come before, and many of these students were as good as any of the lawyers that come before us today, or better in some instances. So I just really want them to be confident, continue the confidence that they showed today, and continue to do well and have much, much success, because you are successful.
Thank you so much. Yes. And Judge Roth, do you have anything that you want to give for feedback to the students?
You know, I like to give good marks, but it's even better when you give good marks and they're justified. I gave a lot of good marks today, and I felt they were all justified. So I'm very happy with being able to participate in hearing these arguments.
Oh, thank you so much. And before I switch to my co-chair to announce the scores, I would just ask the judges to please share your experiences with your colleagues. I would even ask you to identify people you think would volunteer next year, but I'm not sure anyone wants to sign their friend up for more work publicly on a nationally live stream program.
I'm going to tell you, this was hard work. This was hard work.
Well, we have a new judge coming on to the Third Circuit, an African American, so maybe we better work on her.
Yes, please. We would love to have one of the fresh faces from the Third Circuit. I'll reach out and hopefully you can help.
I would be delighted to. Yeah.
Thank you so much. Thank you to Professor Ellis. Did you, Judge Roth, did you know Professor Ellis when he clerked for Judge McKee?
You know, I didn't. I was in Wilmington and Judge McKee's in Philadelphia. So you see the clerks in the courtroom, but they aren't in the same courthouse. So unfortunately, I did not get to know him.
Oh, okay. And with that, I will turn it over to my co-chair for the St. Croix District, Rob Kaczynski. We have tabulated the scores, and I guess I should do a real quick run over. Best oralist receives $1,250. First runner-up receives $925. Second runner-up receives $750. Third runner-up $250. Fourth and fifth runners-up $100.
All right. So before I go into the scores, which I'm sure everybody's anxious to, and I don't want to belabor or delay this any further than necessary, I just want to encourage everybody that is not a senior to do this next year, because I was looking at the scores and the results from last year, and it's incredible the amount of students that are performed well last year actually did better this year, and a lot of the winners and people that succeeded are repeat competitors, and I can only assume that having done it in the past helped them do well this year. So to everybody, even if you're an alternate or a freshman, good luck next year. Hopefully, you enjoyed it again, or you enjoyed it this year, and next year will be fun. So without further ado, though, I'll first announce the oralists. The fifth runner-up, Una Alexander from St. Croix Central High School. And I'll also just say, it's disappointing that we can't do this in person, because it'd be nice to give people applause. That was a good thing about having it in the courtroom, is, we could do actual hands clapping and everything, but, hopefully next year. Fourth runner-up, Alani Arnold of St. Croix Educational Complex High School. Third runner-up, Bernice Burley of St. Croix Central High School. Second runner-up, Tatwani of Antilles School. First runner-up is Aisha Kamani of Antilles School. And the best oralist is Nancy Parisia of St. Croix Educational Complex High School.
Wow, congratulations to all of you. For the team placements, as a reminder, first place is $1,500, second place $1,050, third place $900, and fourth place $675. And Rob, if you want to announce those.
Yep. Fourth place for the school Antilles Appellants with the team of Ronit Chitwani and Ratisha Wani. In third place is St. Croix Central High School Appellees of Bernice Burley, Leah Cornelius, and Angelina Springer. In second place is Antilles Appellees with Kashish Shanani and Aisha Kamani. And in first place, St. Croix Educational Complex High School, the team of Alani Arnold, Nancy Parisia, and Isabella Cruz.
Wow, congratulations, everyone. Rob, is there anything we are forgetting?
I do not think so.
I don't either. With that, I'm sure you're all tired of hearing me talk after all these days. I just want to say I hope that Rob and I have earned the privilege of your time yet again this year. That is our greatest aspiration every year, is that in doing this, you are grateful that you had the opportunity and that you do feel like it was worth your time.
And absolutely, it was a good experience. I'm glad I had the chance to do it. It really enheartens me to see young people who do so well in a program like this.
Thank you so much. I agree. It was unbelievable to do that. And with that, everyone's entitled to leave. I'll stay on if there are any follow-up questions or anything like that, but the program is over. Congratulations and thank you.
The trophies are coming to St. Croix. I can reach out to the coaches.
Yeah.
Right.
Yeah. We'll be giving out all the trophies over the course of the next week or so. We'll divide them up and get them sent over and that whole process. For everyone else, this is the end of the program. For Rob and I, we have 2 more weeks of work until our season is over.
Okay, is the education complex still online?
I don't see them.
Okay.
One of our coaches is online, and the rest of the students are watching the stream.
Okay, because I wanted to ask one of the students a question.
Let me see. I think we should be able to get her back onto the stream. Onto the call. They can both see the stream at the moment. But let me see.
Miss Nancy Parisia.
Okay, no problem. Let me get her on.
She was a repeat competitor.
Okay.
Last year, she was the second runner-up by my record.
Nancy Parisia?
Wow. She was second runner-up last year, yeah.
Okay.
Wow, so it does pay off to participate a second time.
Yeah, she was the second runner-up, and I think and the school was the second place for the territory.
Okay. Ms. Ford, maybe you can answer the question.
Hi.
Do you know if she's related to Nancy Parisia, who worked for the public defender's office?
Well, that I cannot tell you. Okay. I am not sure.
Okay, very well. Because Nancy Parisia was my secretary when in my other life, in private practice, when I did civil defense work, similar to Rob.
Okay. I'm not sure. I will ask. I do know she's incredibly busy, so she might actually still be on campus right now. So I'm not sure if she can get to the call.
Okay.
But yes, thank you all so very much for everything. It's been a wonderful experience.
Okay, and congratulations.
Thank you very much.
I thank the coaches for all the work that they do. I know this is hard work.
Yes. It was difficult work, yeah.
So thank you all. I'm going to leave now.
I enjoyed being with you, and I hope to see you all again soon.
Yes.
I see Nancy.
I'll email you.
Hi, Nancy.